Good morning, distinguished guests, and welcome back to Day 2 of the Global Lawyers Summit organized by the South Asia Committee of the American Bar Association right here in the heart of New Delhi. After a day filled with enlightening discussions and invaluable insights yesterday, we are set to continue our journey through the realms of law, governance, and philanthropy. In fact, today promises to be a lineup of sessions that will not only challenge our perspectives, but also inspire us to work towards a more cohesive global legal community. Let us make the most of this opportunity to connect, learn, and share. And do remember, we encourage you to engage with us and your peers using the hashtag ABA India Conference 2024. Let us embark on another day of groundbreaking dialogues. Well, kicking off our morning, we delve into the role of the judiciary and the rule of law in advancing economic development. This session will illuminate the judiciary's pivotal role in shaping a conducive environment for economic growth and development. To moderate this session, we already have on stage the moderator and the panelists. So to moderate this session, we have Professor Dr. C. Rajkumar, Founding Vice Chancellor, O.P. Jindal Global University. And sir, would you like to introduce the panelists, or should I do that?
I can do that.
Yeah, okay, great, sure.
All right, very, very good morning to all of you. I would like to take this opportunity to thank the ABA India Committee, as well as its chair, Ms. Pratibha Jain, who has kindly invited all of us to be part of this very unique panel. I know that the ABA India conference has been happening since yesterday, and we've had a variety of sessions focusing on a range of issues of the theme of this conference. This particular panel is going to focus on the role of judiciary and the rule of law in advancing economic development. I have with us a very, very distinguished set of jurists. Let me begin by introducing Honorable Ms. Justice Hema Kohli, Judge of the Supreme Court of India on my left. Justice Kohli has been at the vanguard of advancing human rights and fundamental freedoms, both in the court and outside as well. She's had a very long and distinguished career, and we are deeply grateful to her for accepting our invitation to be here. We have with us Honorable Mr. Justice Sanjay Karol, Judge of the Supreme Court of India, another distinguished judge who has also worked on both public and private law issues, and he had, like other judges, other engagements this weekend. But thank you very much, sir, for accepting our invitation to be here. We have with us Honorable Mr. Justice Rajesh Bindal, Judge of the Supreme Court of India, another distinguished judge who's had a very interesting career, both in terms of advancing in both commercial law as well as public law areas. He also had a very important engagement outside Delhi. But thank you very much, sir, for accepting our invitation and being here. I also want to extend a warm welcome to Honorable Mr. Justice Hemant Gupta, former Judge, Supreme Court of India, currently serving as chairperson of the New Delhi International Arbitration Center. As you can see, after demitting office at the Supreme Court, he has now taken a very important role, which has a direct connection to the advancement of economic decisions, especially in the context of dispute resolution. So thank you so much, sir. And we have with us Honorable Mr. Justice Swatantra Kumar, former Judge, Supreme Court of India, former chairperson of the National Green Tribunal. Again, for those of you who are present here, I'm sure you are aware that under his leadership, the National Green Tribunal made extraordinary interventions on some of the most important issues relating to environment and sustainability. Thank you very much, sir, for being here. What I thought we will do is, I'm going to request each of our distinguished judges to say a few words on the broader theme of this panel. But just to give you a context to the panel, I think it's only fair to say that around the world, and of course in India too, Indian judiciary has been among the most respected institutions, not only because of its extraordinary role in shaping India's democracy for over 75 years, but also focusing on issues relating to rule of law and access to justice. It is also the case that because of the independence of judiciary, it has also been an institution which has spoken truth to power, and in that process made other institutions accountable to the Constitution itself. in that larger context, much of the focus relating to judiciary and judicial institutions has laid emphasis on the role of judiciary in advancing human rights, civil liberties, as well as rule of law. But lesser attention has been paid in recognizing that the judiciary plays a very significant role in advancing economic development. Although the judiciary's role, both in terms of its jurisprudence and the court's decisions on a number of cases, has indeed advanced that, we don't talk enough about it. This panel will focus a lot on that. So with those words, I would like to request Honorable Ms. Justice Hema Kohli to kick off this morning's proceedings with her introductory remarks.
Very good morning to all of you. I'm delighted to be part of this distinguished panel alongside my colleagues, Justice Sanjay Karol, Justice Bindal, and my former colleagues, Justice Pratantra and Justice Hemant Gupta, and of course, the distinguished moderator, Professor C. Rajkumar. Attending this conference organized by the American Bar Association is indeed an honor and a privilege. The setting, this iconic Hotel Taj Mahal, which is situated in the heart of Delhi, is the perfect backdrop for our discussion on a theme of critical importance: the role of the judiciary and the rule of law in advancing economic development. Addressing the session's theme, to my mind, necessitates a deep dive into how legal frameworks and judicial actions underpin the economic stability, growth, and innovation of the country. The relationship between India and the US is a beacon of democratic values and mutual respects for the rule of law. Both nations, with their robust judicial system, sure, better. Both nations, with their robust judicial systems, play a pivotal role in upholding justice within their borders and driving economic growth and innovation. The collaboration between these two great democracies, especially in the judicial domain, can catalyze economic development, providing a stable and predictable environment for businesses and investors. The interplay between the judiciary and the economic development is grounded in the principles of legal certainty, property rights protection, contract enforcement, and safeguarding economic rights. These elements form the bulwark on which the market economies operate and provide the predictability and the stability that businesses and investors require and look for. The judiciary's role is in upholding and reinforcing these principles directly impact the investment decisions, market confidence, and the overall economic health of the nation. The judiciary's awareness and integration of considerations such as protection of rights of an individual, economic development, and sustainable growth within the framework of rule of law is both nuanced and significant. Through its interpretations and rulings over the year, the judiciary has demonstrated a keen understanding of the delicate balance between protecting civil liberties and fostering economic progress. In striking this balance, courts have often navigated complex scenarios where economic policies and individual rights have intersected. For instance, the US judiciary's approach to dispute resolution frequently considers not only the legal merits of a case, but also the broader economic implications. This includes assessing the impact of a decision on the investment climate of that country, the market stability, and the overall economic well-being of the state and its people. In the Indian context, the judiciary has shown an increasing inclination towards endorsing sustainable growth models. This is evident from recent rulings that emphasize environment protection, corporate social responsibility, and ethical business practices as integral to economic development. By upholding laws and principles that promote sustainability, the Indian judiciary reinforces the position that long-term economic prosperity cannot be separated from environmental stewardship and social welfare. Further, in recent years, India has made significant strides in establishing itself as a reliable partner in arbitration and mediation services. India's transformation into a commercial arbitration hub, driven by the judiciary's unwavering commitment to fast-tracking matters under the Arbitration and Conciliation Act and fostering a pro-enforcement regime, is undeniable. The Indian Supreme Court, particularly by limiting judicial intervention and respecting arbitral awards, as also party autonomy, has bolstered India's reputation as a favorable venue for dispute resolution. This judicial philosophy complements legislative reforms and signifies India's ambition to become a global hub for arbitration. The approach of the Indian judiciary is therefore of comprehensive consideration. It acknowledges that true economic development is not about immediate gains, but involves a sustainable approach that benefits the society at large. This approach reflects a judicial consciousness that acknowledges the fact that economic well-being and individual rights are not mutually exclusive, but are in fact complementary forces, which, when balanced correctly, promote a more just, a more equitable, inclusive, and prosperous society. Touching upon the protection of property rights, the judiciary's role in protecting property rights is the cornerstone of the nation's economic development. Securing property rights are essential for fostering investment, for fostering innovation and economic participation. Technical aspects of this role includes enforcement of laws against unlawful expropriation, provisions of legal remedies for property disputes, and maintenance of a robust and a land registration system. These judicial actions ensure property rights are clear, that they are enforceable and protected. It encourages individuals and businesses to invest in and develop property assets. Now, property rights don't include just the immovable properties. We all know about IPR and the rights under IPR that foster innovation and attract investment. By collaborating on protection and enforcement of IP rights, India and the US can create a more conducive environment for innovation-driven economic development. This involves aligning policies and enforcement mechanisms and engaging in joint initiatives to combat counterfeiting and piracy, ensuring that innovators and creators are adequately rewarded for their contributions. Coming to contractual law. Contractual law is fundamental to the functioning of modern economies. It provides the legal framework for commercial transactions. The judiciary's technical role in interpreting and enforcing contracts involves application of principles that ensure that contracts are honored and breaches are remedied in ways that can maintain contractual integrity. This includes enforcement of claims of specific performance, damages, and rescissions. By upholding contractual laws, the judiciary facilitates trust among economic actors, ensures that commercial agreements are honored, and disputes are resolved in a timely manner, thus upholding the rule of law. By sharing best practices in contract enforcement and exploring the adoption of uniform commercial codes, India and US can reduce the cost and complexity of commercial transactions. This simplifies cross-border trade and enhances investor confidence, as industries and businesses have the confidence of a consistent legal framework for enforcing contracts. So, friends, in conclusion, the partnership between India and US, particularly through judicial collaboration and mutual respect for the rule of law, offers a tremendous opportunity to enhance economic development. By focusing on areas such as providing certainty in law, quick resolution of disputes, protection of property rights, enforcement of contractual obligations, and digital transformation, both the countries can create a more favorable environment for economic growth and innovation. From India's perspective, learning from the US experience and fostering closer judicial and legal cooperation will not only benefit the economic ties, but will also strengthen the very foundation of our democratic and legal system. Thank you for the opportunity to explore this critical aspect of our judicial system's role in economic development, and I look forward to engaging in discussions and insights during this session. Thank you.
Thank you very much, ma'am, for setting the stage for the rest of the conversations and discussions we have. We have with us now, may I invite Honorable Mr. Justice Sanjay Karol to share some of his views. You can feel free to sit here or go there, please.
On the dais, my esteemed colleague, Ms. Justice Hima Kohli, Mr. Justice Rajesh Bindal, Mr. Justice Hemant Gupta, and Mr. Justice Swatantra Kumar, and the hero of the event, Professor Raj Kumar. Of course, I would not miss out on his wife, his spouse, Mrs. Jain. Thank you for inviting me to be part of this Global Lawyers Summit. We have with us people who have come from all the corners of the world. But above all, I must acknowledge the future of this world, this great nation and the world, the students of the Jindal Global School. Media, ladies and gentlemen, it is indeed a pleasure to return to this conference for the second year running. Last year, I had the privilege of attending panels, and I must say it sparked insight and purposeful discussions on pertinent topics. Hearing the views of our counterparts from across the American continent gave a fresh perspective to problems faced by the legal world as a collective. Rule of law is not an abstract concept. It is something which is enshrined in the very core of our Constitution. Protection and promotion of core human rights has been the focus of both the preamble as well as Part 3 of the Indian Constitution. Our constitutional forefathers had foreseen the role of judiciary in securing the rights of all kinds, including economic, of the people of India. And I must also say, the world. This has been brought out in the preamble of the Constitution, which says that the people of India have been resolved to secure to all citizens its social and economic justice. In this perspective, when we talk of rule of law, I must say that we are all lawyers. We have been lawyers, we are judges, but we are family. That judicial independence is absolutely crucial and a must for any democracy to function effectively. A robust and independent court with integrity is one of the reasons for it to be known as the third pillar of Indian democracy. Every judge, be it Dr. Chandrachud, the Honorable Chief Justice of India, or a munsif serving at the lowest rung of the ladder, and the members of the bar equally and jointly stand tall while serving as a sentinel for life, while whose nurturing and promotional constitutional morals and ethics. The rule of law is undoubtedly the golden thread of world order. It is that essential piece of equipment, if you will, that facilitates both functioning of various factors, aspects and components that make up a global village. This thread binds the Indian Constitution as also the nation and the world. The rule of law is intrinsically linked with economic development. In any thriving economy, the rule of law serves as the bedrock upon which all the other structures are built. It ensures predictability, stability, and fairness, creating an environment conducive to economic growth and investment. Nowhere in this is this more evident than in India, a nation with a rich tapestry of legal traditions and rapidly expanding economy. Since the last conference, over the past year, India's GDP has been one of the fastest growing amongst G20 countries and is forecasted to increase 6.8% in 2024. Economic development plays a vital role in furthering the constitutional goals of India as enshrined in various provisions of the Constitution by uplifting the socio-economic status of the populace, ensuring equal opportunities and fostering inclusive growth. Professor Rajkumar, if you would recollect, last year, same panel, I had said that India, unfortunately, as I have seen, having served the state of Tripura, Himachal and Bihar, that there's a virtual divide between the haves and the have-nots, between the metros and the rural areas. Fortunately, I see this gap now, instead of widening, being shortened. India's emergence as a global economic focal point underscores the significance of economic development in the contemporary global landscape. With its vast market potential, demographic dividend, and ongoing economic reforms, India has become an attractive destination for global investment and trade. As India assumes a more prominent role in global economy, the judiciary's role in safeguarding economic interests and ensuring a conducive business environment becomes virtually vital. Not only is India's economy emerging as a global leader, India's judiciary is becoming a leader through its forward approach and quick adaptation to new innovations and ideas. While on the one hand, Professor Rajkumar has been keeping all of you busy all throughout the year, various conferences, various dignitaries, and the Indian government has been holding G20 summit. Let me also share this with you, gentlemen, that, ladies and gentlemen, that our very dynamic Chief Justice of India, Dr. Chandrachud, has also been keeping us very, very busy in holding various conferences, inviting various dignitaries across the world. And to name a few, I must say that we have had a judge from the International Court of Justice, we have had judges from Australia, Chief Justice of Singapore, and a host number of honorable judges from different parts of the world, including Latin America and Africa. Visit the Supreme Court, and we have had proceedings which have taken keen interest in how justice dispensation is happening in our courts. It's knowledge sharing and openness of, and also the views. We have been benefited. In fact, people who have come from across the world have great appreciation for the justice delivery system in India. From a lawyer's perspective, India has approximately 50,000 lawyers joining the profession each year and is gradually opening its doors to foreign lawyers with the Bar Council of India's new regulations in 2023, permitting foreign firms to be set up in India. What these young lawyers, these young students would do eventually in life, I really do not know. But definitely, as in when you amass wealth, make sure that it is with the object and purpose of distributive justice and not only your progression. I would also say a few of the pertinent tools, you might say, being used by the judiciary to have sustained rule of law furthering economic developments are technology. Indian judiciary has embraced technology through the implementation of e-courts and increased usage of online research platforms which involve digitalization of court processes, case management systems, online filings of cases and virtual hearings. The second phase of e-courts project is nearing completion. And as Dr. Chandrachud has been saying, that we are going to revolutionize the Indian judiciary in leaps and bounds. There's one important aspect which I must focus on, and there's no better person to guide us on this aspect would be Honorable Justice Swatantra Kumar. And that is, with the economic development, sustainable growth also has to take care of the environment. Recently, I went to Nepal, and while returning, I saw that all the peaks, and this is the second time it is happening in running, all the peaks were barren and naked. There was no snow. So the economic development has to also keep in mind the environmental protection and degradation. I also, my esteemed colleague, Honorable Madam Justice Kohli has already spoken about the various ADR mechanisms, the arbitration and the mediation platforms which have been set up in the last 1 year, and I've taken progress in leaps and bounds. Singapore was a very hot destination. Thankfully, India has also now taken the steps in becoming second to none. And with these words, I would say that while India has made significant strides in strengthening the rule of law, the challenges persist. Surely, the deliberations of this conference would find solutions for these problems. Thank you very much, please.
Thank you very much, sir, for that. And I really appreciate the fact that you talked a bit about issues surrounding social responsibility of lawyers. In fact, when Ms. Jain had invited us to this panel, the theme of the conference, one of the sub-themes is actually philanthropy. And it's something that lawyers don't talk much about, and we will come back to it a little later. May I invite Honorable Mr. Justice Rajesh Bindal, Judge Supreme Court of India, to share his introductory remarks.
My sister Hima Kohli, brother Sanjay Karol, brother Hemant Gupta, and brother Swatantra Kumar, and the Director General. Basically, we call any person who calls on the programs is Professor Raj Kumar. I think he also thought that we also need to be taught something, so he has called all of us here. Otherwise, day in and day out, we keep on learning in the court with the number of cases listed and the lawyers assisting us. So it's a learning process continues. I think this is one of the professions where you continue learning throughout your career. You can't stop learning. With the changes coming in the society, the kind of litigation, the quality of litigation changing day by day. And why this subject is being discussed, role of court? Because ultimately everything finally lands in the court only. Whatever the policy the government frames, whatever litigation, somebody private disputes, or the maybe within the country or maybe international, private international, lot of issues, everything will land in court only. So that's why finally the word of the court will only come in to resolve the same. And we decide the cases in the court as per the constitution only. There is no doubt about it. The issue remains the balancing of rights. There, yes, the courts exercise their powers where the interpretation is required. A larger public interest somewhere is required to be seen as compared to a private interest. But one thing I can share that the court system throughout the world can learn a lot of things from our system, because the kind of work and the quantity of work we have is nowhere in the world. So whatever experience we have is altogether different. And in that also the role of the lawyers is very important, because they get the law evolved with the passage of time. You are seeing number of judgments which had come in 50s, 60s, 70s. The view has changed with the passage of time, because the law also changes with the society, the need of the society. Economic development, brother had touched the issue. If you see in India also, the social justice he had talked about, social justice also, what we have seen is the people who were below poverty line, I think 5-10 years below, about 15-20 crore have come up of below poverty line. So that shows some social justice is being done because of the economic development, because of the industrialization, or a lot of other issues are there. And with this economic development, naturally the government resources also have their own share in that. And once the revenue comes to the government, it is spent on the poor state of the society. I think that always helps. In maintenance of law and order, that is also an allied subject basically. If somebody has 2 meals to eat, maybe he will not involve in crime also. Bringing the peace in the society also is very important. Environment, yes, I think one thing which we read is that we should leave the world a better place to live, and not in the greed, whatever is there, we should take away everything today. So with these few words and the elaborative address by my sister and brother, I don't think I should take much time. Thanks for inviting me, and I will also learn in the process. Thank you.
Thank you very much, sir, for sharing some of those views and perspectives. Especially, we will come back to the Human Development Index, the ease of doing business and things like that. May I invite Honorable Mr. Justice Hemant Gupta, former Judge, Supreme Court of India, Chairperson of the New Delhi International Arbitration Center, to share his reflections. It's working, sir.
Thanks, Professor Rajkumar, other panelists, students, and other distinguished guests. I will start with one reservation, with apologies to Dr. Rajkumar. Whether the rule of law is an advancement of economic development, or is the rule of law in putting roadblocks in economic development. The one, it doesn't make news if the court is upholding economic development. It will make news if the court is interfering in the economic development. We'll remember the recent judgment on electoral bonds or other cases starting from way back, actually from 1951, Shankari Prasad, when the court interfered, set aside the Aggregate Reforms Bill, Acts of Madhya Pradesh, Bihar and Uttar Pradesh. Shankari Narayan, Kameshwar Prasad, and then came Golaknath, and ending with the Keshwanand Bharti. The difference in all the judgments is like Keshwanand Bharti 7/6. So what do you say, that whether the 6 who are dissenting or the minority judges are not relevant, or but as a rule of law, we go by the majority. India has a basic distinction as compared to the US. In US, the 9 Supreme Court judges are appointed by the President with the approval from the Senate, and then it is debated what is the political philosophy of the candidate, whether he will be good or sporting of the political party like Democrats or Republicans. But in Indian system, there is no such system. Judges are said to be apolitical. But even if we are apolitical, but we grow with a particular viewpoint, kind of upbringing which we have, kind of social structure we belong, that influences our thinking process. That's why there is a difference of opinion among us the judges in the same matter. It is commonly said if the same matter is placed before three different benches, you will find three different opinions. So therefore, in my parent High Court, where Justice Bindal also comes from, in matters like FIR, anticipatory bail or the regular bail, there will be difference of opinion. Therefore, the court decided as a matter of system that all cases arising out of one FIR would be placed before the same judge, because at least in same matter, there should not be a contradictory orders. But that may not be true about Supreme Court, because the same FIR matters are not clubbed together. They are listed before different benches, and different benches give different viewpoint. Because justice dispensation system is very, very subjective. My view will be very different from Brother Bindal's view or from Sister Hema Kohli's view. But that is the development of law. That's how we have learned how to reconcile different views. That's a big challenge which we face, subjectivity in the decision-making process in courts. The issue is how do we say that the courts or the rule of law will lead to economic development. Economic development, as I said earlier, if it is positive, there is no news. If it is negative, it becomes the news. Like it's commonly said, if a dog bites man, it doesn't make a news. If the man bites a dog, that is the news. So same way, the interference of the court in certain matters makes a news and not the other way around. I will only say that I've written a lot many pages, but in court, the lawyers, we are here, Mr. Kapoor and other lawyers, and you will be all budding lawyers, you will learn. The lawyers are the best psychologists. Each lawyer modulates his argument, keeping the view of the court. If a judge is liberal, we all know there was a time in 1970s, everybody knew that he's a pro-tenant, pro-landlord, you will raise an argument accordingly. One understands and modulates law, keeping the viewpoint. Otherwise, the creativity is gone. The lawyer understands how to raise, what to say, and what not to say before each court. That is the one aspect. In the respect of arbitrations, when the 1996 Act came into the picture, an award could be set aside if it is against the public policy of India. What is public policy of India is not explained in the Act. In 1996, I was a practicing lawyer. When I read this clause, it says it is a Pandora box. Because how do you define public policy? Then a Supreme Court judgment came that the public policy will include if it is a patent illegality, picked up from the 1940 Act. Then subsequently it was explained that the principle of patent illegality will be a ground to challenge. Again, what is patent illegality? It's again very subjective. I may say it is a patently illegal, the other may say no, it is not patently illegal. Because we have to have specific conditions in the statute on what grounds the court can interfere. But in the recent trend is that you hold your hands back, give the arbitrators the choice of the award which he has passed. We should not interfere as a court because to avoid the subjectivity. That is one process of dealing with the matters. The law will keep on evolving. We are all there and trying to learn the process of law. Thank you very much.
Thank you very much, sir. We'll come back to some of those issues. May I invite Honorable Justice Swatantra Kumar, former Judge, Supreme Court of India, to share his introductory reflections.
Firstly, I would like to thank Professor Raj for having provided me this opportunity of sharing this morning dais with the distinguished and most eminent judges of the Honorable Supreme Court of India, Justice Hema Kohli, Justice Sanjay Karol, and Justice Binder. I hold all these three honorable judges in a very high personal esteem, and therefore I am really honored to share the dais with them. Coming to Justice Hemant Gupta, a cool judge, now heading and creating an institution for international arbitration hubs. And Professor Raj, supposed to be the moderator for this session. I'm sure, ladies and gentlemen, all of you know that moderation goes nowhere near Raj. If he was having the element of moderation, Jindal University would not have been what it is within this short period. So my all compliments to this man. And obviously, the delegates, students, and distinguished invitees. Without you, dais will be meaningless. So therefore, good morning to all of you. Look at the topic that we have for today. It's a beautiful triangle of stating the role of judiciary on the one hand, rule of law on the other, and finally, the economic development. Frankly speaking, I see no conflict between them. They are essential features, and within this triangle of three angles falls a country's fate. What will be the fate of the country and its citizens would evolve from these fundamental concepts. They say the founder of this expression of rule of law had defined three elements of rule of law. He said absence of arbitrary power on part of authorities, equality before law, constitutional supremacy. I would add another element, which in my humble view is fundamental, is right to access to justice. If a country or its legal system does not provide for effective and easy access of justice, whatever be the structure of the rule of law in that country, it would prove to be quite ineffective and maybe even futile to some extent. Well, as Justice Karol mentioned, that Constitution has the core of rule of law. Unlike US, unlike UK, the Indian judicial role is controlled by the Constitution of India, while in the United States, it is controlled by Senate. In UK, it is controlled by acts or the legislative formulation. So what we really need to look at is the constitutional framework of India, right from its commencement of the preamble, which talks of social, economic, and political justice. To administer this justice to the citizens of this country, it is essential that
we have a rule of law which is effective and which really deals with the protection of rights of the citizens. The rule of law is the test or the touchstone of the administration of justice system in a country. It is called inner morality of law. If we look at the first contribution which I think has been made by the courts to uphold the rule of law in our country is what just now was referred, is the Keshananda Bharati's case, and where the theory of basic structure of the Constitution was enunciated. Please imagine the Indian state of affairs in absence of Keshananda Bharati's case, where the Parliament would have the right to amend anything and any part of the Constitution, protecting and enunciating the basic structure theory changed the entire economic concept in our country and its interrelationship with other countries, even in economic terms, because there was a greater certainty of law. People knew that there will be some part of the Constitution, some part of the rights of the citizen which cannot be touched upon. So that created what normally is called the 3C principle: certainty and surety for the people, clarity of law, and the confidence. If you see these three things, how they emerge out of a legal system is primarily for the reason that there is a certainty of rule of law and implementation of enforcement of law. Once these doctrines were put together, then it comes out with a clear mind that we need a clear rule of law adherence, application, and enunciation. Objectivity of rule of law is the essence. You cannot have in any country implementation of law without enunciating and without adhering to the basic fundamentals of rule of law. Your right of hearing, your right of protection. Now see in our Constitution, for instance, expansion of, or which I normally quote everywhere I speak, the misunderstanding between creativity of law by the courts and overreach should be understood with absolute clarity. Article 21 today has led to creation of 5 legislative acts resulting from creativity of judges, not from overreach of judges. The courts have been, in order to adhere to the rule of law, have been very creative in enunciating certain principles which have led to the social welfare legislations in our country for economic growth, for maintaining sustainability in relation to all other laws, and as well as in our interrelations with different countries across the world. Thank you, ladies and gentlemen.
Thank you very much, sir. I think all the judges who spoke have really touched upon some of the core issues. Now we have around 10 minutes or so. I'm going to be fast and ask a few questions. Let me start with Justice Seema Kohli. Ma'am, is it fair to say that since the opening up of the Indian economy in 1990s, all institutions have been reshaping and reimagining their purpose, their vision, and indeed the impact? And so considerations of economic impact has also become an important factor that judiciary takes into account when it's adjudicating. If that is the case, what are the things that goes in a judge's mind when they approach cases such as, for example, in Shiva Shakti Sugar versus Sri Renuka, where the court observed the court needs to avoid that particular outcome which has a potential to create an adverse effect on the employment, growth of infrastructure or economy or the revenue of the state, unquote.
Thanks, Dr. Rajkumar. Am I audible? Yes. Thank you. So this was a judgment authored by two judges, Justice Sikri and Justice Sapre were the authors of this judgment. And the emphasis, and I'll just quote that a little bit, is that the opinion of the court was that the economic analysis of law ought to be broadly accepted in India and serve as a guide to statutory interpretation. What would that mean in real terms? It would mean that the Supreme Court must serve as a pivotal affirmation of the judiciary's role in fostering the state's economic growth, of enhancing the well-being of its people within the constitutional framework. So we remain within the structure and we interpret it in a manner that shows that there is a definitive interpretation of the nation's economic prosperity, which is of prime consideration, of its citizens' welfare. And that is also integral, all of it within the framework of interpreting the Constitution by the judiciary. This approach is just not a legal precedent, the judgment that has been quoted. It embodies the judiciary's commitment to ensuring that its decisions reinforce the economic infrastructure, they stimulate employment, and increase the state's revenue without compromising the principles that are enshrined in the Constitution. That's the bottom line. So through these interpretations, the judiciary has positioned itself as a guardian of the population's legal and economic rights, its aspirations, and acknowledged that economic stability is the cornerstone of social well-being. I think that answers it, Professor Rajkumar.
Thank you so much, ma'am. May I invite Justice Sanjay Karol? Sir, the role of G20 has been brought to limelight more recently. To what extent Indian courts use experiences from other jurisdictions, both in influencing and impacting economic decisions? Because, you know, within the G20, there are very developed countries and there are developing countries, and clearly the balance needs to be struck between those two issues when judges are deciding cases.
Professor, I think it is the other way around now. The world is coming to India and seeing what India is doing, how Indian judiciary is functioning. And more so, not only with regard to the access to justice, which was referred to by Honorable Justice Kumar, but also the efficiency and the efficacy in the justice delivery system and the hierarchy which we have in justice delivery system. As I mentioned, people have been coming from all across the world, and they are fully appreciative of how we are functioning. And let us not forget, 140 crore people and more than 10,000, 15,000 judges in the country at the level of district level and thereunder, and approximately about 950 judges at the Constitutional Court. So therefore, we are very, the Indian judiciary undoubtedly is very meaningful, very purposeful, and now the world is looking towards us, not only in terms of an opportunity for economic development, but also ensuring that all dispute resolution mechanism is India becomes the hub for dispute resolution mechanism. Thank you.
Thank you very much, sir. May I invite Justice Rajesh Bindal? In a short span of time, I'm going to ask you a difficult question. Sir, we have 50 million cases pending in our courts. One of the things that a foreign investor or somebody who is looking from outside coming to India is that they want to see how effective and efficacious the legal system is. I would love to hear from you. What are the efforts that the court is taking to, address the pendency?
Thank you, Professor Rajkumar. Yes, we know the number of cases pending in our country. We have about 80,000 in the Supreme Court and 61 lakhs in the High Courts and 4.42 crores in the district courts. I think to take out all this, we are using a lot of technology now. And it's not that all the cases are delayed. You see, there are good number of cases, about 75 to 80% cases, which are decided within 2 or 3 years of their filing. These are very small number of cases which are delayed in the process. State being a largest litigant, yes, it is said, but if we see the data, in the Supreme Court, the civil litigation is 78%. If you go to the high courts, it is 72%, and the district courts, it is 25% only, because major chunk is criminal litigation. In criminal litigation, the state has to be party. So we can't universally say that the state is a compulsive litigant, but High Court and Supreme Court, we have seen that. And to check that, we got a lot of litigation policies prepared from the state, that in what type of cases they have to litigate and what they are not to. And there are policies of the government, especially in the tax department, they have fixed some threshold limit to challenge the orders before the High Court or Tribunal or the Supreme Court. So this is the way we are trying to curb the litigation. E-court projects is there. Now, a lot of amount has been sanctioned by the government for that, and the recent third phase is of more than 7,000 crore rupees. And I'm happy to learn that recently there was a conference in Bhopal where the judges from UK had come, and they were surprised to see what India has done in technology in the judicial system. They don't have even 15-20% of that. So they were really surprised, and especially the numbers which we are having, the digital transactions we are having, how we are giving access to justice to the people. In legal service authority, yes, we say access to justice is one part, we are giving access to court only. But still, access to justice is also being given, and the quality of litigation. And another thing which I just want to share with you, now our e-court project was also appreciated by the World Bank in 2019 in ease of doing business, and our ranking, I think, improved at that time by 20 numbers. And we have commercial court acts where pre-litigation mediation is compulsory, and there are time-bound directions for conclusion. Then the Mediation Act has come, and in the Mediation Act, you see, it is executable as a decree of the court now, and on a very limited grounds. So these are the steps being taken. There are special courts, commercial courts, to take care of all this. If you go to the website of the NJDG, you have some data on that, data in the sense processed, that what are the reasons for delay in the court system. So this gives a guideline to the judicial officers, to the persons who are at the stage of planning, to take care of all these delays so that we are able to dispose of cases. It's not that the cases are not being disposed of. So this is little I just wanted to share.
That was fantastic. Thank you very much, sir. Please, ma'am.
Just for your understanding as students, there is a difference between pendency of a matter and arrears. Let's not mix up the two. That is, this matter goes into the system and becomes pending doesn't make it an arrear.
Right.
Every matter has a lifeline. For example, a simple civil suit will have a different life vis-a-vis an appeal, vis-a-vis a writ petition, vis-a-vis a criminal revision, or any other subject jurisdiction. So when we have yardsticks to measure what is pendency and what is arrears, as in flag it, as in red, green, red, yellow, so on and so forth. And it is monitored regularly by all courts, and most of us get back and check what is the pendency of our courts to see what is the progress. And it's not just, let's say a suit has a 5-year life. Compared to that, a writ petition will have a few months' life. So pendency of a matter is not an arrear. Do keep that in mind. That's what I wanted to
Very important lesson to learn. Thank you so much, ma'am. May I invite Mrs. Hemant Gupta to quickly reflect on the fact that to what extent arbitration and alternative dispute resolution can grow in India, especially to address economic matters. Clearly, we have the developed world taking a lead on arbitration. In this current context, should we be looking at Asia and other aspects, other parts of the world to advance our arbitration vision?
It's a very important question, and for my point of view, it is, somehow or the other in India we have grown with the idea of ad hoc arbitration. Ad hoc arbitration is where the court appoints an arbitrator. And this practice is continuing for last more than 80 years. 1940 Act talked about appointment of an arbitrator by the court, and 1996 also talks about that procedure. The lawyers, and to some extent even the judges, can't comprehend that institution other than the court can appoint an arbitrator. To be honest, I was Chief Justice of 2 courts. I exercised the power of the Chief Justice as a delegated judge. I had no idea that institutional arbitration is also a concept. This came to my mind only when I started working as a chairperson of this institute. Their world is divided into two parts. One is the developed countries, one is the developing countries. Developed countries, Singapore is one, Europe is one, the America is one, but the developing countries, India is at the threshold of being a developed country and developing country. The other countries in the Southeast Asia, in the Central Asia, in the African continent are the developing countries. So, to say that India should become a hub of international arbitration, we need to strengthen our institutes. We have the big pool of experienced lawyers, arbitrators, but the ecosystem is not supporting us. Why people prefer Singapore is that post-award, the setting aside of the award is dealt with in a very effective manner in a timeline, in a quick time. But in India, if award is challenged, can you help me with But in award, if in India is challenged, the first date of hearing would be after 3 months or 2 months. Then opportunity of hearing, blah, blah, it will take at least a year on a conservative estimate. But Singapore is able to decide the objections against an award within 3 months. That gives rise to the confidence in the litigating public that the judicial system is supporting us. We need to, like Delhi High Court has done that, where they have constituted a special bench for intellectual property rights, where the matters are decided in an expeditious way. But this experiment is not being done in the other high courts. We need to constitute special benches for deciding arbitration matters, to decide, to give a quick decision, so that people have a confidence that if award is given, it will not go into the cold storage for years to be decided years after. I was in Chandigarh about 2 months back. One of my friends came. He says that award was given about 10 years back by a former Chief Justice of India, but the objections are still pending before the High Court. That is...
Thank you, sir, for those candid reflections. The ABA chair has told me that the time is out and we need to leave, but I'm going to ask one short question to you, sir. Sir, most of the time when it comes to economic decision-making, somehow environmental issues are put up front as if they are at loggerheads with each other. Having served at the NGT and the Supreme Court, how do you think we should navigate this conundrum?
Well, there is no conflict between development on economic means and the protection of environment. It's a misunderstanding. Once you talk of development, then you must talk of sustainable development. When you are doing unsustainable development, reckless development, destruction of natural resources, you can't call it as development. So once you call the development in its true meaning as it is understood by virtue of law, I am not understanding on individualist basis, then there is no question of any conflict. Please kindly examine two doctrines together, doctrine of public trust and doctrine of distribution of state largesse. Both of them apparently look to be in conflict, but if they cannot be, because they have to be applied in a very congenial and a meritorious manner. If the assets of a state are to be done or any development of the country is to be done, then it must be done on sustainable basis. Sustainability is doctrine of balancing. You must think whether you need to destroy a natural resources before you make a development, or you can drive a balance between the two so that you develop as well as you don't destroy.
Thank you very much, sir, and thank you to all of you. I want to thank all our distinguished judges for their presence, and I want to thank our audience and thank the ABA chair, Ms. Pratibha Jain, for giving us this opportunity. This session is ended. Thank you very much.
Thank you very much, everyone, and I would request our moderator, Professor Dr. C. Rajkumar, to present a token of appreciation to the esteemed panelists. Moving on, ladies and gentlemen, may I now invite on stage Ms. Reema Arora, Trustee V for her foundation, for her special address. Please welcome Ms. Reema Arora.
Ladies and gentlemen, a very good morning to all of you. Speaking in presence of this distinguished gathering of the finest lawmakers gives me immense excitement. Hermann Hesse wrote, and I quote, "In all beginnings dwells a magic force for guarding and helping us to live." These words inspired Pratibha and I to start our foundation, We for Her. We for Her literally stands for our motive and philosophy, one that recognizes female emancipation as a social, economic, developmental, legal, human rights, educational, and health requirement, and to look for solutions for every obstacle in the path. Having lived and visited various cities across the world, we felt a sense of fear about ours and our daughters' security everywhere, especially in Delhi. And we realized that if, in spite of being privileged, we feel insecure today, what about the less fortunate ones? The grim reality of violence against women is a symbol of deep-rooted patriarchy. Globally, 1 in 3 women experience physical or sexual violence. India ranks 128th out of 177 in Women Peace and Security Index. Indian women today feel less safe, even though the representation of women in the parliament has grown in the last 5 years, and there is increase in financial security. Last year, the National Commission for Women registered close to 29,000 complaints of crimes against women, including domestic violence, pointing out to the safety issues even within the so-called domestic sanctuary. Death, tragically, is often the most catastrophic consequence of this widespread problem looming in its myriad forms: physical, sexual, verbal, digital, material, economic, and even honor-based violence. Each form inflicts its own brand of harm, leaving scars that may never fully heal. At We for Her, we understand the urgency of addressing this issue head-on. We are committed to empowering women, whether seeking justice against violence or trying to bring a positive change through new ventures. Violence has a direct correlation with disempowerment, and disempowerment of 50% of the population has a negative impact on the GDP of the country. Every woman deserves to feel safe, respected, and empowered, regardless of her circumstances.
according to the study conducted by the Ministry of Labour and Employment, Government of India, on female labour utilization in 2023, less than 1/3 women participate in any economic activity or paid work. The female homemaker norms keep them away from labour force and refuse recognition in the system of economic statistics. This ensures women are financially dependent and therefore may be oppressed. Female participation in labour force is essential for an inclusive and sustainable development of the country. At the macro level, greater level of women participation is a must, and that will ensure that we achieve our goal of Viksit Bharat. To dissolve the taboos and insecurities associated with females working in mainstream economic activities, we need to create a healthy, safe, and hygienic work atmosphere and create cities that are safer for women. No woman should ever feel afraid to navigate public spaces freely or walk alone freely. We for Her is committed to this cause since its inception in 2020. Starting with running a campaign for reclaiming public spaces for women, We for Her commissioned a comprehensive study by Janagraha to delve into the reasons why women perceive Delhi as unsafe and to gather insights that will inform and shape future initiatives aimed at creating safer urban spaces in India. Ensuring safe travel is the only way of integrating women wholesomely into the fabric of socio-economic fabric of the country. Education is the key in this endeavor. We must teach our children, both boys and girls, equally about consent, respect, and equality from a very, very young age. We for Her intends to raise awareness and literacy through various programs. Access to higher education empowers women to make the right choices. All research from the past points to the fact that rule of law and justice ensured are the main deterrents for any crime or violation. Legislation in itself would not suffice because violence against women is a socio-economic problem, and one has to approach any deep-rooted social problem in other ways as well. But legislation is necessary and essential to give that push and have educative factor as well as the legal sanctions that will give public opinion a certain shape. We cannot combat gender-based violence and bias alone. We for Her calls on you to join hands in a collective effort, a united front against injustice and oppression. We must challenge the patriarchal structures that perpetuate prejudice against women and create a culture of accountability and support. Right to justice acts like a protective umbrella of other fundamental rights under the Constitution of India. We for Her aims to provide the survivors of any oppression with the resources and support they need to rebuild their lives and seek justice. We intend to support women seeking to uplift themselves through economic endeavors. We call upon you to lend your time and support. As we stand here today, we have different opportunities to bring about a positive change. We all have a part to play, a part that no one can play better than us. I would like to take this opportunity to introduce to this august audience our website, We for Her. So here we are trying to create a platform to give legal support to women who are in need. So they can go here, ask for a request. Can we scroll it, please? Yeah. And so this is the website, and this is for all the lawyers and law firms choosing to do pro bono work. You can register here on the website, and this will connect all the women seeking help directly to the lawyers or law firms choosing to do pro bono work. This will also have the option. Can we go to the main website, please? Yeah. This will also have the option of posting relevant blogs, tools, research papers, and any relevant events taking place anywhere in the world for female emancipation. This is going to be a community website, and I request all of you to go through the website, please. In closing, We for Her reaffirms our commitment to empower women, to remind them of their Shakti, to help them get their rightful place. This is just the beginning. Let us stand together as allies and advocates to create a world where every woman lives free of fear, free of the shackles that centuries of patriarchy has bound her to. Thank you.
Thank you very much, Ms. Arora. Well, as we progress through our summit, it is time to turn our attention to another highlight. We have another Managing Partners panel, Law, Governance, Philanthropy and Artificial Intelligence, a discussion that promises to dive deep into the strategies and insights from the helm of India's leading law firms. Our moderator, Ms. Naina Krishnamurthy, founding partner K-Law, will guide us through this rich conversation, unpacking the challenges and opportunities facing law firm management today. Please, Naina, can we have you on stage? And introducing our eminent panelists for this session, please welcome our first panelist, Mr. Ajay Behel, the co-founder and managing partner at AZB and Partners. Our second panelist is Ms. Pallavi Shroff, the managing partner at Shardul Amarchand Mangaldas. Please welcome our third panelist, Mr. Nishant Parekh, partner at Trilegal. And last but not the least, please welcome Mr. Vivek Chandy, the joint managing partner at J. Sagar and Associates. And Naina, the stage is all yours now.
Thank you so much. I find myself in a very enviable position today, with my colleagues, my esteemed colleagues, and to moderate them is really an honor and a privilege, and I hope I serve them all well.
You get an opportunity to grill us, it's okay.
Okay. So without further ado, let me just start, because I know we have a limited time and there's so much of knowledge that we want to glean from each of you. So let's start. I think my first question to all of you, and anyone can answer this first, is what would you change? And maybe in one word, one sentence, two sentences. What would you change, knowing the world that it is today, the amount of advancement, evolvement, the world that we live in today? What would you change, the one thing that you would change when you started your career in the 90s, the 80s?
Okay.
Would you like to?
Hi, thanks. I would say AI and IT, because I think thanks to AI and IT, research tools are so easy. Today we see that you can have judgments translated in every local language. Digital land records have all, now been, made available, and earlier they were not available. So while there are a lot of downsides working with AI, I think it's really helped make the profession easier. Hybrid working places, people now, ladies, at our firm, we encourage ladies who've had children or who work with husbands on transferable jobs to work from home. And thanks to IT, they've been able to do that. And we have some of our best lawyers who are ladies. So I think that's really been a big driver, IT and AI.
What would you change?
I would have had a creche at the firm earlier than we did. We started about 15 years ago, but I would have started it much earlier when I had my children if I could have, but somehow it didn't happen. And I think AI and everything else, I would actually learn as I go along. Technology was non-existent when I started practice. Today, we are all tech savvy. We have to be. So that's what you learn along the way. Of course, it makes life much easier. But the only one thing I wanted to change if I had to go back in time was to have a daycare center in the office, which we have in our larger offices. So that's the one thing. It's so much easier for women.
Absolutely.
And make medical facilities available. So we have doctors who come to the office once a week, both homeopathy and a lady doctor. So some of those things which are more elements of welfare, I would have liked to start earlier. We started some 10 years ago, some 15 years ago. But if I could have gone back, I would have started those things earlier.
Thank you. That's really insightful. Thank you. Ajay?
I mean, let me be contrarian. Frankly, when I look back, nothing actually, and I'll tell you why. The one thing that I do ask myself is that would I have spent 7 years practicing as an accountant, as I did, as you know, from my garage, and become 6 years junior to most of my colleagues from college. But I think, frankly, I think the answer there is that till law colleges embrace much more about accounting and finance today, and everybody is more like Professor Rajkumar, who has taken this initiative and gave me an opportunity to speak on this aspect in the college about integrating accounting. Because 5 years residential course, you should be able to make a lawyer come out at least 60% as a chartered accountant. Because you're in-house, you've got fantastic facilities. As CAs, we have no facility, there's no training facility, there's no learning centers, no nothing. And the world of law, business, and the combination of finance, accounting has become ever so critical. So that's the one thing I always ask myself, that would I have changed? The answer is no. And of course, whatever else we add as facilities, when you're in your garage, you don't think about what you would be able to do when you get to a little larger office. But of course, other things would happen with time. But this is one thing that I do consider once in a while. But the answer is still no.
Ajay, actually, it resonates with me because my first job was with this accounting firm called Arthur Andersen in the 90s. And when I joined that firm, I had to stop being a lawyer and be an accountant because I think they didn't have any patience to hear the legal principles and, the application of law. They just wanted to understand how can we get this done and how can we get it done within the legal parameters that were available. And I learned to read a balance sheet there. I was forced to read a balance sheet. I didn't know how to do it. And the thing is that I did law because I didn't want to do math anymore. And I came right back into it.
That is a misconception, by the way, which I cleared at Jindal.
Absolutely. And I
cleared it at Jindal because I asked Rajkumar, what is the basic reason people don't do law? And I asked accounting, and all the thought of students all said, we're scared of maths. I said, we do no maths. At least you can use a calculator for sure. That's all you need.
But let me tell you that if you're trying to escape math, you are so,
But I agree with most of us. I'm a disputes lawyer, but we're both corporate lawyers, and you too, Chandy. But I think accounting is so essential, whether you're doing corporate law, you're doing schemes of mergers, amalgamation, or you're writing out your formula for deferred payment, or whatever way you're doing it. You need it. When you come into the disputes world, you need to understand the fundamentals of the transaction, which are quite often based on accounting principles. When you do disputes on, delays, or what are the damages. Again, you need to do valuations. If you don't understand valuations, how are you going to cross-examine someone, understand or even do justice to your own client? So understanding business, even for disputes, is very, very critical. You know, how many of us ask the client when the when you get a dispute, what do you want to achieve out of a dispute? What was the fundamental of this transaction? Did you concede A or B or C? What was your thought process? You know, so I think as disputes lawyers, we view the same transaction documents very differently.
Nishant, you're the youngest amongst us, but...
So, speaking for myself,
yes.
I ran away from engineering. Right? And, you know, I want to make a confession. Sometimes I do get dreams of writing that engineering exam and wake up in the middle of the night. So I'm glad that I'm a lawyer. But let me give you two answers to your questions. One is slightly more personal one, and then one from the standpoint of how I see things as a law firm leader. What is the one thing I would change? I would be a dispute resolution lawyer. I wish I was better advised when I started my career. And I really feel that the impact and the change that you can bring through dispute resolution is immense. So I wish I could change that one thing. But now when I look at things as a leader in a law firm, I wish I could change my country, my location, because and this is an industry issue. I feel as some of the top law firms in India who interact with clients and various other stakeholders, I really feel that we need to compete in different ways rather than on pricing. Yeah. If you look at fees and rates that law firms charge in this market, I don't think there has been a significant shift in the last 10 years. Whereas in terms of the quality, in terms of just the range of things that law firms do, and law firms in India and each one of us have reinvented ourselves every few years. The kind of advice and the depth of advice that we provide to our clients somehow doesn't match up with the kinds of rates that we are able to command in this market. And I really feel that we ought to not compete on rates and hold our rates.
Nishant, I couldn't agree more with you, because somehow or the other we see the only way firms compete is to cut price, and it's a race to the bottom. And I agree, all of us have reinvented ourselves, we've learned more things, we've kept in pace with what's happening globally, brought the same law and the same techniques and everything back to India. But we compete with somebody who comes and says, I will just undercut by more than 50%.
No, actually, I have a thought to the contrary, because while I disagree with undercutting, I think maybe rates have stayed the same, because today we have very efficient GCs, we have much more lawyers, we have technology that's helping us in making things more efficient. And I think, speaking for all of us on the dais, I think we've all done reasonably well, even with the rates that we are charging, the same rates for the last 10 years. So...
You know, but rates is one thing. Costs increase. Even in the law firms, costs multiply, actually.
Without a doubt, I'm seeing that every day.
But the rates don't. And that
but
is a challenge.
like I said, maybe if we can be more efficient and, deal with rates, but we are also always pushing for higher rates.
So as the only woman on the panel, I wanted to ask you this from your perspective. What do you define success as? What is your definition of success? Is it just profitability? Is it something that is softer? What do you feel success is?
Being in a competitive world, in a competitive scenario, from pure business perspective, I think profitability is very important, and none of us can ignore profitability, because ultimately people have to be paid and costs will increase. I think profitability is important. But I think equally important, if you ask me, is a satisfaction that people get that they are working in a particular firm. And I think unless you have that satisfaction, the feeling of belonging beyond the money, I think you cannot succeed. So whether you are doing something more like providing some of the services, facilities, enabling women, creating the atmosphere for women, because at least in our firm, women are about between 45 and 55% of the total number of associates and partners that we have. So given that, unless you are creating something plus for them, it's going to be very difficult for all of us if we don't manage that aspect, the softer aspect. Today's day and age, mental health, a very big factor. You need to recognize that. You need to have programs for mental health. And I think the faster we recognize and provide for that, it's very, very important. We at the firm have a very robust program for mental health, for women, and it's more than just saying that you can work from home 3 days a week or 4 days a week. That may be a facility they need once in a while, which is fine. There's no problem. But you have to create the atmosphere, which is a more enabling atmosphere. And that has to be driven by the leader.
So speaking from personal experience, I completely agree with you, because I always say the story is that I started this firm because I never had a place that I felt was my own. I never felt connected. I gave a lot of myself to whichever job I was in. I think I was a fairly good lawyer, and they could have retained me if I felt that sense of belonging. So you're right. You've got to feel that you belong in that place.
And you are important for the firm.
Absolutely.
Even if you're the first level associate, you have to feel that you are important for something.
And
you
you're
have
not just
a role to play.
And you're not just a cog in the wheel of whatever it is. And as far as mental health goes, for us, we started this during COVID. We have a therapist on call for the lawyers at the cost of the firm. So we take a lot of interest in that.
So we also have every Wednesday is a Wellness Wednesday. We've tied up with an agency. They come on site. They make available mentorship, and also they have a psychiatrist there and a psychologist. And we make that facility available to anybody within the firm, and one person from their family, whoever they want to bring. So they can have 52 sessions of consultation in a year with them and their spouse, their family, their child, whoever they want.
Excellent, excellent.
Yeah. Plus other programs as we go along the year.
Vivek, this question is for you. This much touted about AI and technology and it taking over our lives, and and the irony is, the paradox there is that we created this AI. It's the human being that has created this AI to make our lives more easy, more convenient, more efficient. And today a lot of us fear it because we feel that it's going to replace us. It's going to take away our quality of life, our livelihood. So do you think AI is a friend or a foe, or it's both? What do you think? Especially in the legal industry.
I think that really depends on how you deal with AI. For the reasons I said earlier, I think it could be a hugely helpful, it could be a huge friend, but you can't let it, control you. And my daughter's a first-year associate with one of India's top firms. And the other day she told me she was fed up of doing diligences. She said, can't AI do this all? And I said, but then if they do it probably could. But then when you become how will you become a senior associate unless you learn all this and a partner and be able to supervise what AI has done? So for those in the audience, I don't think AI is really going to be taking away your jobs, because you have to learn from grassroots to go up and supervise what AI is doing. So to repeat myself, you can use AI to your benefit, but don't be overly reliant on it so it really controls you.
Nishant, I want to ask you this. It's just sort of expansion of that same question to you. Is we have a lot of young people in this audience, and I think for them, they want to understand. Huh? We are younger. Okay, younger. Yeah, younger than us. Let me put it that way. Sorry, my bad. So, so a lot of younger people in the audience, and and so I think they want to know what their relevance will be in terms of what is it that they need to do to up their game for us to actually look at them and say, okay, you know, you're still important for us to hire freshers, and it's not because, you know, AI is doing everything that you guys already know, you've been taught. So what is it that they need to understand?
So Naina, I think AI and perhaps other new technologies that are coming out are both a friend and a foe. And it really depends on how you embrace technology. Someone said that, you know, the future lawyer is the lawyer who embraces AI successfully, right? And I can say that some of the things that we've seen, right, so far in terms of technologies that are available are extremely promising. They're very, very promising. But they're still at a nascent stage. And it is for lawyers to actually pick up those technologies at the nascent stage and make them better. There's a big, big gulf between technology and product, right? And for some of these technologies to be meaningfully used in law firms, lawyers need to work on those technologies and make them great products, right? So it's not as if some tech person is going to come in and will show you a technology which does diligence by itself, to Vivek's point. But yes, if technologists and lawyers get together, they can make their own lives better, right? And I really don't think technology is here to replace lawyers. But technology will replace lawyers who do not embrace technology.
That's a wonderful perspective, and I think I can feel a sigh of relief in the room. Ajay, can I ask you your thoughts on this?
I think it's in between. It's neither a friend nor a foe. It's a tool. I think, you know, if you look back, it's not that we, at least all of us who have practiced for the last 20, 30 years, 40 years, there have been many game changers in our own careers. Internet, for one. Absolutely. And it changed the way actually, if you go back even before internet, Pallavi will remember FIPP applications. We were probably filing 150 applications a year. True. And as liberalization happened, that was a revenue stream that went away. Internet came in. We used to give, I remember advice, since you talked about Anderson, on expatriate taxation. Yeah. Hundreds of opinions a year. All that became available on the internet. Nishit Bhai will remember. He's partly responsible for all of that with the wonderful articles that he writes. But so it's not that we haven't seen change. Now, every change sometimes is a greater change from the past, but we see it for people who haven't been through that journey. They see this amazing change and they think, oh my God, this is going to, you know, just destroy us. So I don't think it's either a foe or a friend. It's a tool. And a tool always, as Vivek said, has to be managed by people. And Nishant, I think, had the same theme, basically. So you have to embrace it. You have to accept that there are certain things it will do, which will take away the need to do certain other things that you today do physically. But what will happen is that the quality of application to the output of AI will require probably a higher standard of examination. I mean, today an AI can draft an agreement for you. We all know that. But there's no accountability. At the end of the day, if somebody goes to an AI tool and he takes some advice from there, there's no, who do they go? If we have the question, they'll come back to Pallavi or to Vivek or me or Nishant. There's no accountability. So we have to treat it as just one more important tool, maybe very dramatic tool, but not as something that is going to make somebody extinct or somebody not extinct. Certain aspects of what we do will be assisted by AI. At least that's how we see it. So I don't think there's anything to worry about, but look at it the right way. That's why I call it artificial. If it becomes human intelligence, then all of us are redundant in any case. Then we'll be artificially talking to everybody. We won't have this panel. We'll have some robots sitting here, and there'll be no debate, which is okay. I mean, it's like, yeah, maybe, yeah. So then it doesn't really matter,
On a more humorous note, I can tell you that clients are embracing AI in a big way. So we have this one client who has now a rule for their own organization that when they ask a query to a law firm, right, they will get onto the internet, they will get onto ChatGPT, and they will research that question first, make a note, right, themselves, and then pass it on to us. And the really funny thing was that on this one shareholder issue that we were discussing, we got this note, and it really looked like this note was picked up from a law school project. Many of the citations were made up.
Oh my God.
So that's that's AI for you.
Yeah, so where is the accountability, as Ajay said? Yeah. I think AI has to be viewed in terms of extension of technology. And as Ajay said, from the times that we started practicing, Ajay, maybe I a little earlier or a little later, or around the same time, we came through embracing and change of technology dramatically. We used to be in the age when everything used to be typed on a normal manual typewriter. Papers used to get cyclostyle for filing in courts. 7 copies got filed. There was no electronic, nothing, no internet, nothing at that time. The first computer that a law firm bought we bought, and I still remember Neelam Dhawan, who was there, now has become retired as the head of HPL. So it was huge. I needed a whole table and a huge screen, and the CPU went below it from these single integrated units that you get now. And then it moved to a stencilographer, then it moved to something photocopying, and then it started something else. So when you see how technology has evolved, and we have to keep embracing, and I think as Nishant said, those who don't embrace technology will not survive. You have to keep, and this is one more extension of the technology that we have today. Law and tech go together. There are tools that are available, and firms have to adopt and embrace that technology. The older generation in the firms are scared of technology. It's surprising they shouldn't be. The younger generation love technology and love to explore and play around with technology. And I think that's very heartening. They are going to push their seniors to start adopting technology. And they come up with things, at least I know they come up to me and say, why can't we try something this way? Why let's try something else? And they want more and more technology so that their life is a bit easier. Can I just chip in here
one point?
Yeah.
I think one of the things we missed here is email. When email came from people like us, from telex machines, I remember the first fax machine was so expensive, I had to share the price with my brother who had an office there because it was so expensive. But I'll just, on this technology issue, since you were mentioning it, something came to my mind about embracing technology. The power of communication or the importance of communication was lost or is getting lost with this email generation. And we were so used to building our relationships on physical contact, and many of them have endured in a very different way, not just in an institutional way, but we made friends with the clients we dealt with. What I saw some years ago, and I had a conversation with my team, is that they were happier communicating on email. And there are some people who are not smart about email, not the kids, but the older generation, and they would write an email not realizing the impact it has. I don't agree, and 40 people get that, and 40 people, other than 20 people get, angry. But when we tell people, why don't you just pick up the phone and have a conversation, there was almost a hesitation because they've just stopped getting used to this pick up the phone, have a conversation. I think COVID has somewhat restored that through the whole VC culture, thankfully, and that physical, or at least quasi-physical communication started happening. But I'm just giving an illustration of how sometimes a tool which is so effective can actually be negative in some ways, that the very essential communication skills actually disappear. So we have to be very careful. It's not that we haven't seen tectonic shifts in technology, but I have to be very careful about how we groom or how we approach this from our teams and make sure the essence of communication is not lost just because these tools exist. I'll give you one final one on AI. You'll like that. A Gujarati meal, somebody had ordered a Gujarati meal on AI, and it had a non-vegetarian dish in it. So, but the next time I ordered it, the next morning it had corrected itself. So it's dangerous. It's very smart. So obviously it knew it was wrong somewhere.
I actually want to quickly get on to the next question because I'm cognizant of the time. But this is something I spoke on the panel yesterday also, is that finally the bottom line is adapt. We humans have adapted over generations, over sort of evolutions, we have adapted. And we are still here. We will continue to be here. Why do we survive as a race? Is because we are so good at adapting. So if you don't adapt, then you become extinct. It's as simple as that. So that is what, in a nutshell, right? I'm saying what you all are saying, yeah. So the next question that I have, Nishant, to you, is how we keep talking to clients and advising them and expounding wisdom on ESG and what they need to do and how they need to be more socially conscious. What do we do as firms? What do you do as a firm? How do you weave ESG into the way you operate your firm?
So I really feel that the world has moved from paying lip service to ESG to actually doing something about it. And so as an organization, we do take it very seriously. In fact, we have internal ESG newsletters going out every fortnight where the newsletter actually talks about the kinds of advancements we have made as an organization when it comes to ESG, right? We've appointed an advisor who is helping us become a net zero organization by 2030, right? And that means that some of the things that we do and some of the things that we do on a daily basis, right? Whether it's use of plastic, use of paper, even use of water and resources, right? Is something that we are trying to limit and be really conscious when we are, and mindful when we are using these things, right? Outside of that, right? There's obviously commitments that we have made as an organization to ourselves on the on planting trees, and we're actually spending real money, resources on that, right? When it comes to the social aspect of things, as a firm, we have really come to a point where we feel that we need to do more about education, right? And so we have adopted some schools in parts of Maharashtra. When it comes to governance, and I think governance is more inward-looking, right? We take governance and how we manage the firm very, very seriously. We're an extremely transparent organization. In fact, we run it very much like a listed company. And as management, we feel we are answerable to our stakeholders. We have meetings where we, really share a lot of information about the firm and the business with our partners. And we feel that that's the way to go. And you have to keep sort of pushing the envelope on each one of these things as an organization.
Thank you, Nishant. That's so heartening to hear that. And, I'm taking actually points from what you said to apply it to the way we run our firm. Vivek, would you have any thoughts on this, on what you do at JSA?
Apart from trying to conserve resources, I think we are also doing a lot of public interest litigations for anything which concerns the environment. When I started my practice, I had no work. So I would keep filing public interest litigations, and the opportunity I got was to appear against the top senior counsel because the stakes were very high. For me, it was free batting. I was doing something for the environment. And JSA does a lot of that kind of work. So anything you need for the environment and you need a good counsel, reach out to us and we'll be happy to help.
Super. Ajay?
Yeah, well, of course, on environment, a lot of the stuff we talked about, plastic, etc. We have a hotel, so whatever we do there, we try and also bring in here, use paper, recyclable, and so on and so forth. So that's obviously a work in progress constantly. On the societal front, clearly we have a theme that people must recognize a commitment to society. The slight difference that we have imbibed is that we do some in the firm and some of it is personal. Because we give the opportunity to partners to do. I don't know if you're aware, but during COVID, we ran 16 vaccination camps where we vaccinated over 12,000 people. And we were the vaccine sponsors at AZB. And even though vaccination was free, we realized that a lot of the factory day workers were not able to leave when this was, the second time there was no lockdown. So we took the camps to them, to Okhla, Madingari, and we also had tied up with an organization which gave them rations because, there was this fear that we'll get sick, etc. So rations were given to them for a week. And I was doing it originally from my own family trust. And one Sunday night, I remember sending out an email. I said, let's see if people would want to contribute. Just within our partners in Delhi, within 10 minutes, I had 33 lakhs committed. And we spent 1 crore rupees, after which we put up a team in AZB. We imported regulators from China. We imported converters from China. So a lot of it was combined, some done personally, and all this money was given by the partners personally. Because I said, it'll be personal. Why impose on the entire firm if people want to do it? We contribute to Bharat Veer. We were the largest contributors in compared to a lot of other organizations. We've done after that we did one for widows and children actually who've got parents have been lost in COVID. Again with the same organization, 1 year complete food supply. Again done by the initiative of the partners and our council. So we spread it across in that sense. On governance, obviously, we are not a family-run firm. Nothing wrong with a family-run firm, by the way, Pallavi. I actually value that in some ways. You realize that when your kids are not in business, originally you think that, I'm free. Yeah. The problem is this becomes your family. So a lot of them sitting here are my family and you owe the same responsibility. So from governance, we are very clear that we have to take care of our people and now they have to take care of themselves and maybe at some point of time they have to take care of us. Absolutely. So I think that's a journey which we are going through and we are loving that.
Thank you. How insightful and how different each of you are doing things and making an impact on society. What about you, Pallavi? I
think 2 or 3 aspects I'd like to highlight.
Yeah.
One is, as you said, family run but professionally managed and professionally run. We've just expanded our managing board to bring many other people on the board and training them and grooming them for the future. And because you can bring people, but you need to train and groom them and help them experience the trade-offs that need to be made when you're taking decisions. How will you be inclusive in your decision making? I think that's what a leader does effectively. So training them to be the leaders of the future, I think is quite important. Governance, we also have our different committees that sort of manage things. And then, of course, we have our management board. The managing partners, of course, run on a day-to-day basis. So it's pretty much like a normal company does. You have your audit committee, you have your risk committee, you have all these sort of things the way we manage the firm. Maybe we are all for size that now we need all of these things rather than, just making it look fancy. You need it, actually. I think on governance in anything else, other than that, as I said, what we value are people, and therefore some of the DEI initiatives that we take are very important to the firm. In fact, our DEI initiatives have just been recognized by Morgan Stanley as being among the 2 outside law firms that they use, having a very good DEI program. So we were one of them, and one firm is in the US. So I think that that is something that really gives me satisfaction, that we are going to reach out to people, diversity in a true sense, whether you have people who have differently abled, gender ratio, LGBTQI, support all of them from different geographic regions, religious reasons. We have a multi-faith prayer room in the firm. So these are small initiatives if you look at it, but put together, they make a very formidable
Absolutely.
program across the firm. Then the mental wellness, when you couple with this program, I think that is, I believe it's part of governance.
It is.
Apart from managing the firm and being profitable and all of that, this is very, very important from the human side of our people. I think that's quite critical.
So,
and Naina, since you're not espousing the virtues of your firm, a few months ago when I was with our colleagues in our firm planting trees, there were several people from your firm also planting trees.
yes. Yeah, we thank you for that, Vivek. I think all of us, and I speak for all of us, and since I also run a firm, you can see that how each of us, it's not just about work and clients. We have an interest, and this is what I was saying on the panel yesterday too, that you've got to have something that is bigger than yourself. You've got to have a purpose that is bigger than yourself, otherwise you're never going to feel fulfilled. And I think each of them have sort of reflected that in their own specific way. So it's really, really heartening to hear about that. The final question, because I know we are almost running out of time. The final question, and this is for all the panelists, and maybe you can say it again in one word or one sentence, is what piece of advice, because I see so many young lawyers, young students who are on the, on the crux of becoming lawyers. So what one piece of advice that the doyens of the legal industry here would say to them for them to show up, lead, and live in this new world? Shall I go with Nishant first, the youngest?
Sure. Look, I'd say perseverance and passion for what you do. That's what this is about. And I think when I look at it as somebody who's leading a law firm, I feel as organizations, each one of us are actually custodians of careers of lawyers who join us, right? And we owe them a certain responsibility to give them an environment to become great lawyers. But to become great lawyers, the initiative really needs to come from within, right? Why do we use the word practice? We practice because, it is a practice. Each one of us practices every day, and practice makes perfect, right? And you cannot get to becoming a successful lawyer who makes meaningful impact in clients' lives without the perseverance and passion that it takes to get there.
Thank you, Nishant. I think that's very well said. Ajay.
Last year I was set up with the same question and got lambasted for telling people that they should work hard on social media. But I'll say that yet again, and I'll clarify.
2,500.
I'll clarify. Many people consider me a workaholic. I think I work pretty hard. But I have never compromised on certain basic things that are important to me. One of them is my workout regime. All through my career, I worked out every day, and clients are aware that that particular time is not available. But what I was trying to say is that the question is simply this: that is your priority your work? Everybody has to make balances. So my priority is work, but I'll find time for things which are important for me. Workout is important. We've partied. We've done all kinds of things. So it's not that we haven't lived a multi-dimensional life, but one thing was always clear: we are in a business where we are dependent on demands of our clients. And telling a client that I am not available for you is simply not an option when you're managing a firm. And now as you get into that, and I mean, so many of us here, we have to answer to our clients. And that is the only message we try and convey to people. I honestly haven't called people on a holiday more than maybe 6 or 7 times 10 times in my career, and always when I'm working myself. But somehow this impression is just because we say that you must just, forget about, not about work-life balance, but this whole concept of work-life balance has to start when you start working first. Before you start thinking about work-life balance, experience what work is, get that passion, and then ask the question of what is work-life balance. We go for an interview today, my partners tell me, we are asked, what is the work-life balance in AZB? And I say, hang on a minute, काम तो शुरू करो पहले, या फिर work-life balance की बात करेंगे.
What about you?
Work hard.
I would tell all the youngsters they are becoming lawyers at a very exciting time in India. Yeah. See India's growth, see the scope of the legal work that you can do, how challenging, how exciting, how invigorating it is, whether you are a disputes lawyer or you are a corporate lawyer or a projects lawyer. I think so much is happening. Feel the excitement that around you, the kind of work that you will do wherever you are, and passion and perseverance, grit, determination of just being there every single day to work. You can work your 8 hours, you can work your 9 hours. As I said, have your own mindset and your balance, but that's different. I think one more important thing is your integrity. Never ever compromise integrity in the profession, because you get caught in the first 5 minutes if your integrity is not there. And that will mar you for life. Your integrity is the first and the foremost thing after passion, hard work.
I endorse this 110%. What about you, Vivek?
So I'd say work hard, but within limits. Don't burn yourself out. Speaking for myself, I've never worked, ridiculous hours. But when you're working, work hard and meaningfully. And I'm reminded of the famous lines from Rudyard Kipling's, if you can fill the unforgiving moment with 60 seconds worth of distance run, yours is the world and all that's in it. And what is more, you'll be a man, my son.
Thank you. I think that was a really, really awesome panel. And one final word from me, if you ask me, what is my advice to them, is that when you fall, learn to pick yourself up. Because you're going to fall 1,000,000 times, but pick yourself up 1,000,001 times.
Very true.
Thank you very much, panelists, for such an insightful session. And now I request Ms. Pratibha Jain to please come up on stage and present a token of appreciation to our esteemed panelists. All the panelists were talking about their ESG commitments. I must say, look at each of these law firms that they represent, from where they started to where they've grown, and the kind of employment that they're creating just by itself is such a massive contribution. And, I know, for example, Ajay was talking about yesterday how he's been working on decriminalization of various laws and regulations. Each of them, I know, do a lot of work with various ministries in terms of making ease of doing business in India. And they've all committed to creating a pro bono club of lawyers that's going to focus on, at least they're already doing the work. How do we highlight the work that's already being done? So a big applause to them, please. This year we had 2 managing partner panels, as you know, one yesterday and one today. If we do it again next year, I want to do one panel with all of you on stage. And I think that would be really, truly historic, if you all agree, getting all of you, the top 8, top 10 on the stage together. So that's what I'm looking forward to next year. If you agree, please, one more round of applause. Thank you, everyone. We now turn our focus to a crucial and timely topic, navigating India's new personal data protection framework. This session is set to demystify the complexities and implications of India's evolving data protection laws. It is our honor to welcome Honorable Justice Sanjay Kishan Kaul, former Judge, Supreme Court of India, for a special address on this pivotal subject. His insights are not just invaluable, they are essential for every professional navigating the legalities of data protection in India. Can we have Justice Sanjay Kishan Kaul on stage if he is here? Ladies and gentlemen, please put your hands together for Honorable Justice Sanjay Kishan Kaul. Sir, can we have you on stage, please?
Very good afternoon to all of you. It's between a morning and an afternoon now. In this data-driven age, which we had never grown up with, and we saw towards especially the COVID period and the post-COVID period when the judiciary faced these challenges, the sheer volume of personal data collected and analyzed is unprecedented in human history. I was never a member of the Facebook, never a member of anything, till my children told me that you are on the Facebook because somewhere I may have written something and, you know, it is reported so. So the digital footprints we leave behind without sometimes being even a party to it ranges from both our browsing habits, social media activity, more sensitive information like location data, health records, and financial transactions. To give an example, I have never understood why, I'm told technology permits it, that you are, you know, if a mobile is lying somewhere, I suddenly realize if I'm discussing a particular subject, suddenly the ads start coming on that. That's the level of what I believe is the technology age's invasion into a privacy of a human being, and I am a person who values the privacy aspect. Let's look at the privacy regime, because that's the area I'm supposed to address and explain in the context of the Act which has come into place now. This privacy regime evolved from the Information Technology Act, personal data issues, and it reached a stage where we were all using in some way before this also the technology without realizing the ramification of it. So these are leveraging from a customer's data of financial inclusion, risk management, medical issues in COVID times that arose. And all that became part of public record. The concern is that if you look at the privacy regime and the understanding with the Puttaswamy's case, that is where it begins, where we gave a constitutional right to the regime of privacy. And I was party to it in some ways and had my own additional viewpoints on it. The very factum of profiling and discrimination is one aspect which arises. Security risk, manipulation and nudges, as I said, of how to deal with particular aspects. And the Puttaswamy's judgment, while maintaining the issue of privacy, also knew that there were certain things which were required to come in public domain. So it laid down a triple test criteria. The triple test criteria was that, as laid down by the judgment of the current Chief Justice, Justice Chandrachud said that the action must be sanctioned by law. The proposed action must necessarily, in a democratic society, for a legitimate aim, and the extent of such interference must be proportionate to the need for such interference. If we pause, each of these three are important. To which I added a fourth prong to it by saying there must be a procedural guarantee against the abuse of such interference. The concerns was that the privacy invasion doesn't arise only from the corporate side. The danger is also from the government side of such invasion in any regime. So the possibility of losing or your privacy or information which you may not like to share being part of a general domain information has become a challenge. If you look at the new Digital Personal Data Protection Act, we'll come to that, but which is yet to, with the rules not being framed. When the rules will be framed, the government people will say, but in the current mode, everything will happen post-June, and then it will have to be put to public domain, as I was discussing over a cup of coffee. And then how much time does it take, even if we look to, say, the latter part of the year? In many countries, it has taken time for this regime to evolve, and we are trying to bring it very quickly. Now, what the repercussions of that would be is another challenge. It is my view, which has been reflected in my judicial pronouncement. I'm not reading it out, but I'm explaining how I look at a privacy issue and how I have looked at judicially as a privacy issue, is that there must be a personal information must be of a nature coupled with the right to be forgotten with the realm of informational privacy. Why do I say this? Life is a long span, especially in today's age. People live to 80s, 90s. At some earlier part of your existence, you may do something, and many of us have done something, I think, which we would not like to share. But there was never any system by which everything was put in public domain. So today, any indiscretion also is put in a public domain without our knowledge, and sometimes at our behest, because we tend to participate in this process of giving information to everybody. I say people, telling what they're doing from the morning till the evening, then you are putting yourself in a public domain. When you put that sometimes, and at that particular ages, you may not be realizing the consequences of putting all this in public domain. In a way, privacy facilitates personal growth, allowing individuals to learn from the past mistakes and evolve. Now, this evolution process of evolving, as a human being, I think, gets affected if we tend to put everything in public domain and for an indefinite period of time. That is one of the issues which the Act seeks to address, as to what is the time period within which things will be addressed in public domain. I also believe that the hallmark of a constitutional freedom in a democracy is having the autonomy to control our lives which belong to us, and this will become impossible if everything is in public domain. People are not static. They change, grow through their lives, they evolve, they make mistakes, they achieve successes, they achieve failures. And if we look to the inherent right that flows from the right of privacy, the right in a modern age such as the one we are facing now, the commercial exploitation of one's identity and personal information, controlling online presentation and dissemination of personal information for specific purposes, is an important shield. So on one hand, we want to send this, open up the privacy issue by letting a commercial exploitation of what we want to do. So there are different kind of fields now today operating. People help in forming opinions and other things. Yet there are some things which we want to retain to our personal distinct, and I think that discretion must be left to the individual. So there are different kind of, I would say, boundaries in respect of different relationships, and privacy assists in preventing awkward social situations and reducing social friction. This is part of what I've written. And there is, I feel, no justification for making all truthful information available to the public. The public doesn't have an inherent interest in knowing what the other person is doing, though today everybody has walked into somebody else's drawing room, if I may say, even the bedroom, in the way things are being done. But this preservation becomes all the more important. This right of privacy and right to be forgotten, if you look at it, India has been a pioneer. The European Union regulations sought to provide for it, but before they could provide for it and make it implementable, the Indian courts had taken cognizance of it and then taken action on it. If we look to the Act of the Data Protection, it deals with the various aspects. It deals with the fairness and transparency. It is to be accompanied by data to a notice given to data principals. If you look at the scheme of the Act, the purpose of limitation of personal data to be collected is one of the crucial aspects to my mind, which links with the aspect which I was emphasizing, with the right to be forgotten. Data minimization is another aspect. Accuracy of data is the third aspect. And the storage limitation, along with the integrity and confidentiality. Now, it provides for very, very high levels of penalty for violations. Whether how far it will work, I'm not too sure as yet. Because this balancing act between what the public, what should be in public domain and what should not be, will take time to iron out. My own impression is that this regime will take a couple of years to settle down. And therefore, how it is managed and who will manage it is a very important aspect of it. Recently, I was, a couple of days back, just reading a newspaper, and it reported some cases which I think are very good examples of how things can go wrong and how this problem arises. So we had a Madras High Court judgment where a single judge ruled against and division bench ruled in favor. It arose out of a man who approached the Madras High Court that a personal information, including details of his family, remain unredacted, despite his having obtained equitable in whatever he was held at that time. So it's a continuing information. Similarly, in Karnataka, there was a case where they said that somebody was not even charged, but an allegation was made by a neighbor, the daughter, and ultimately what was found was they were in a consensual arrangement or relationship, and even a charge sheet was not filed. Yet that information remained in public domain. Similarly, are other cases where somebody was charged with NDPS Act, and ultimately nothing was found and proved. And the examples given was that the consequences was that if somebody was, say, wanting to apply for an Australian visa, they said he was denied a visa on the basis of this information. Somebody must have gone and searched from the embassy checking process. Now, these are very, to my mind, problematic issues which are coming up. Redaction of court proceeding is, from a judicial point of view, is arising more and more in these cases and will continue to, I think, arise. Because one is in matrimonial matters, other is in sensitive cases like allegation of sexual aspects. So there were also a case of Me Too. Somebody said after many years, and ultimately it was found that there was nothing which was there. But it remained as an example of Me Too among the other Me Too examples which were there. Now, how ultimately these challenges will be dealt with by technology, I think is a great challenge. How these data will be protected, how this act will work out. For somebody of a different generation and a different ilk, who has grown up without a TV being in existence as an instrument, I look back to my childhood and think that things are very, very simple. How to bring up your children is going to be a challenge, is a challenge already. How you cannot deny them information, but how to manage the information is a challenge. I have seen children handle mobiles more simply than be able to speak. So I have a grandchild who's 2 years old, and I see him being deprived of a mobile, but he knows how to put on the music in this. And I wonder that, his ability are more than mine at 2 years, because this generation now is growing up with technology. And I really want to flag the issue for the sake that I think though technology, AI, all these are very important issues, the human race faces many challenges out of it. And these are challenges of mind which is going to take place. And how we deal with it, how we control with them, how the data regime will deal with it is going to be a very important issue. Thank you for giving me the opportunity to be here.
Thank you very much, sir. Our deepest gratitude to you for illuminating the intricacies of India's data protection landscape. And may I now request Ms. Pratibha Jain to present a token of appreciation to you. We are honored that Sir is also joining us for the panel discussion. Well, taking the discussion forward is our moderator, Mr. Akshay S. Nanda, Partner, Personal Data Protection and Competition Law at Saraf & Partners, whose expertise will undoubtedly enrich our understanding of this critical issue. And now welcoming our other panelists on stage, please welcome our second panelist, Mr. Adhiraj Singh, Associate General Counsel at Make My Trip. Our next panelist is Mr. Ashish Agarwal, Vice President Public Policy in NASSCOM. Please welcome the third panelist, Ms. Tamini Marva, Group Chief Legal Officer and Chief Ethics Officer at Axis Bank. Now please welcome Meenal Nasa, Senior Corporate Counsel, Corporate External and Legal Affairs at Microsoft. And last but not the least, please put your hands together for Mr. Rakesh Maheshwari, former MeitY Officer, Cyber Law and Cyber Security Division. Over to you now.
Hi, good afternoon, everyone. I think considering the paucity of time and we are right before lunch, so I'll quickly get to the questions. So I would like to start with Mr. Maheshwari, who spent about 35 years with MeitY. The Data Protection Act, which has been introduced, is largely the foundational basis, and the guiding principles of our law is similar to the other privacy legislations like the GDPR. And Justice Kaul pointed out those lawful bases, which are data minimization, storage limitation, lawfulness, fairness, and transparency. But though our law has been based on the same foundational principles, there is a different, unique approach which India has taken. So I would love to get clarity from you that what is the unique approach that India has taken which differentiates our law from other legislations like the GDPR, and what is the thought process behind this deviation?
Yeah, so thank you very much for giving me this opportunity of interacting and sharing my views. Views are personal. So as far as India is concerned, definitely at one end, there is a requirement to meet the rights which have been given to the person, to the individual, which is the right to privacy. And simultaneously, we being a growing economy, we doing a good role in a digital world, that this industry should also continue to grow. So maintaining a balance between what the rights of the individual is, vis-a-vis the ability of the industry, the ability of the government also, because the law equally applies to the government organizations unless the same have been specifically exempted under the law, to be able to do the legitimate processing of the data is what was the aim. And I mean, this is how it is a bit different vis-a-vis the other jurisdictions. So if we look at maybe the penalties, which are much, much more rationalized, we look at the way the Data Protection Board can be approached, which is a bit difficult in our scenario, and maybe creating a difference between large and small organizations. So proportionality of the responsibilities or accountability proportional to the size of the organization, the data that is being dealt, and of course the underlying principle being that it has to be informed consent, it has to be for a lawful purpose, it has to be with a clear purpose being communicated, data being stored only to the extent required, and whatever legitimate rights are expected to be met.
Sure. Thank you, sir. So coming to Ashish. So Ashish, one of the deviations which the Indian law has made from other privacy legislations is that the Indian law is a very consent-centric and a very consent-heavy legislation. You know, typical non-consent-based lawful basis that we find under the GDPR as well as the Singapore law, such as performance of a contract and legitimate interests, you know, are missing under the Indian law. So therefore, primarily for majority of the processing activities, companies need to take the consent of the individual. I would request if you would discuss that what is consent, how should the consent mechanisms be designed in a manner that consent is meaningful, informed and valid under the law. Also, what are the challenges that industry is likely to face, considering the fact that for majority of the processing operations, they would necessarily need to rely on consent?
All right, great, thanks. Since this is a room full of lawyers, so I'll probably talk more from an industry lens than use sections. But I have my act, so if you have questions, I will refer to the subsections and come through. So if you just think about it from an industry context, right? So what are these activities? So one clear discussion we are having is that there is a whole set of industry which relies on this advertising model, where you have data monetization, advertising, and you presumably don't pay a subscription fee for a service. Now that entire bit, in terms of, we have seen the jurisprudence even in Europe that contractual obligation doesn't work. Even legitimate interest is being frowned upon. So in our case, probably it will have to go down to the direction of consent, right? While people would say, and I think there is scope for it, and they should, that can we use Section 7 of legitimate use in a certain situation? A simple example being, I am a user, I don't have an account, I've logged in, I have filled up my shopping cart, I decided to get distracted, and I come back, and I want to see the shopping cart still there. Now I've consciously put the stuff in shopping cart, so is it a fit case for legitimate use? So that's one kind of scenario. A whole set of scenario for a lot of others is just making sure my transaction passed through, which is a coffee shop transaction in a physical world, or it is about largely saying that I want to do business improvement, or I want to do fraud prevention. Now, fraud prevention, whether it will pass through into legitimate use or not, I don't have a view, but service improvement or business improvement is a larger thing, which probably you need to rely on, again, on consent. So I think if I just to sum up on this question, we do have this consent, then we have legitimate use, and then we have under 17, 1 and 2 exemptions. And under 3 also, 17.3, we also have possibility of exemption under 5, which I'm presume under Section 5, which is the notice requirement, and that could be more about subclause 2 and 3 in terms of removing difficulties for certain class of, fiduciaries. So now coming to the specific challenges. See, one of the things which is problematic is that under GDPR or everywhere else, you have had this huge scope of, guidance is coming out, and you kind of then rely on that. But in our law, we don't have that provision. So I think there is technically a possibility that since this is transitioning from the IT Act, you could use some of the provisions in the IT Act to give guidance. And that is something, because there is some kind of a framework under that can be potentially utilized. So we have suggested that, but we don't know where that will head. But I think some of the other things we are hoping is that at a starting point, if you rely on the global guidances, in sense what is technical measures which need to be employed, or so on and so forth. I think we have a list of 6, 7 issues which we have taken with the government. There are certain things what is detrimental to the child. I think that again is something that is coming up as an area of a challenge. And just to conclude, I think because my journey in this has been for 6 years working on this law, I think a lot of the things which could have been a problem on day zero problem in terms of how do we deal with existing processing, how do we deal with cross-border data flows, I think those big red flags are gone. And the preamble of the law actually says the objective is to protect the data, but also to enable its processing for lawful purposes. And that is something that we will need to say. I'm sorry, because there's so much to say, but I think just if you look at the board, a lot will also rely on the capability of that board itself, because the last thing you want is that there is a problem and day one you get a penalty. I think what you want for the initial months and maybe a year or so is board saying take remedial action. And that gives guidance not only that firm which needs to take that action, but serves as some kind of a evolving jurisprudence on what is that we are actually expected to do. And I think a lot will ride on that, but I'll pause.
Well, do you anticipate that the rules are going to bring in a lot of clarity and certainty regarding the various compliances to be made?
So to be honest, I think this law treats the firms as very mature, right? So you literally can't have a thought process that, oh, I have a checklist and I've done A, B, C, D, and now I am compliant and I don't have legal risk. I think that's not the way this law is designed. So from that point of view, even from the rules, probably you will get some clarity which will be beneficial, but you wouldn't get all the clarity that industry is hoping or expecting. I think we will need to go down that route of doing the right thing. And I think largely from a consumer point of view, there are a lot of things which are actually good. And I think it's also an opportunity for industry to say that, can we turn this around into a tactical advantage? Rather than fighting this battle only, saying that, okay, we are privacy first. We are taking consent. We will do this notification to you. And this could just be a disruptive way of saying that, somewhere creating a brand and a market for ourselves rather than necessarily fighting all the battle. Yeah.
Thank you, Ashish. Now over to Damini. So Damini, how are the banks assessing the potential impact of this legislation? Do you anticipate any specific areas of concern or significant changes to your current data handling practices?
Thank you for giving me this opportunity to be here. And maybe I'll take up the question not just for banks firstly, but for all entities that process data, data fiduciaries who will be processing data. And to that extent, I think the upcoming legislation is going to be transformative in terms of how we have been dealing with data, all data fiduciaries. It puts the focus on data fiduciaries to provide the basic frameworks and safeguards for data privacy to data principals. Focus is going to be on data fiduciaries across all sectors, not only limited to banks. So with that, maybe if I move on, and again, I think the principles apply across in all industries, not just to banks, where currently we are all in project implementation phase because the upcoming regime requires extensive assessment of what is the data architecture, where is the data coming in from, where is the data going out, and what are we doing with the data. And there needs to be a very good understanding of the data architecture to then be able to get into the consent process and then get into the ongoing compliance process. The two things I think which are focus areas right now, and we'll see how they evolve, is clearly around the rights of data principles, which have now been codified very clearly under the Act, and the right of information, that one right that they have now. They can come and seek information on what data of theirs is with the data fiduciary, how is it being processed, and with whom is it being shared. It's a codified right, and therefore now if there is a data principal who comes and asks for that information, that will need to be responded. To get to that, you have to have a very clear data architecture and how the data is flowing in, flowing out, and what is being done with the data. So it's very important, I think, for all data fiduciaries to be in that project mode right now to assess where they are. I think the second we've all talked about is the right to seek withdrawal of data and right of erasure. And this again becomes a focus area because these are rights that needed to be codified for a long time in our legislation, which is a very welcome step. But also the regulatory interplay that will be there in, for example, there's the PMLA laws or the KYC requirements where data needs to be retained for a particular period of time. So while there is a right of erasure, there is also other regulatory or statutory directives which require data to be maintained for a particular period of time, and how will that interplay play out, and a good understanding of also, therefore, within different sectors, what are the different regulatory interfaces. So I'll just pause with that for now. Yeah, but lots to do.
Yeah, thank you, Damini. Over to Adhiraj, similar question. See, as a technology platform which competes on a global basis that processes a considerable amount of data and shares personal data with several third parties, which can include your hotels and airlines. And since you've already made a lot of effort in complying with the GDPR and the CCPA, what challenges do you anticipate in complying with the Indian DPDPA?
Thanks, Akshay. Let me just preface it by thanking everyone for the opportunity to speak here. And thank you, Justice Kaul, for your very informative remarks to open this. The challenges I see will not be technical or in their implementation because, as you rightly said, we already have experience of GDPR, we have experience of the California Data Protection Law, UK, Thailand. So many countries have come up in the last few years with their own data protection strategies. And there is enough and more knowledge which is available out there on how to implement all of this. But as Mr. Rakesh rightly put it, I think the challenge will be in how the Indian regulator looks at it, how much time it affords companies to implement this, and as rightly already put, what are the sort of penalties that get applied on companies, at least in the commencement, because the process and the paths to full compliance is not easy. And personally, I'm not aware of any company in the world which can today stand up and say they are fully compliant with any privacy law. The way all big companies are structured, the number of processes they have, the number of products they have, the quantity of personal data that they process, the number of new initiatives that are always in pipeline, in sandboxes, and even, and this is a real example, the number of new CVs that they get every day, the number of new employees, vendors sending across personal information to thousands of employees in a company is too much for any company to be able to track and say with 100% accuracy and certainty that they comply with all privacy laws. It is always a process, it is a continuous struggle of the information technology team, of the privacy officer, of the legal team, driven by the CEO and the top management to try and do as much as you possibly can to cover as much information as you possibly can, as well as you possibly can. So I think the number one challenge will just for the regulator and the board to understand that, and like and I have no reason to believe India will be different. In Europe, we had a very good experience working with regulators because they understood this and they were more than willing to help companies to answer questions, to give guidances, and where necessary to pardon small mistakes and just to advise them to put in place better processes. So if we could get similar support in India, I think India will also, the Indian companies should not find it too difficult to implement this and to give its customers and the Indian citizens the privacy rights they truly deserve.
Well, so the DPDPA is definitely going to create significant challenges for companies in their compliance efforts. But, you know, there is another perspective. Some may look at compliance with the privacy law as an impediment, as a hindrance to business. But there's another perspective that in today's data-driven economy, privacy protection, data protection, complying with the laws can actually emerge as a competitive differentiator for players in the tech space. So my question to Meenal is, so Meenal, do you think that privacy can become an important non-price parameter of competition in this digital economy, which sets one's products differentiate from the other? And how can companies use the DPDPA to help, in fact, grow their business rather than seeing it as an obstacle or as an impediment in their business operations?
So first of all, thanks, Akshay, for inviting me and giving me the opportunity to speak on this significant legislation. I think more than anything else, privacy is a fundamental human right. And all organizations should do their very best to protect this right of the consumers and the users of their products and services. So I don't see the DPDPA law as an obstacle or as a competitive advantage. I think, you know, if you comply with the law, obviously you gain the trust and confidence of your consumers, and that's just a byproduct. So yeah, I definitely don't see, and if you're not complying with the law, then you will face reputational damage. So yeah, I think companies, the central focus of companies should be to, you know, uphold the rights and, you know, give the data principles, you know, honor their rights and, you know, their data privacy preferences, you know, giving them control and, you know, empowering them with control over their data so that they can manage their data privacy preferences, being transparent with them, you know, telling them about, their rights to delete or rectify the data, being accountable. And I think complying with the law just is accountability, and it's the gaining the confidence of the customers, the regulators, is just a byproduct.
And I think gaining customer trust is critically important in today's digital era. Yes, Ashish.
So, just to take from your point, right? See, when you're taking consent, and consent is a requirement and you have to do it. Now, how do you do it? So, for example, now there's a detailed guidance from EDPP on dark patterns on taking consent. And we ourselves under the Ministry of Consumer Affairs have generally come up with dark pattern guidelines. So I think initially industry, how it starts its practices will set the ball rolling on this. So can we avoid these dark patterns, and can that become a baseline? I think those are some of the things which could be relevant.
Coming to Mr. Maheshwari, so how the law has been structured is, on one hand, you have these significant compliances of data fiduciaries, and on the other hand, there are these several rights which have been given to the data principles. So could you talk about what are the rights given, and how would these rights collectively, protect the freedom and interest of the individuals in today's digital era?
So, in fact, the whole law is primarily because of the rights which have been conferred to the individual. And the first right, therefore, is to be informed about the consent which is being taken in the language which the user understands. It has to be simple. It has to be understood, hopefully, and therefore, the way today's privacy policy is presented versus the way, once the law comes into force, the consent notice is to be presented, hopefully should undergo a change, should become much, much more simple in the language, clearly communicating the purpose, the duration. So that's the first. And in any case, once you have given it, you at any given time have the right to know as to what information has been shared, with whom it has been further shared by the company entity, which is the data fiduciary. In case you are looking for some correction, updation of this information, yes, that will also be possible. You are looking for erasure of this data, so right to be forgotten, the way it is actually required in the, in the real world is a bit different than the way right to be erasure, which has been envisaged in the Act. But as a user, whatever information, whatever personal data you have shared with the company, you will have the right to get it erased as well. And lastly, the right to nominate. So in case you are looking for maybe that after your death, who should be able to handle your personal data, even that right is there. I hope I have already covered the right to seek grievance redressal. So that also is inbuilt. So in a way, all these rights are giving enough of opportunity for every person to be able to exercise the right of freedom of speech and expression. And as soon as I say right to freedom of speech and expression, 19(2) always comes along. And that's where, in certain cases, these rights will no longer be valid. Maybe it is disaster, maybe it is national security issue, sovereignty, integrity issue, or maybe it's a criminal investigation where such rights will take a backseat.
So I just wanted to take a lead from there, and the right to nomination that you talked about was one of the most interesting rights that I read about. And taking a lead from what Justice Kishan Kaul opened with, the continuing data remaining in the public space on Google, and what the right to nomination does, even after there's a demise, and if you've nominated somebody to deal with your data, and that data is there, which should not have been there, for the examples that we already heard about, the nominee can actually exercise that right and have the data purged. So I think that was one of the most interesting rights that I was following. Yes.
So Damini, considering the number of compliances which need to be made, I think it is very critical to actually create a culture of privacy within the organization. And Damni, if you could provide us some inputs that how does one go about creating a culture of privacy within the organization? What is the role of leadership as far as creating a privacy-centric organization is concerned?
So I think leadership should take the front. It should take this on a front footing to set the culture right, because it's important that this comes from the leadership and then it percolates down to the organization. And we will see the journeys and different organizations, how they shape up to, complying with the data privacy, really depending on how the culture shapes up. Because it is one thing to say that, yes, we will have the processes and policies, put on paper, but the other thing to say, how is the organization and every individual in the organization really taking care of and ensuring that privacy is the center stone of their thought process. They come in and they're thinking privacy. When they're dealing with data, they're dealing privacy. But I wanted to go a step forward and say it's not just the organization or within the organization. The clear role that has been demarcated for data fiduciaries and data processors. And it will not be enough to have a culture within the organization or within the data fiduciary to say that, yes, we are going to be thinking data privacy. We have to extend this to the data processors, because if we are going to have to comply with the privacy regime in totality, it is very important where the data is going, where the data is being processed. Is there a culture of ensuring privacy in those organizations? So I think the collaboration, the bridge, the conversations, and therefore the seamless culture spanning out from the data fiduciary all the way to the data processor is a very important milestone to be achieved.
And I think when it comes to data processors, there's a higher risk under the DPDPA because, unlike under the GDPR, where there's still penalties can be levied on a data processor, under the Indian law, it is only a data fiduciary which can be held liable. So therefore, there's a higher risk of, so even if there's a breach at the end because of the negligence of a third-party data processor, it is the data fiduciary which will be penalized under the law. Also, Damni, just another point. So in order to comply with this law, there needs to be coordination between various departments of the organization, the IT, the legal, the privacy office, the HR, business, marketing. So how do you get everybody together with a common vision, and what can you do to ensure that there is effective coordination across the various departments, and at the end of the day, it doesn't become the responsibility of just one department?
I think a very good point that you bring up, because that's really going to be the heart of how organizations comply. It's a pain point, but cross-functional departmental integration is very important. And I'll just take an example of breach notification, which is again a new theme. As far as breach notification to data principles is concerned, it's a new theme. Breach notification to regulators and regulatory bodies has been there already in our regime. And if there is going to be a breach, and depending on how the rules play out in terms of how much time there is available to make that notification, the coordination will have to be seamless. Has the breach occurred? What is the nature of the breach? Does it need to be notified? What is the impact of the breach? And therefore, what we are talking about from the product team, IT team, the legal team, and also the marketing team, because impact of breach is going to be significant. And if there is going to be then conversation in social media, how do you react and with what do you react? So yes, cross-functional department integration, not just at project phase, but an ongoing phase will be very important.
We keep discussing rules are weighted. But Meena, is there anything that companies can do today to initiate their journey of compliance with the DPDPA, or we need to wait for the rules to actually?
I think while we are waiting for the rules to get the full picture and, to completely assess the full impact of the law, I think companies should definitely start preparing and take the first steps towards compliance with the DPDP law. I think one of the first things that they need to start doing is first of all do an impact analysis, identifying the gaps and the risks between their current data practices vis-a-vis the compliance requirement under the law. And data mapping can be done through identifying what type of data they're processing. Are they processing sensitive data, non-sensitive data, identifying the data flow, what are their business arrangement with vendors, third parties, who's identifying the data fiduciary, who's the data controller, who are their data subjects, what is the purpose of the data. And I think once you have a well-documented data map and data flow, you will be all set to comply with various requirements, whether it is consent mechanism, whether it is once you have a data flow map in place, you'll know, you'll be able to establish accountability. You will be better prepared for your data breach response. And another thing I think companies should start doing is that revisit their data protection policies, update them with compliance with laws, and what are their data retention policies. If they need new policies like data portability, data breach response, and start training and educating, their staff members on the risks and the compliance requirements. And establish a process for monitoring and auditing, the compliance requirements. I think these are the few steps that they should start with.
No, I agree. And at the end of the day, it's the data mapping exercise. Unless you don't know what data you're processing, what are the various source points, you cannot really comply with the law. Now, compliance, the biggest issue, I think, for the industry is that what is the timeline which is going to be provided for compliance? And I will put this question to Ashish, because NASSCOM has been advocating that the law should be implemented in a staggered manner so that to ensure business continuity. So based on what we've heard from the government regarding the timelines, do you think the timelines are adequate to comply with the law, considering that the Indian DPDPA has been made much less prescriptive as compared to the GDPR?
So to be honest, industry can always use more time. But I think we are already in end of March, and to be honest, a lot of the hard work of data mapping and determining the existing legal basis and mapping it to the legal basis in the law, that doesn't really require the rules to a large extent. And I think that exercise is time-taking exercise. So I think you have at least till June, July before the rules to do that, and it will not be sufficient for everybody because there's no one size fits all. I think at a somewhat mental level, the way we break it down is in two ways. One is people who have extensive GDPR experience already, and people who don't. And then another is, what's your business model? Is it B2C, B2B2C, or B2B? So I think then you find that people fit in various boxes, and they are on that journey. The tech industry largely is digital, so I think they are in a relatively better position. Even if they have not necessarily have customers in Europe and all of that, they might have just been providing tech solutions to the larger world. So in that sense also they're a little more aware of, so their journey in that sense will be relatively easier. On the whole, I think once the rules come in, we are already seeing, as even Justice Kaul said, I think this is going to be at least after June, maybe at least one more year of settling down. And then I think learning by doing. So I think there is a broader alignment that as much as this is a data protection law, it is also a signal to the world that for 30 odd years, we have reached a stage where we are processing data of 150 countries without a data protection law with the SPDI rules in IT Act. And this is something which should enhance that trust and not kind of make it uncertain and all of that. So I think given that as a context, I think if there is a need for more timeline, I think there is scope for exemptions and removal of difficulty and all of that. So we'll see all of that come in play if and when needed. Yeah.
So I would like to put this question to Mr. Maheshwari as well. Do you think the current timelines which are being proposed are adequate? Because, when the GDPR and other laws came, companies were given a period of almost 2 years to comply with the law. And they already had a legislation directive for the last 30 years. So considering that this is something new.
So first of all, no formal timelines have been proposed. Point number one. Point number two, as mentioned by Mr. Ashish, that for good number of activities, don't wait for the rules to come. They're already clear in the law. And therefore, the actionables can be initiated without waiting for the formal rules to be published. Having said so, going by the experience of the other countries, one, the rules may not get formally published before maybe August, because there is a process involved. And then as a bare minimum, ideally you have to have a time of another 6 months. But as I mentioned, don't wait for all that period. I also believe, as has been mentioned by Justice Kaul also, that in the initial time, because a lot of clarity, a lot of confusion, and a lot of, I'll say, guidance which needs to be given to the industry rather than going in for the punitive action. So I do believe there will be a reasonable window. I mean, there is a reasonable window, but I also simultaneously will like to convey, assert that the action must begin. You must start working, I mean, or if you are helping, if you are providing consulting support, legal support, you must start advising to your clients to start working on implementation of this law as soon as possible.
Thank you, sir. So today, Indian businesses are competing on a global scale. And the challenge is that you not only need to comply with the Indian data privacy law, but you need to comply with the privacy laws of all those other jurisdictions as well. So Adhiraj, this is something that you have been doing. So what guidance can you give us on how to traverse these different laws of different jurisdictions, having their own nuances?
Sure. Before I answer that specifically, let me just touch upon something that was already mentioned, and that is on culture and privacy becoming a competitive advantage. And let me just draw a poor parallel as that might be with, say, vehicle safety. So one of the first things I ever worked with was on an internship where I had to work on an imported car. I was, in association with Mr. Saraf's office only at that time, when I was a very young intern. And I still remember at that time when we had finalized everything and the imported car came, it came with the hook of a seatbelt. Because the point of that was because no one in India was used to wearing a seatbelt, but the car would beep if the seatbelt of the driver was not inserted. So they used to give that buckle which you could just put inside over there. And recently I was talking to a colleague and asking him how he decided between two vehicles. And he said that one of the vehicles didn't have a sturdy enough roll cage, so he was scared about accidents on the highway, and therefore he bought a Tata vehicle in the end. And that just shows that, when the law started, there was always a requirement for Indian cars to have seat belts. Then there came a law, tried its best to pull people up. But once the law was a starting point, when people became educated about what this implies and how it will affect their daily lives, and when customers started asking brands for more, then brands also started responding. Then you had started having questions like, does my car have 8 airbags or not? Does it have 5 seat belts? Does it have a roll cage? What all safety features does it have? And I think privacy will go the similar way. Once people start actually reading what is there before they're saying, I accept, once they start actually looking and differentiating between brands based on how their personal information is used by the brands, you will see this discussion evolve far beyond what the basic law requires. That said, coming to the point you said, I don't think the challenges are insurmountable, and as everyone has said, we know what the law is. It is quite clear. We've implemented it in various jurisdictions, and it is not as much a legal point as it is a point of technology and making sure that technology develops to a stage where all customers can be given the right to track and control their personal data by themselves. The end point of this is not a brand handling personal information. The end point of this from a technology perspective is actually taking all the power and giving it back to the customer so that the customer sitting over there on his app or on his computer can decide and say, okay, brand, I'm going to take away this piece of information. Please delete this information. Show me at a click of button who all you have shared this information with. And at the click of a button, I can exercise every single right which the law gives. No other solution is feasible, and that is pretty much the only learning which you get after you implement it in 3 or 4 places, that end-to-end technology solution is required for an end-to-end digital personal data protection.
And as Meenal pointed out, it all boils down to your data mapping exercise. You need to know what data you're collecting, how the data is flowing in, who all the data is going to, because the entire compliance effort ultimately rests on that. So we still, time's up. Can we still have a couple of questions in case? Yes, Weber.
Thank you to all the panelists. I just had a question for the panelists, Mr. Maheshwari, Ashish in particular, and Damni, Meenal as well. One of India's government's objective is to facilitate the growth of Startup India. and Digital India and Startup India are very important objectives that the government has. At the same time, it is also important to respect the right of privacy, as Justice Kaul had laid down in his judgment of Puttuswamy. And the entire DPDP law is premised on that. But the statute also has significant onerous penalties. I'm very glad to hear that the panelists feel that the law is rather quite clear. But for instance, I've had discussions with Akshay about informed consent and parental consent, that it itself is a very tricky area. And with such significant penalties under the law, do you believe that practically, while promoting Startup India and Digital India, which will grow on the back of digital growth, data growth, do you believe there'll end up being a differentiated regime between tech companies, the big tech companies, and the Startup India? Do you think the government is likely to play a slightly more, I would say, a balming effect to the Startup India? Because we're seeing something similar happen in the competition sphere, where you're suddenly seeing a differentiated regime playing out for the big tech companies, where they are seen as more consumptions of large data, and the issues of abuse are played out much more onerously, as opposed to the Startup India.
Maybe if I can quickly convey, from a legal accountability perspective, the amount of compliance, starting from the consent notice and consent framework to maybe grievance redressal, or maybe to I'll say take care of the eraser request. There are exemptions which have been given to the startups. The word startup has already been mentioned. The intent is all such small companies. Now that is something which will get clarified in the rules as to who comes within that scope. But I mean, now that's a guess which you will have to take. So if you are fitting within the definition of a startup, you can right on day one assume that these exemptions are there. If you are maybe into the large kind of categories, which tech companies, large tech companies will be, you can always believe that you are always in that area. Banks hopefully will be in that particular area of the significant data fiduciary. So in many of the scenarios, the distinction will be clear, or distinction is clear even without waiting for the law. But definitely one expectation which is clearly there is that whether you are small or large, you must be aware as to what personal data are you processing, and the security of this personal data is your responsibility.
Sure. Thank you, sir. Justice Kaul, can you have one last word?
Yeah. To my mind, one of the most important things that everybody's touched, and I think it happens in India, is the composition of the board. The board must adopt a legislative-friendly approach, what I call, which means look to the intent of the legislation, look to the privacy issue, look to how it is to be done, and a friendly approach to iron out things. My only concern is what is going to be the composition of the board. It should not become a tyrannical aspect, as sometimes happens, and that will depend on who mans the board. If you have people who are experts, who are of the field, I think there will be no problem. If you only make it a haven for some categories of retired people, I think there will be a problem.
Thank you, Justice Kaul. Thank you, panelists. Thank you for taking our time today. Thank you, everyone.
Thank you, everyone. I request Mr. Akshay to present a token of appreciation to the esteemed panelists. Thank you, everyone. As we approach the midday mark, I invite you to enjoy a lunch break. This is a perfect opportunity to network, reflect on the morning's discussions, and rejuvenate for the insightful sessions ahead. Please ensure you rejoin us promptly at 2 p.m. as we have much more in store for you. In the meantime, do not hesitate to share your experiences, thoughts, and those invaluable networking moments on social media using a hashtag ABA India Conference 2024. I would also like to request everyone to visit the V4Her standee place outside and scan the QR code to register for the pro bono work and join the community. Please keep the conversation vibrant and engaging both offline and online. Enjoy your lunch, and we look forward to welcoming all of you back for an equally enlightening afternoon. Welcome back, ladies and gentlemen, and to those joining us virtually as we delve into the afternoon sessions. Well, our next focus is a critical aspect of the legal landscape themed cross-border arbitration post-M&A and stakeholder disputes, a session designed to navigate the complexities and common pitfalls of cross-border mergers and acquisitions enriched by real-world insights. We are privileged to commence with a special address by Honorable Justice Jasmeet Singh, Judge of the Delhi High Court, whose expertise on the subject is unparalleled. Please put your hands together for Honorable Justice Jasmeet Singh.
Distinguished guests, ladies and gentlemen, good afternoon. It's indeed a privilege and a pleasure to be here and to address this esteemed gathering. I'm deeply honored to address this gathering today on the topic of immense significance in the realm of corporate law. In a globalized world where businesses transcend geographical boundaries, it becomes imperative to have strong mechanisms for dispute resolution, especially in the complex domain of mergers and acquisitions. India's involvement in M&A activities had a remarkable start this year, jumping 78% in deal value, reaching to $6.3 billion. As companies seek to expand their reach and consolidate their market position through strategic mergers and acquisitions, they inevitably encounter a host of potential disputes and challenges, including pre-closing disputes, post-closing disputes such as price adjustments, indemnification, many of which span multiple jurisdictions. The same is also true for the multifaceted landscape of shareholders' disputes, particularly from the perspective of Indian law, ranging from breaches, representation, warranties to disagreements over valuation, earn-out provisions, exit rights of investors, and mismanagement. These disputes, if left unaddressed, can potentially derail the harmony and progress of a company, affecting not only its stakeholders, but also the broader economy. In India, dispute arising from mergers, acquisition, and shareholders' dispute find redressal primarily through statutory remedies provided under the Companies Act 2013. It empowers NCLT to adjudicate claims of oppression and mismanagement. It also introduces class action proceedings, allowing members to initiate collective action against companies for violation of law or breach of fiduciary duties. Additionally, we have the Competition Act 2002, which safeguards market from anti-competitive practices, including that of abuse of dominant position. However, with respect to disputes ranging across borders and the unique nature of mergers and acquisitions, arbitration has gained significant traction. As per finding of CMS European M&A Study 2022, which provides insight into M&A market and the utilization of arbitration for resolving conflicts arising from M&A transactions, there has been a notable development in arbitration across Europe for M&A disputes, citing that despite a marginal decrease of 1% observed in 2021, previous years witness a consistent upward trend in the inclusion of arbitration clauses. Over the past 11 years, from 2010 to 2020, during which arbitration usage averaged 33%, its current popularity as a method of settling dispute remains closely aligned with its long-term appeal. The same is true since arbitration provides for a neutral forum for dispute settlement. This is particularly valuable in cross-border M&A deals where parties come from different judicial systems. By providing an impartial forum for dispute resolution, arbitration enables parties to avoid potential biases in foreign court systems. Secondly, confidentiality is invaluable in M&A transactions which involve sensitive information, trade secrets, and arbitration provides greater privacy and anonymity compared to litigation processes thereby safeguarding the reputation of the parties involved. Thirdly, arbitration offers flexibility, resulting in more efficient and cost-effective dispute resolution. Parties have the autonomy to select arbitrators with expertise in M&A transactions or industry-specific, ensuring that resolution process is relevant and expedient. Following the current needs and trends, we have about 35 arbitral institutions in India, varying from DIAC to Nani Palkiwala Arbitration Center to the International Arbitration and Mediation Center at Hyderabad. In fact, DIAC in 2023 had 9,707 arbitrations listed, which according to me is a considerable increase over the last couple of years. We had the DIAC week, I think about 2 weeks ago, which was a resounding success and had representatives from all over the world. The competitive nature and international and domestic market demands that all arbitral tribunals to continue to demonstrate their reliability as effective and competent platforms for resolving disputes. It is also relevant to mention that in the realm of damages, valuation methodologies play a crucial role in quantifying damages, with heavy reliance on expert opinions and market practices to determine fair compensation. Expert determination, while not as widely recognized as arbitration, plays a crucial role in facilitating quick decision-making, particularly in the context of M&A transactions and technical sectors such as construction and natural resources. However, unlike arbitration, expert determination operates outside the realm of legislation. It is not governed by the same legal system as the arbitration, nor is it characterized as an arbitration under the New York Convention, which in turn means that expert determinations are not enforceable as awards under the domestic arbitration law. Instead, expert determination relies on consensual agreements between the parties involved. Nonetheless, as we navigate the complexities of M&A transactions and various shareholders' dispute, it is essential to recognize the potential of expert determination, if not in terms of individual enforceable proceedings, but definitely as a supplement to arbitration proceedings. Additionally, one can also observe the dynamism of international arbitration and how there is continual growth and development in the concepts prevalent in arbitration, especially in the cases of corporate governance and shareholder disputes, where time is often the essence. In this background, the concept of emergency arbitration emerges as a beacon of swift resolution, and the notable case of Amazon versus Future, which has only strengthened the pro-arbitration stance of the judicial system. Therefore, like any legal mechanism, arbitration requires a robust framework and supportive judicial system to function effectively. The courts in its pursuit have taken many proactive measures to streamline and improve the efficiency of commercial arbitration in India. In Delhi High Court, we have the commercial arbitration, we have the commercial division, as well as the same in the district court, which deals with commercial disputes, and arbitration cases also go to the commercial division. The idea behind this is to ensure speedy disposal of arbitration matters. The landmark judgment of Vidya Drolia shed lights on the nuanced approach adopted in determining of the arbitrability of O&M disputes. These decisions highlight the importance of upholding the sanctity of arbitration agreement while ensuring that statutory remedies are not circumvented. Therefore, the road paved for cross-border arbitration in M&A and shareholder dispute is certainly much smoother and continues to be laid down in a manner that promotes sustainable growth and prosperity for all stakeholders involved. It is hoped that cross-border arbitrations can continue to showcase a collective commitment to upholding the highest standards of integrity, professionalism, and ethical conduct. By adhering to these principles, the international commercial sector can not only navigate the complexities of cross-border transactions more effectively, but also contribute to the overall stability and success of the global business environment. Thank you and congratulations for hosting this wonderful event. Thank you.
Thank you very much, sir. And I request you to join us for the panel, please. So you can take one of the seats there on the left. Yeah. And guiding today's discussion forward are our two moderators. Please welcome Mr. Montek Mayal, partner at Osborne Partners, and Mr. Manmeet Singh, partner at Saraf and Partners. Please, can we have them on stage? And I'm very happy to welcome our esteemed panelists, other panelists. Please welcome Mr. Anthony Sinclair, senior partner at Quinn Emanuel. Now please welcome Mr. Rajat Rana, partner at Selendi Gay. And last but not the least, please welcome on stage Mr. Srinivasan Narayanan, managing partner, KNL Gates. And over to the moderators now.
Good afternoon, everyone. It's indeed a pleasure to be here today. I must confess, after the special address, my job is made much easier. You've set absolutely the perfect context to take this discussion forward. Very, very simply, our panel today is sort of divided into two broad parts. The first part will focus on the key trends that we are seeing in M&A disputes, the type of disputes that are coming across in that context, and what possible remedies and forums are available to parties that find themselves in such disputes. That part will be moderated by me. The second part will focus on key quantum damages and valuation issues that come up in those disputes, building on what we discussed in the first part of the session. Unsurprisingly, the time is not enough to cover all the topics in detail, but we hope to give you some flavor of the issues that come up in this context. So without wasting any further time, I'll get straight to the questions for today, the first part on the trends and remedies. And what I intend to do here is just go through the panel and get their views on what the key trends are in the M&A disputes context. So perhaps I'm going to start with you, Srini, first.
Thank you. Okay, as a disputes lawyer, we deal with the problem at the end of the day. The problem's origin is at the beginning. So I just want to highlight two things that people should bear in mind. The arbitrability of a matter in a shareholder dispute or M&A is a matter where the law which is different in the different seats. The law in India has evolved. In Singapore, we have Mittal and Westbridge, and in UK, you have Fulham Football Club, etc. Why do I start with this? When transactional lawyers draft documents, they spend a lot of time on the terms of the document. They spend a lot of time debating what should be the governing law of the contract. They choose the seat, so you get the law of the seat. And so often we have cases where the governing law of the arbitration agreement has to be discerned by various means. Nobody sits down and thinks about it. And yet it becomes the most important factor in what your remedies are. So in the Singapore decision of Mittal and Westbridge, the Singapore Court of Appeal actually said there's a double test. The arbitrability will be decided by the governing law of the arbitration agreement, not the contract, and the governing law of the seat. So the first thing I'm going to point out is those who are drafting agreements find out whether the reliefs you want, are they capable of being achieved, what are the limitations, and it is not a matter for disputes lawyers. The second point I would make is the relief you want. So very often again, we have this argument about subject matter. Subject matter, operation and management, does it go under the Companies Act, or is it a matter for shareholders' dispute? Actually, the nature of the dispute does not determine what you can or cannot get in an arbitration. It's the nature of the relief. You can't get a winding up in arbitration. The Indian courts have been very clear. You can't affect third-party rights. You can't affect in-rem matters. But again, whoever is drafting the transactional document needs to know what does your client really need in terms of the relief, and then you see whether that relief can be structured and built into the agreement that you're drafting. As a disputes lawyer, I hope you don't take my advice, because well-drafted contracts that are very clear, where everybody knows the consequences, will be the death knell. And I still got 2 more children to go to university. But as a panelist, please do take my advice. Thank you.
Thank you very much. Anthony, I come to you next. What are you seeing?
Yeah, thank you. I've been asked to comment about the types of disputes that we're seeing in the post-M&A or M&A shareholder context. And I think to start with a trite observation, it's undeniable that we are living in uncertain times. And above all, such uncertainty is generating disputes and relating to a mismatch in expectations about business values. And I think that's the overarching theme I'm seeing. First, many deals done during the pandemic were done quickly, possibly too quickly, with insufficient due diligence of the targets or even of the founder or partner on the other side. And that has generated disputes around deals that have failed, deals where fraud has been exposed subsequently, when the tide goes out, so they say, everyone can see who's been swimming naked. Since that time, there has obviously been a great boom in the M&A sector. And the sector was awash with cash, and interest rates were low. And what we're seeing now, though, is that deals that were agreed during those times of easier finance, maybe more optimistic macroeconomic conditions, now look overpriced. So following what we've now gone through, a period of heightened interest rates, greater regulatory scrutiny, I'd suggest, especially in the crypto space, stakeholder activism with regard to companies' ESG standing, probably shakier valuations in the light of such uncertainty. What we're seeing, I think especially, is buyers seeking to claw back what they feel they might have overspent by revisiting due diligence, looking at what they were really told about an issue, and exploring whether there might be claims around breach of warranty, non-disclosure, misrepresentation, and even fraud claims, as I mentioned. And stemming from these conditions, I think we're seeing buyers tenaciously pursuing indemnity claims, and also, in the same vein, taking a stingy approach to paying out on earn-out liabilities or releasing deferred consideration.
No, thank you. Perhaps I'll just highlight this point for now, and I'm sure we'll revisit later. Just because you've overpaid for something doesn't mean you can get it back. Now, coming to Raja, just building on that, I know you do a lot of work in the private equity and venture capital space, and especially with these issues around earnouts. What are your thoughts?
Thank you. I think just from the U.S. perspective, and just to set some context, in 2000, private equity only controlled 4% of U.S. equity, corporate equity. And if you see the trend in 2021, it's now 20%. So private equity has actually grown 5 times faster than the U.S. economy. And whenever a private equity deal happens, the way it works is you take a lot of debt, you want to make profit very quickly. And when interest rates are now 20 years high, things are just not going well. And I'm not saying all deals will end in calamity. Some do. And when they do, typically the disputes we are seeing now in the US, and typically you see in Delaware courts, which are the go-to courts for these disputes, are post-acquisition disputes. So you see disputes when it comes to earn-out disputes, as Anthony touched upon. We are seeing a number of those in the pharma sector. We are seeing a number of those in telecom sector. And overall, if you open any textbook these days on type of disputes in U.S., you will see retail, healthcare is notorious in U.S. right now in terms of private equity disputes. And I think the third category where we see a lot of these trends are, put options or call options, which you put in a bucket of exit disputes. Where you're trying to exit, you're trying to exercise your put or call options, and there's a dispute about it, someone not respecting the call option, valuation disputes, which Montec, loves. So I think, so this is the growing trend in the U.S., and I think the biggest challenge for all of us sitting here today is that a lot of this is public because it's private equity. And I think more and more is getting public, and especially in the U.S. courts, unlike in arbitration. So I think time will tell.
Thank you. And I think just as an interesting, just building on what the trend you mentioned, consistent with the growth versus the GDP of the US, if you look at more broadly statistics on the source of capital in developed markets, is increasingly companies are staying private more, longer, and raising private equity rather than going public for raising capital. So I think that's only going to mean further increase in private equity related disputes. Manmeet, just bringing it all home, what's happening here? What are we seeing in terms of cross-border shareholder and M&A disputes in India?
I think some of the issues raised by Anthony and Rajat are also playing out in India. The global macro environment has turned adverse. As a result, there was a sustained period where in India liquidity was also not very forthcoming. As a result, we saw valuation markdowns where obviously that's not a happy situation for investors, so they have been looking very closely at the reps and warranties and wherever they can make an indemnity claim. And also in certain situations, we've seen private equity investors get aggressive and see if they can change the management. In some cases, that successfully happened. In some cases, there are attempts being made. Let's see how some of those play out. But we are seeing investors get aggressive with enforcing their rights, making claims. So particularly in the startup space, there has also been, allegations of revenue inflation. There have been allegations of receivables not actually being recoverable. So those kind of issues are also getting played out now.
Thank you. Don't take the mic away too far. I'm coming back to you next. I think just kind of summarizing this part, and I just want to build on something Anthony said. Perhaps it's human greed, perhaps it's something else. But in periods of crisis, you tend to have more claims of fraud, corruption, diversion of capital, partly because people are under pressure to inflate their books and get a better price. And I think that, frankly, has also caused a lot of pain and disputes. Pain for everybody, perhaps in the room and the clients, but a lot of billables for the people on the panel. But it's been a consistent source of claims in the last few years. And I think that's quite consistent with what we're seeing in the private equity space, as Manmeet mentioned in India. Many of you would have known exit disputes have made headlines in India across a number of sectors, across a number of investments, not only in venture capital, but also obviously in more mature private equity investment space. Now, with that, we'll move to the second part. I think we're doing good on time. The second part of the discussion, which is the remedies that you now have access to. So when things have gone wrong, what do you do? And which is why Manmeet said, don't take the mic away too far. Coming to you straight. So things have gone wrong. Something has gone wrong. What can you do as the injured party? What can the parties do to sort of rectify or remedy the breach that's occurred?
So as Justice Singh said at the beginning, there are remedies available under the Companies Act, and of course, where there is an arbitration provision, recourse to arbitration may also be available. Now, there are judgments in India which have gone back and forth on to what extent shareholder disputes are arbitrable. As things stand, there are arguments and there are judgments to suggest an arguments which can be made to say that an oppression mismanagement dispute would not be arbitrable. Now, what constitutes an oppression mismanagement dispute, or whether it's a dressed up dispute, itself becomes a fact-specific inquiry. the Bombay High Court recently in the Anupam Mittal case was faced with a peculiar arbitration provision, in light of which it took the view that the dispute there was not arbitrable, and it was an oppression mismanagement, prima facie an oppression mismanagement dispute. But at the same time, it left it open for NCLT to consider the application under Section 45. So eventually, whether it is something which would be an oppression mismanagement dispute for which the remedy would be before NCLT is something which would be examined on facts, because if it's a dressed-up matter disguised to look at an oppression management dispute, whereas it's actually a pure contractual matter covered by the shareholders' agreement, this is something the NCLT will decide upon. So it's really about how the petition is set up, what the facts are, which will decide where the remedy would lie. Now, of course, the considerations may be that, as Justice Singh also mentioned, that if you want confidentiality, then you may want to prefer arbitration. If you want if you're not concerned about confidentiality, if the nature of remedy is such which an arbitral tribunal cannot give, because the arbitrator is a creature of contract, bound to follow the contract, NCLT's powers under 241, 242 of the Companies Act are quite wide. It can make any order in equity, including ordering buyouts, including amending the articles of association, including amending any contracts between the company and the management. So the rights and remedies would really determine what the optimal remedy should be. So in the Indian context, those would be the considerations.
Thank you. And I think one thing Justice Singh mentioned, which is so critical today, which is so much of the investment is happening on intellectual property, context of business secrets, operating details, patents, etc. And a lot of that confidential information is not something you want to share in the public forum. Now, I'm coming to Anthony and Rajat, perhaps in that order as well. So you choose your forum, whichever forum you think is best for your client and the interests that you represent. But what are the remedies that are often sought in this context? What can you seek as the injured party? And while discussing that, can you also touch upon perhaps the importance of interim relief, especially, or injunctions, especially in shareholder and joint venture disputes? Perhaps Anthony first and then Rajat.
Thank you, Montek. That's an expansive topic, and I'm sure we'd love to talk about the different types of legal claims that could be brought. But the way I'd like to focus on this first, as a litigation lawyer, is to think about first enforcement. Where is the money, and how am I going to get my client paid or get my client satisfaction? And I think it's really important to talk about self-help first. It obviously depends on what the deal lawyers have helpfully provided in the contract. But the first things we would be looking for would be whether any retention monies, for instance, have been held in escrow or are otherwise accessible for drawdown. Is there any security that has been granted in respect of such liabilities? Are there share pledges, for instance, that we can enforce? Have powers of attorney already been issued and granted to the board or put in escrow again that we can execute and enforce against the other side's shares immediately? Are there letters of credit giving security for any post-completion liabilities that we can draw upon immediately? Default notices. If there's been a breach, a breach of a representation or a warranty, it might be that there is a default notice where we can exercise a right to call or put shares or to have the other side's shares forfeited. Step-in management rights, which you've mentioned and Rajat mentioned as well, are also very important. And we've also seen private equity investors acting in their capacity both as equity holders but also as creditors, looking perhaps to circumvent a long drawn-out shareholder dispute by acting in their capacity as lender and putting a target company into administration, and that way helping to facilitate an exit for the lenders. So I think self-help issues are critical at the outset.
Thank you. Rajat?
Yeah, thanks. I think it's, as Anthony said, it's a very broad topic, but I think the type of remedies that you're thinking about, I think you have to obviously look at the forum first, and that's very critical when you look at the remedies that you're going to seek. And I'll just start with one example. Maybe it will outline the type of remedies that one could seek, and just talking about earn-out disputes, which is, for example, for those who don't know earn-out disputes, it's essentially if I buy a company from you at $50 and you think it's $100, I agree to, you say that after I buy the company, if you give me the metrics, if it shows that the company continues to perform at X level, I agree to pay you that extra amount, but I will not pay you right now at the acquisition time. And I think there's almost like a tsunami, for lack of a better word, in the U.S. on earn-out disputes. And when you run into earn-out disputes, let's say I'm the former CEO, I submit my earn-out statement, the private equity investor refuses to respect my earn-out statement, and they file an objection, and there's a dispute about whether your revenue projections, the way the company performed, is actually it's falsified or it's actually true. So the first dispute comes as the private equity investor would say, I object to all these earn-out statements, the projections you made, and we have to audit the financial statements. And they keep auditing the financial statements for months and months and months. So the forum you want to choose is like the forum that's going to compel you to go to the dispute resolution clause. So the trend we're seeing, and not only we started with the arbitrability issue, is to run to the Delaware court, which is typically the fastest right now in the United States, more than New York courts used to be, is to seek an order to compel arbitration. And then when you go into arbitration, the remedy that you're seeking is either specific performance if you want to do it, but in cases like earn-out, you don't get specific performance because as long as you can be compensated, there's no specific performance. It's very hard to do that. And then you go into, obviously, damages. And in other earn-out cases where the former management continues to be part of the new company, you see remedies where you make a claim for mismanagement on behalf of minority shareholders who are making claims for mismanagement against the company. So I think those are the biggest remedies that you typically seek. Obviously, you're seeking for your earn-out value during the dispute. So I think ultimately it depends on the forum, because I find arbitration tribunals, they're excellent when it comes to fairness issues, but I think when it comes to, you don't even come to arbitration because of some of the practicalities of the dispute, because the trigger point to go to arbitration, according to some investors, or some would say, is not there because there's no financial statement. So you have to go to the court and compel the dispute, and then you go out and outline all the remedies, specific performance or damages. I think those are two broad buckets, and you can obviously frame your claims depending on what you're seeking in a dispute.
Thank you. Actually, that's a perfect segue to the second segment now of the session, which Manmeet will take forward.
So our second segment is on quantification. Shri and Rajat, in your experience, how do you see the role of arbitrator, in a role of expert, in a shareholders' dispute? And what are the typical damage quantification issues which arise in a dispute of this nature?
So I think the typical damage would be contractual damages, depending on the law of the agreement. And the question, of course, is it's a fact-sensitive exercise. And to be fact-sensitive, you need the documents. You need the accounts. As many speakers have said, there's always an underlying layer of allegation of fraud, mismanagement, and the party claiming would, of course, say, my right to information has not been given to me, and therefore, how can I even quantify? So there are two solutions to this. One is embedded in the underlying agreement is the right to management information. that should go beyond what the Companies Act provides, especially if you don't have a seat on the board. The second is at the point in time when the arbitration is starting, the procedural rules that govern discovery is critical. You must be entitled to discovery, and you must choose arbitration rules that are discovery friendly. Because without the underlying data, the quantification, whichever basis of quantification you are taking, whether it's an expectation loss or reliance loss, it still starting point is the data. The other thing, of course, then, is there should be, when you're looking at quantification, some sort of broad understanding in the agreement. It cannot be over-engineered, as we discussed at lunchtime. It cannot foresee everything, but it must be principled so that the arbitrators and whoever are the valuation experts speak from the same hymn sheet. So if it's an exit and you're a minority, is there going to be a discount for lack of control? If it's a private company, is there going to be a discount for lack of marketability? If it's a property company, are you going to use DCF or are you going to use NAV? Now, you may think at that point, it's too early to decide all of this. But again, if it's decided early, I would suggest that actually the dispute won't even arise. Because if people can see the shape of the dispute and the way it's going to be answered, then they would not take their luck in arbitration. But if the dispute does arise, it actually makes it a lot easier. The other issue then crops up with the experts. I will later on, if you give me 2 minutes, talk about how you deal with experts. But the main thing is, when you're going to deal with experts, are they going to try to put up a joint report? In the course of the procedure, would there be hot tubbing? Would there be sequential? Would the expert evidence be taken out of sequence, meaning experts after factual witnesses? These are all the possibilities that you can look at in terms of how to ascertain what your quantified damages are going to be. I will hand over on the question of what are the possibilities of your quantified damages.
Thank you. I think that independent experts play a very important role in shareholder disputes. And just to take one example, for example, in exit disputes where you exercise your put option or call options, someone like me obviously is completely paralyzed when I think about valuation of shares. If you exercise your call option or put option 10 years ago, or 20 years ago, 30 years ago in a company that's publicly traded and there's no dispute about liability and the only issue that needs to be resolved is the quantum, the tribunal or the courts are going to look at experts, independent experts, to value shares. And the way you frame those issues in sense, how you value shares as of today when a put option was exercised 20 years ago, whether in the contract there's a mechanism to calculate the fair market value of shares when I first exercised put option in 2001. And if I were to be awarded a relief today by the tribunal, how would you calculate in those 25 years or 20 years the control premium that's on the shares? How do you calculate the dividends and basically come to the value of shares as of today? So I think it obviously is all dispute specific, but I think independent experts do play a very critical role in instances just I just mentioned just now on the exit options.
I just want to quickly just add something here, and perhaps just building on what Rajat just said. So you can think of the disputes that often arise in M&A shareholder context in three wide buckets, right? You have disputes at the entry when you're making the investment. You can have disputes at the middle when you're in the context of the actual investments being taken place and you're part of, as a shareholder, you're operating the company. And disputes at the end when you're exiting from that investment. And I think experts in that context can play sort of different roles, but the common theme is we are asked to quantify damages or valuation of the asset, right? That's the primary skill set that we bring on. And at the entry level, you have the primary question often is of valuation. So we touched upon this before, and Anthony also referred to the point about misrepresentation. The simple point is that you thought this company is worth 100. You actually realize it's only worth 50 because something was lied to you about, and therefore the difference is what you're claiming as compensation, right? So that's the skill set that often is the valuation skill set, right? So what would the value have been if this representation was false, which it ended up being, and therefore you overpaid for the asset. During the life cycle, the questions are often about fraud or breach of reserve matters that you might have in a contract. And there the question often can be of corporate finance. So the second skill set that valuers can bring in is of corporate finance skill sets. So for example, this company entered into transactions with related parties at below arm's length. So that meant the value was getting diluted in the company in which you invested. And of course, exits, the most famous examples are all over headlines. We just type in exit disputes in India, you'll get multiple Google pages. But the real question there is often, again, of valuation. So someone is exiting the company, could be a private equity investor, could be a minority investor, could be a full sale of the business. And the question really becomes is what's the value? What's the right value? One party argues it's low, other party argues it's high. And again, people like us are brought on board to testify on the valuation questions. The only other thing I would mention at the forefront, and again, this was touched upon earlier, and it's quite critical increasingly in the venture capital space, is earnouts and actual purchase price adjustments. We won't go into the details here, I'm not going to bore you, but the simple short point is, they're the questions of accounting. How do you make adjustments to the purchase price for certain aspects agreed under the shareholders agreement, for example, right? So very simply, there are three skill sets which are often important in disputes for damages questions: valuation, corporate finance skill sets, and accounting.
Thanks, Montek. Anthony, coming to you, would you like to talk about any difficult valuation issues or quantum-related issues that you've seen in your arbitrations?
Thank you. I'm just motivated to add something to what Montek just said. When one's looking at an earn-out dispute, the role of the quantum or economic expert is not just a matter of accounting. Because what very often is going to arise is a claim that the company has been managed in a certain way in order to ensure that thresholds for payment of an earn-out have not been met. And so there, again, I think the economic expert can help persuade a court or tribunal about the way in which the business has been run compared with the ordinary course. I mean, this field presents so many complex issues of quantification of loss, and I think it's really important to involve a quantum expert, especially when you might have a choice of different types of causes of action, whether breach of contract or in tort, for instance, where we know the standard of damages is different. It's important, I think, to have the quantum expert involved, and even at that stage, trying to help formulate what type of claim is best going to realize full value for your client. And that's especially, for instance, when one's looking at causation of loss. There, I think, the quantum expert can really help when you're trying to think how are you going to explain which loss is attributable to which particular breach of a warranty, for instance. And another difficult issue that often arises, and again, it depends on the cause of action that you're advancing, is to what extent hindsight information can be is relevant and can be deployed. So, for instance, the issue might be put to you that a particular threatened litigation never eventuated, a particular risk never in fact arose, or the actual costs that the buyer had to incur in dealing with an unexpected issue were not as great as anticipated. And again, use of hindsight, I think, is a complex matter requiring input both from lawyers and the quantum expert.
Rajat and Srini, adding on to what Anthony just mentioned.
Yep, I think the cause of you can claim damages for loss of chance, and this happens quite often in life. You go in, you're buying a company, there is a representation that has induced you to buy the company, And the representation is we are almost striking a deal with XYZ. And then what's the damages if there's no deal? Or that falls through for any reason. So you come into the world of loss of chance. And loss of chance is becoming increasingly important to courts and tribunals because it gives the adjudicator an avenue to sort of have a middle ground. You don't have to prove your loss of chance or at 50%. You have to prove that it's material, it's a significant chance, and then the probabilities come in and you might get a reduced damage. So again, this is where you have the interface between the lawyers and the experts. Because the lawyers have to explain to the experts what can or cannot be achieved in court, and then the experts will have to answer that question. So I think that ties up with causation and the importance of engaging your expert fairly early. The second brief point I'll make is the expert is a neutral and is an independent, but you want the tribunal to understand what's your underlying case. And therefore it's important to bring the expert in early, not just to identify your cause of action, not just to try and pitch your case where you get the most money, but also that the logic, the essential facts are established. So you don't end up amending your pleadings or trying to shoehorn an argument at the end of the case.
Would you like to add to that?
Just very brief. I don't know if it's working. It's working now. I think just quickly is that I think the issue that I see sometimes can be very complex is the valuation date. As Anthony said, when sometimes you see multiple claims and also you have multiple contracts and you have multiple claimants in an arbitration. It is always really interesting how valuation date is decided and picked by the parties. And then I think there's nothing worse when the tribunal comes back and actually moves the valuation date, which completely guts your quantum in the case, and you end up winning the case without winning any damages. So I think valuation date is always something really tricky and something you should really spend time thinking about at the beginning of the case.
I guess we are running out of time, so if the audience has any questions, we'll be happy to. Sorry, Justice Singh, would you like to add to the discussion?
Yes, I would just like to say that I've been in the arbitration roster for about 4 months now. And what I've seen is that there is no contract which is foolproof. And the arbitration lawyers, the litigation lawyers, they are actually, they're musicians, they're artists. Every word is so beautifully argued. Every word of the contract forces you to think that, yes, this could be a possible meaning. This could be, and that's the only way, according to me, how the law evolves. So it's fantastic, and keep it up.
Yes, Vaibhav has a question.
I just have a question for the panel, particularly in the Indian context. As a transactional lawyer, one of the tricky points is that we are required to pretty much incorporate the entire shareholders' agreement into the articles to ensure its enforceability. Typically in a joint venture scenario where one party is trying to force the other to cooperate, to do something, it could be exercise of a drag right, where you're dragging the shareholder away, or you're calling the shares. You can't literally put a gun to the counterparty and say, sign the share transfer form. So you need him to cooperate to do something. I understand what Anthony said about step-in rights. You take control of the management. As a company, you cancel somebody's shares. But where you require the other party to do something, and with the Indian law where arbitrability of, oppression, mismanagement, invariably in a joint venture, if one partner is saying, you have breached, I will exercise call, buy your shares, the other party says, no, you were oppressive in your conduct throughout the currency. Now, in most scenarios where the Indian partner or the counterparty takes this argument of oppression, mismanagement, if we start seeing these trends where Indian courts are involved in assessing the core value of the dispute, whether it's arbitrable, non-arbitrable,
you will typically see 2-3 years elapsing in the case of, operation successful but patient dead. So is there some thought process as to how this sort of ground of non-arbitrability on oppression, mismanagement, and shareholder disputes can be easily sort of segregated? Otherwise they're so overlapping, with one partner always taking this as a ground. And by the time this issue gets addressed, a few years have gone down the road. I mean, as we are seeing in the matter that you were mentioning about.
So I think Section 8 would not require, in my view, and Justice Singh is here and he has an arbitration roster. In my view, it would not require an extensive analysis. You have to see on a prima facie basis whether it is a dressed-up petition made to look like an oppression mismanagement, or it's a matter which is purely an issue of contract. So I think that the skill for the lawyer would be to show that prima facie it is not really it's not really an oppression mismanagement issue, or subject to your Section 8, right? You could seek relief. You could seek relief if there is urgency and the court is still hearing a matter. Then, without prejudice to your Section 8, you possibly could seek relief from the court as well.
So just I'm not a lawyer, that's the first caveat I'll make. But the second point is that's why you're seeing increasing the investments, having management step-in rights, finding a way to sustain the value of the business while the dispute's going on. I think that's super critical because otherwise, like you said, even if you win the battle, the war is obviously ended, the value of the business is zero. You really often can't enforce against the actual shareholders or the promoters. Their assets are either not available to you or have been moved around. So I think the question of how you sustain the value has become absolutely critical. I have not seen a private equity investor in the recent past not have these rights like management step-in rights, certain reserve rights that kick in on an event of default to ensure that the company's value is maintained. Any other questions? We have one more from the front benchers. Jagdish, yes?
Thank you. That was a very interesting panel. This is a question partly for Justice Singh, but also the rest of the panel. One of the things that sort of strikes me in a lot of these shareholder disputes and post-M&A situations is that it's ultimately about, business minds coming together and trying to find a solution. And the disputes get dragged out for a long period of time because there are so many issues. So perhaps one way is case management, where either, for example, an interpretation of the contract is looked at as a preliminary issue, or if it's about the numbers, then experts are brought on forward before fact witnesses, et cetera, and number crunching is done at the outset to sort of bring the business minds together and focus on what the key issues are in the dispute that's driving them apart, and perhaps reach a settlement even before a judgment is required. So I don't know whether that sort of case management is something that the decision makers and adjudicators are thinking about.
See, under the Commercial Courts Act, we have the case management system, but not under the arbitration agreement, but there is, we have courts which are dealing exclusively with arbitration. So there is a bit of urgency, and the scope of interference in an award is very minimal. Under Section 11, the fact whether it's an arbitrable dispute or not is seen at the outset. So these are issues, these are steps, according to me, which is kind of going in the right direction to see that the arbitration is given there are time limits for the arbitral tribunal to decide the issue. 29A is only if it's an extreme case, why it could not be decided within that period, 1 year plus 6 months. So these are all steps which go to that.
Any final question? I know it's time's up apparently as per this. But any last questions? I think that's a no. With that, can we just have a round of applause for this fantastic panel?
Thank you very much, panelists. And now I request Mr. Mohit Saraf, Managing Partner, Saraf and Partners, to please come on stage and present a token of appreciation to our esteemed guests, starting with Honorable Justice Jasmeet Singh. Can we have the token of appreciation, please? can we have for the other guests, please? Can we have the applause going, please? Thank you, everyone, and a group picture, please. Thank you, gentlemen. We now turn our focus to a topic of paramount importance in the legal and financial sectors, effective and efficient, the Insolvency and Bankruptcy Code of India. This session promises a deep dive into how this pivotal legislation shapes business resilience and economic recovery. We are privileged to commence with a special address by Honorable Justice Amit Bansal, Judge, Delhi High Court, whose profound knowledge and experience in this field is widely recognized. Please put your hands together for Honorable Justice Amit Bansal.
Good afternoon, esteemed guests. I have the good fortune to speak with you today about a unique piece of legislation enacted by the Parliament of India in May 2016. As the Insolvency and Bankruptcy Code, IBC, approaches its 10th anniversary, I would be happy to share my views and reflections on its effectiveness and efficiency. Let's start from the beginning. In the years prior to the enactment of the code, India was beset with what is commonly referred to as the twin balance sheet problem. The twin balance sheet problem refers to a scenario where banks are under severe stress due to many NPAs and corporates are over-leveraged to the extent that they cannot repay their loans. The code was enacted not only to ensure that banks are able to recover the dues, but perhaps more critically, to ensure that over-leveraged firms are rehabilitated. The philosophy of the code is that comprehensive resolution of the distressed firm is better than the piecemeal liquidation of the corporate debtor. The code, to accomplish this objective, which departs from previous legislation of the same nature in several ways, two of which I would like to briefly mention. The first is creditor in control. After a firm is adjudged insolvent, the company's previous management is dislodged. In their place, a resolution professional, or RP, is appointed, and all managerial power of the company vests with him. The RP runs the show under the supervision of a committee of creditors, or COC. This comprises the firm's financial creditors. The ultimate objective is for the RP to quote a resolution applicant and submit a resolution plan for the rehabilitation of the distressed firm. The decision to approve or reject a resolution plan lies with the committee and thereafter the relevant tribunal. COC has vast powers to cause haircut of any amount in order to rescue the company, suggest change in management, restructuring of the company, amongst others. The second notable aspect is the stringent timelines. The entire insolvency process from admission to approval of a resolution plan is supposed to conclude within 330 days, failing which the firm is to be liquidated. The importance of timelines has been reiterated by various courts and most recently by the Supreme Court in Ramakrishna Forging versus Ravindra Lunkar, where Supreme Court set aside directions by NCLT directing revaluation of the debtor firm's assets on the ground that the entire process is time-bound. These features of the code are enabling features so that company can be rescued from its management as quickly as possible. The timeline is crucial since it ensures that there isn't further value erosion within the firm. Beyond revival and liquidation, another major aspect of the code is the deterrence effect that it brings. The threat that a firm may change hands if not managed properly allows for better debtor-creditor relationship, prompting substantial recoveries outside the code along with improved performance. Therefore, what we are witnessing now is that many debtors choose to resolve their debts in the initial stages, unwilling to bear the consequences that a CIRP brings. As a result, the defaulter's paradise that used to exist is lost. With this background, we can pose two questions to ourselves. First, is the code effective at doing what it's supposed to do? And secondly, does it do so efficiently? Coming to the first issue, as I outlined earlier, the code is supposed to improve recovery for banks and rehabilitate over-leveraged firms. As per the IM Ahmedabad report from August 2023, creditors have on an average realized 32% of their admitted claims. In cases where the insolvency process concluded with a resolution plan coming in, creditors realize approximately 168% of the total value of the firm itself, which is the liquidation value of the firm. The fact that creditors recovered more than the liquidation value of the company by itself is an endorsement of the philosophy of the code. The same report also tells us a lot about how firms perform after the conclusion of the resolution process. The report notes that the average sales show an increase of 76% in 3 years following the resolution. The amount a firm spends on its employees as a proportion of its revenue is also seen to increase by around 50% in the 3 years. Similarly, increases are seen in the market capitalization of listed firms and overall liquidity. The results were apparent to the Supreme Court even 5 years ago. Justice Nariman, speaking for the bench in the celebrated case of Swiss ribbons, noted that the experiment conducted in enacting the code is proving to be largely successful. The code, like any bankruptcy legislation globally, accomplishes these twin objectives by curtailing the rights of stakeholders. The prime example of this is the moratorium, which comes into force upon the admission of firm into the insolvency. Once the moratorium is enacted, a creditor cannot initiate or continue any recovery action. Since both contractual and statutory actions are interdicted by the code makes certain promises to creditors. Promises that you won't be worse off in insolvency than you would have been outside of it, which is fundamental to any bankruptcy law. If creditors aren't assured that their outcomes inside bankruptcy are at least as good as their outcomes outside bankruptcy, no creditor would choose it. To this end, every resolution applicant's plan must conform, among others, to two requirements. First, operational creditors, that is the creditors, must be paid the amount they would have received had the firm been liquidated and money distributed as per the waterfall mechanism prescribed in the code. Second, financial creditors who do not approve a plan must be paid their liquidation value. In other words, they must be paid as much as they would have had the firm been liquidated. These requirements are essentially a safety net. A creditor may choose to assent a plan and accept a payment lower than its liquidation value. However, if a creditor does not consent to a plan, they at minimum need to receive their liquidation value. Calculation of liquidation value is therefore important to the entire process. Different creditors strike different bargains with the firm. One creditor may agree to advance a loan at X%, subject to an exclusive mortgage. Another creditor may agree to advance a loan at twice the rate of interest without any security in its favor. Those familiar with banking industry would see this inconsistency as being a feature of debt financing. Thus, upon commencement of insolvency, each creditor walks in with unique security. Liquidation value for each creditor is arrived at by estimating the value of the corporate debtor and assigning a proportionate share to each creditor. One way of doing this is by looking at what percentage of a creditor's debt makes up the total debt of the company. The total liquidation value of the company is then assigned accordingly. Thus, if there is a company with liquidation value of rupees 100 and two financial creditors each with rupees 100 debt, then the liquidation value of each creditor would be rupees 50. The Supreme Court in India Insurgents ARC versus Amit Metallics, this is May 2021, endorsed this view, holding that each creditor's security would not be relevant when ascertaining their liquidation value. Under this method, the fact that one creditor has more valuable security than another is immaterial. There are, of course, certain merits to this course of action. If creditors are told that they won't be given the value of security if they dissent from a plan, they may be more likely to assent to a plan to get a higher payout. The issue is that in doing so, in effect, invalidates the pre-insolvency contracts entered into between the creditors and the firm. A contract for creation of security is purposeless if, at any time of the insolvency, the creditor cannot take recourse to it. Invalidating creditors' contracts dilutes the effectiveness of the code since it creates incentives for creditors to seek recourse outside the IBC. Recently, in January 2024, in DBS Bank Singapore versus Ruchi Soya, the Supreme Court questioned the view taken in India Insurgents, observing that creditors' pre-insolvency contracts ought to be taken note of while determining their liquidation value. Specifically, the Supreme Court held that Section 52 of the Code, which allows creditors to step outside a liquidation proceeding and enforce their security interest, is built into Section 53 of the Code, which prescribes the waterfall mechanism. This is relevant because Section 53 treats all secured creditors as a single class without due regard to their security. By reading Section 52 into Section 53, the Supreme Court recognized that even among a class of secured creditors, different creditors may have different values due to them based on their security interests. DBS has referred India Resurgence to a larger bench. Ultimately, this issue will have a huge impact on the effectiveness of the code going forward. Now I move to the second issue, whether the code is efficient. The code prescribes stringent timelines for each action. Whether these timelines in practice are stringently followed is a complicated question which depends upon many factors. It needs to be flagged that average time taken for admission of a case during financial year 2021 and financial year 21-22 stood at 468 days and 650 days respectively. The primary outcome of delay is that the value of assets keeps depreciating. The law, as it has devolved, seeks to ensure that the code stays as efficient as possible. One of the ways it does this is by minimizing the number of factors required for determination at every stage of the process. A good example for this is the Supreme Court judgment in Dilip G. Vrajka versus Union of India, where the Supreme Court was dealing with a constitutional challenge to the provisions of code pertaining to personal insolvency process. Supreme Court held that the debtor need only be heard once the resolution professional's report comes in. In a sense, the Supreme Court dispensed with the requirement for a protracted hearing at the admission stage, ensuring a swift path to admission. Similarly, Supreme Court in Suresh Kumar Reddy versus Canara Bank, this is May 2023, has emphasized that at the time of admission of a company into insolvency, the relevant tribunal has minimal discretion. By restricting the scope of inquiry to just the existence of a debt and default, the Supreme Court reduced the amount of time an admission hearing may take. The judgment in Suresh Reddy to quite an extent diluted the Supreme Court's judgment in Vidarbha Industries versus Axis Bank, where the Supreme Court had expanded the discretion that a tribunal exercises when adjudicating an insolvency petition. Post Suresh Reddy, the position once again seems to be that a tribunal needs only to ascertain the existence of a debt and a default thereupon. Another way in which the law has evolved to ensure speedy and efficient completion of insolvency proceedings is by restricting the challenges to the plan approval process to after a plan is approved by the committee and is pending before the tribunal. In ArcelorMittal versus Satish Kumar Gupta, Supreme Court held that no resolution applicant has a vested right to have their plan considered. By cutting down on pre-plan approval litigation, the entire plan approval process is streamlined, making the process quicker. It is also apposite to make note of the doctrine of commercial wisdom developed by the Supreme Court in case Shashidhar versus Indian Overseas Bank, and most recently reiterated in M.K. Rajagopalan versus Dr. Periyaswamy Palani Gaunda. The doctrine of commercial wisdom protects decisions taken by the committee on a commercial level from judicial scrutiny. The classic example is resolution plan approval. If the plan complies with the provision of law, then tribunal ought not to interfere with the plan on the ground of reasonableness. By limiting the scope of judicial interference, the doctrine of commercial wisdom ensures rapid plan approval and implementation. The law thus has consistently been shaped in a manner that ensures decisions are taken as quickly and efficiently as possible. To conclude, the objective of the law is to aid and assist the business and commerce, not to hinder it. Code is a watershed legislation that aims to accomplish this while simultaneously ensuring fair outcomes for all stakeholders. While more time is needed to finally decide whether the law is effective and efficient, as things stand right now, in my view is that it is. One hopes that continues to be the case. Thank you all for your patience, and I'm grateful to having provided me this opportunity.
Thank you very much, sir. And now I request Mr. Mohit Saraf to present a token of appreciation to you. Can we have the token of appreciation, please? Well, taking the discussion forward will be Mr. Parag Maini, partner AZB and Partners, whose insights will no doubt illuminate this complex topic. Please welcome the moderator. And now welcoming our esteemed panelists, each a stalwart in their field, ready to unravel the complexities and triumphs of the insolvency and bankruptcy code. Please put your hands together for Mr. Abhilash Lal, resolution professional, Alvarez and Marshall. Now please welcome Mr. Arvind Nair, Senior Advocate. Please welcome our third panelist, Vijay Lakshmi Das, Vice President, Office Space Solutions Limited. Our fourth panelist is Mr. Deepak Kumar Gupta, Executive Director, Standard Chartered Bank. And I would like to invite back on stage Honorable Justice Amit Bansal. Sir, if you could join us back on stage. Mr. Parag, over to you.
Thank you. Thank you so much. Sir, thank you so much for your insightful views. And, we look forward to have your guidance throughout on the panel.
I would jump in wherever I think I have something to contribute.
Absolutely, sir. Absolutely. Thank you so much. Thank you. At the outset, I would like to thank to all of you who, despite being in a holiday, right, you have all turned around and, being in the large numbers. Thank you so much. Thanks to all my panelists. So I, on behalf of AZB, welcome everyone to the panel discussion on effectiveness and efficiency of IBC. Since the theme includes words effectiveness and efficiency, I would pause for a few minutes and in fact, I would like to say that, what was conceived to be efficient and, efficiency. So there are 4 pillars in IBC which are there. So to start with, our first pillar is Committee of Creditors. And since we are talking about COC, which has been given a major role in the decision-making process, we welcome Deepak Gupta, who is an Executive Director of Standard Chartered Bank. And Deepak, you have been on the various COC. You have an enriching experience in dealing with number of matters. So, we welcome you to the panel. Thank you. Thank you. Coming on to the next pillar is that resolution professional. He is the main man on the ground. And as we talk about resolution professional, he usually is being tasked with the task of, reviving the company within a time-bound manner whilst every question and every decision is being challenged in various forums. So Abhilash, thank you so much. Thank you so much for joining. We have Abhilash Lal, who is a renowned resolution professional, and he is the resolution professional for 7 Healthcare Private Limited, now Jhabua Power, as well as IRP of Go Airways. Abhilash, thank you so much for joining the panel. Thank you. And then when we talk about the third pillar, which is the NCLT, when we talk about the enforcement, NCLT, adjudicating authority, and as well as the appellate authorities, they play a crucial role in enforcing the ethos of IBC. And with this, I would welcome Mr. Arvind Nair, who is an eminent senior advocate and considered to be a toughest of opponent, and who keeps the spirit of IBC alive and make sure that the value get preserved. Thank you so much, sir, for taking out the time. And yes, and the fourth being operational creditor, we have Bijoy Lakshmi Das from Office Solutions Limited. Bijoy, thank you so much for sparing your time and being a part of the panel. Thank you. Thank you. Abhilash, since the theme is effective and efficient, we cannot think of any individual other than Abhilash in his personal and professional capacity to open the discussions. Abhilash, whilst not wanting to give away your age, we believe that you got your license to practice in the year 2017. And within this 7 years, I'm sure you have not only had the ringside view, rather you were in a ring to test the effectiveness and efficiency of insolvency and bankruptcy court. So my first question is, could you tell us what according to you has been the most effective in insolvency and bankruptcy court? And at the same time, what has been the biggest constraint?
Thank you. Well, considering that we need an experience of 15 years to even qualify as an RP, I certainly can't pass off myself as a 35-year-old, right? So, so much for my age. And you get RP started on this, I think very thoughtfully you put a countdown clock in front. I'm really liking that. Keep an eye on the clock. Okay, so without repeating what Justice Bansal said, I think the IBC is a fabulous piece of legislation. Extremely well thought out, extremely well reasoned, and very effective if, and it's a very big if, the management experts say it's more important to do things right than to do the right things. The right thing somebody else will take care of. But Drucker famously said that you have to do it right. Execution is an issue. And I think all the best interests, the best intent of the IBC, unfortunately are diluted because of the problems with execution. I'll just take 2 or 3 things. I think Justice has already mentioned all of this. Look at the timelines, for example. See, please understand that the whole of IBC is predicated, all the steps in the CIRP and other things are predicated upon the previous events being done in a definite period of time. You have to admit it within 14 days. And you know what the qualifying criteria are to admit a company to IBC. If you don't do it in 14 days, everything else goes downhill from there. What can the RP do? First of all, he is hanging around 2 years, 2.5 years, 3 years. The promoters remain in charge. And one of the most important facets of the IBC is the creditor in control. That goes for a toss. Your avoidance applications, the RP is supposed to go back what? 1 year for all transactions and 2 years for related party transactions. What will you do if the insolvency commencement date is 2 years after the application was filed? The last thing is the value. We all know, if the company is in stress simply because of poor management, willful or otherwise. If the same people continue to be in charge, knowing fully well that once this is admitted, they will end up losing the company, they're not going to leave things lying around. They will take steps and the value keeps on getting eroded. And in this admission period, I'll take an average of 2 years, you will find that the outstanding debt goes on increasing You have the original debt, you have the interest, you have the penal interest, there is a surcharge on that, and Deepak will tell you what else is there. That keeps on going up while the value keeps on coming down. And therefore, by the time it is admitted, you come across what is perhaps the most popular criticism of IBC, and that is haircut. First of all, why are we measuring haircuts on the basis of the outstanding debt? Was the IBC around when the debt was given? Was the RP consulted that this amount of debt is right? No. They come in to the picture only on the insolvency commencement date. And there is a reason why we have economic value and liquidation value that are predicated by the code. So I think logically you should look at what is the value of the company on the day it enters bankruptcy. And the last thing here is, unfortunately, while the IBC is very strong on the intent, in terms of having the muscle to force everyone, unfortunately all the muscle is on the RP. And I don't mind saying so, but you did mention Parag, that he's a favorite whipping boy. But everyone from regulatory bodies to enforcement agencies, to government agencies, to creditors, to promoters, they say, all right, now we have somebody whose collar we can catch. I mean, call me Mr. Spock. He is a single point of, I don't say contact, I say collar. Yeah? So unfortunately, what happens is somewhere along the way, it is lost that the RP is supposed to be an officer of the court. The RP is working for the country, for the creditors, for everyone else to recover. And yet, you know, the feeling is that, no, okay, he is the RP, let's catch him. If I may just take one more minute, you know, I have handled about 7 companies. In not a single company I have found that audited financials have been filed. Right. On an average, you know, they haven't been filed for the last 3 or 4 years. And I'm not counting the admission period. But the moment the RP comes in, he starts getting reminders from the MCA, other places, where are your financials? And I think the culprit in all this is that one line which nobody bothers to stress upon. And that is that the RP will keep the corporate debtor a going concern. So it becomes the RP's responsibility, liability, whatever. And unfortunately, unlike Spider-Man's uncle, with great authority, with great responsibility, the great authority does not come. That's Marvel. We were discussing with you. Right? So I think that is the problem. So in short, I will say that is a law very strong in intent, and I think if followed correctly, we will see a lot more results than we are seeing now.
Thank you so much, Abhilash. That's very helpful, in fact. So coming to Mr. Nair. Mr. Nair, you have worn several hats. You have tested the waters from different aspects, be it from an RA level, be it from a resolution professional, or, I mean, COC, I mean, all the stakeholders. What is your view on the effectiveness and efficiency of the insolvency and bankruptcy?
Before I start on the effectiveness and the efficiency, let me first say that I absolutely agree with Justice Bansal. It is, despite all its practical difficulties in navigation, it is a watershed legislation. Let's not forget that. That's point 1. 2, in the overall context of the law being settled, let's not forget that the IBC is still a very, very new legislation. We are still looking at developments and path-breaking changes happening in the Arbitration Act, and that came about in 1996. This is only 2016. So a lot of issues are still coming up before benches, whether it's the adjudicating authority, whether it's the NCLAT for the first time. So there is a lot of settling of the law that is happening. Again, before I come down to some statistics, let me add to what Mr. Lal said about RPs being the whipping boys. I think the difficulty is, and we all have Section 29A to guide us, a lot of the litigation that we are seeing in IBC, which is consuming a lot of time, is actually promoter-sponsored litigation, with promoters in the background, and they're all chafing at the fact that they've lost control of the companies that they may have built or their families may have built. So they sponsor a lot of people to file objections. And the benches do give time. I've always believed, perhaps it's the weight of numbers or the way our judicial system is structured, but I've always felt that Indian benches, whether it's constitutional courts or whether it's tribunals, have a lot of empathy comparatively. If you see other courts in the Commonwealth, whether you see Australia, you say UK, or even the numbers that the United States courts look at, the kind of numbers that benches here have, there is a lot of empathy. They usually give an opportunity to everybody to make out their case, and that sometimes takes the time. But having said that, effectiveness, I'll just give a few statistics just so that we know how much this legislation has achieved in a very, very short time. For instance, one, reduction in non-performing assets. This has decreased the NPA rate of banks significantly from a peak of 14.8% in September 2018 to a low of 3.2% by September 2023. Now, in context, if you see, whether in absolute terms or relative terms, this is a huge achievement from 14.8% to 3.2%. Also increase in bank profits. Banks experienced a remarkable turnaround, recording a historic profit of 2.63 trillion. Then improvement in corporate balance sheets. Firms have showed enhanced performance with more robust balance sheets. Then corporate governance and also global ranking improvement. Our ranking in the global insolvency resolution improved drastically, moving from 136 to 52 within the first 3 years of the IBC's implementation. So this is the effectiveness which makes it a watershed legislation. The problems, I'll again come back. For me, the problem is essentially the weight of numbers. The legislature in its wisdom has sought it fit to include home buyers. I can tell you from personal experience, every bench on an average of the NCLT is hearing 40 to 80 matters every day. I don't think that's how the legislature intended this statute to play out. At least 50% are matters which are relating to home buyers. Each item that is listed before a bench has on an average 10 to 20, 30 interim applications, interlocutory applications. And in home buyer matters, these applications even go to 40, 60, 80. The legislature intended that there will be an authorized representative of home buyer associations. We are now increasingly seeing a situation where there are multiple home buyer associations. In fact, I'm going to give a few examples of pending cases, so naturally no names. I'm actually appearing in a matter where I'm appearing for the SRA, where a single who's obviously an investor, a single home buyer who bought 5 or 6 units, filed objections. Everybody questioned his locus. He was heard over 3 hearings. Everybody was heard. Orders were reserved. Time was given to file written submissions. And lo and behold, this particular home buyer or investor, as we like to call him, has changed counsels and now wants to argue his matter afresh. So those are the kind of difficulties that are being faced by benches. And I think that's taking away from the effectiveness. Coming back to the role of the RP, again, I must point out, as Parag said, as counsels, we are fortunate to appear for various parties. But I can say, I don't know if that will be of some comfort to Mr. Lal. I can tell you with some personal experience that when we stand up saying we appear for the RP, we still are relatively accorded more importance than we are when we stand up for the SRA or we stand up for any other objector. So that faith that RP is the nodal officer, he is the officer of the court, is still there. And mostly when we still see many bitterly contested matters where the bench immediately says, who is appearing for the RP? We first want to hear what the RP has to say. Of course, there will be some bad eggs. All counsels are supposed to be officers of the court, but all counsels don't assist the court. Similarly, there will be RPs who will perhaps not be able to fulfill that responsibility. But overall, everything said and done, I think the IBC is proceeding very well. It's still very, very new. So a lot of issues are still being settled. And I'm sure if we give it another 5 years, I think a lot of the dust would have settled.
Mr. Nair, you have made one point with respect to home buyers being included as financial creditors and the number of matters which are being listed every day. So do you think that the summary jurisdiction of the NCLT is being diluted somewhere or the other?
Absolutely, absolutely. That's why I immediately, at the starting of my comments, I immediately talked about the empathy of Indian judges, because we have tried to tell benches as delicately as we can that, look, they may have, this is not an equity jurisdiction. This may be unjust or unkind to a particular investor or a home buyer, but please don't examine this. But I think judicial training here, the empathy, the experiences, the difficulty, the practical difficulties that a home buyer or an investor faces does compel benches to hear nearly everybody. I'm yet to see a case where any bench of the adjudicating authority or even of the appellate tribunal has actually shut out a home buyer and said that, look, you've come late and you will not be heard. In fact, I was personally appearing in a matter where the adjudicating authority kept requesting, in fact, they were kind enough to not direct, but to request both the SRA and the RP that please try and see, these are people, some of them were NRIs who had missed the advertisements, some were people who had missed the publications, and they kept saying that please accommodate. In the end, I think we ended up accommodating 35 extra home buyers who had missed all deadlines.
Thank you, sir. Thank you so much. Deepak, coming to you. I mean, for our panel purposes, you can be introduced as possible COC. And since you have attended many COCs and being a part of it, what are your views on when we talk about effectiveness and efficiency of insolvency and bankruptcy court?
Parag, I just need to step back. So before getting into effectiveness of any law, we need to just step back before it was actually enacted, before IBC. So as a lender before IBC, what was our numbers of recovery? What was the years typically we used to take? So in a company when it's under financial stress, unfortunately you have customers, vendors, lenders, and then equity guys. They didn't have one panel to go to. They have different courts, different, and they will be basically taking their case to individual courts. All the courts will not know exactly what is happening in that company overall. So there was no macro view. And that really, as a percentage, it was typically 26 cents to $1 recovery over a span of 5 years. So that was the average before IBC came. After IBC, now there is only one tribunal which go to, and all these guys go to one guy. And the RP is there. He will have a macro view, what is the issue in the company as a whole, and that he is going to solve it. So post IBC, the number is simple, 71 cents, and an average is 1.5 years to 2 years. This is the number of 2021. Okay, now the problem started after that. These are the first, few cases plus the cases which just came after that. And one of the cases we just talked about, Bhushan, is a fantastic case which ended in 330 days, the perfect deadline, and we had a massive 68 cents we recovered as a lenders. Post that, what has happened, both Mr. Nayyar and Mr. Lal has covered already, so I don't need to keep repeating it. There are a lot of litigations have started coming in, and because there is a look-back period of 2 years also, where the RP has, promoters really typically want to, litigate, continue, and delay the admission itself. That has created a problem for the lenders also. As a lender today, my first preference is not NCLT, or might not become an NCLT later on. We may are looking at selling the loan itself. NAR sale is a new thing in the market right now. We are looking at it. And if it doesn't really resolve going forward very quickly, I don't think so NCLT, your cases will be a lot of, you will see, from the lenders at least.
Absolutely. You made a valid point in terms of promoter-driven litigations as to how it hampers the overall effectiveness when, under the statute, you are supposed to adjudicate on, 14 days, but it didn't hang on for years and years.
We still have a case which is being debated for 7 years almost.
Absolutely, absolutely, yes. So, Bijoy, coming back to you, I mean, now you are a fourth limb, in the form of an operational creditor. Being a, in-house counsel, I mean, you have larger roles to play. I mean, it's not about only taking the company into insolvency, but, you also, as a company, may also be subjected to a threat of insolvency, right? So how do you see and how do you manage that as well? I mean, other than your 2 cents on, efficiency and effectiveness of the IBC, how as a in-house counsel, how as a, operational creditor, you see this code panning around?
So
Yeah, it is in fact for companies like us which intend to thrive and expand, it's a very, very big threat for us if there's a threat of an insolvency proceeding, right? So whenever we are under that situation where we think that we probably might be dragged to NCLT for any such case, the endeavor is always to settle it, right? Because we don't want to, because there are a lot of stakes involved for companies. So there's, first of all, the goodwill is at stake. Secondly, they're investors and they're bankers. So it raises a red flag, and which is not taken very lightly by the management. It's a very, very big deal for companies, right? So in such scenario, we try and we ensure that the internal teams are aligned on making timely payments. We honor the payment terms. But however, there are scenarios where, maybe the service provider is not complying with the terms of the agreement, or maybe there's some shortfall in the services. In such scenarios, we ensure that the business teams are made aware that we need to put across the communications well to the service provider. And where need comes, we also send across legal notices just to ensure that these issues are highlighted, escalated before we are, at a legal battle before an NCLT. However, yeah, it is in fact very effective from my point of view, because if in case we need to, sue somebody and the threshold limit in that case is, is more than 1 CR, then we definitely opt for NCLT, for the reason being that puts a lot of pressure. No company would want to stake their reputation, so everybody pays up. And it's vice versa for us also. The moment we receive a notice from any from a client saying that we are going to sue you before NCLT, we promptly make the payment in case there's no dispute raised earlier. So yeah, from a company perspective, it is material, and I think it is effective. However, there are certain, maybe positive changes that can help us all in, taking it further. Yeah.
But Bijoy, we have also seen in the past, when we are being provided a brief, a lot of times we see that, post the execution of the contract, usually legal teams, there is a presumption that legal team is supposed to be out, and now the baton is with the business teams. Now they are the ones who are in coordination, or who are doing these communications with the service providers. They, in all your day-to-day communications, they tend to make those mistakes, right? And they say that that we will honor our commitment and we'll pay it. So at times it creates, and and the opposite side will definitely gonna come with that email saying that, look, this is an admission of an amount. Now henceforth the company needs to go into IBC. So so how as an in-house counsel you manage, and do you have an escalation matrix, and how you manage amongst the other stakeholders within the same organization?
So we all learn from our mistakes, right? There are times when the scenario that you mentioned had happened where, maybe the business teams without consulting the legal teams have, sent across communications which didn't help us in the legal battles that we had. However, learning from those past experience, we make sure that whenever we know that certain, transaction with the client is going to that angle where, there probably can be any litigation, and obviously considering, now insolvency is something that everybody goes for. So we ensure that the communications has to be proper, and we cannot make any admissions. One has to be, yes, initially there was everybody was doing individual work. Now we have cross-functional teams. So whenever there is some default or some sort of a dispute arising, we create a team. We teach how to, and legal team has to communicate or has to do the drafting for their teams. So there is an internal alignment that has happened with such laws being now, used against companies. So now there's a CFT in every organization who work towards ensuring that we don't make mistakes in communicating or drafting agreements, so to say.
Thank you so much. Thanks. Abhilash, coming back to you. So amongst the numerous struggles that IBC has faced, and continues to face its integration with the existing laws, do you think that a large part of the problem is that because the government department do not talk to each other, and as a result of which a lot of issues crop up on day-to-day basis?
Certainly. I think to a very great extent that is true. See, and I think the core issue there is that within IBC we need to fix a center for responsibility. Who is responsible? Just as an example, take avoidance transactions, right? The RP doesn't have the ability to conduct forensic audits, etc. If we find something where it reeks of a fraud, we take it to the NCLT. 99% of the time the response comes, oh, the NCLTs are not in power to handle this. Please take it to the ED or EOW or SFIU or CBIO. I don't know. I'm not a legal guy, right? And that's where the problem starts. And to come back to my earlier definition of Spock, these people, the agencies, do not think the RP is there to help them. They think, aha, we have somebody here. Let's catch him. Let's find out. And so what ends up happening because of this lack of communication amongst all the people, most RPs try to take the path of least resistance. And I'm sorry to say, I'm admitting it as an RP, that most RPs hate it when they come across any kind of evidence of, any kind of avoidance transaction. They say, oh God. Because certainly investigations in these matters will outlast the CIRP and nobody takes credit. Yes, there are steps being taken. It is being said that the resolution applicant must mention how they will treat the avoidance thing. But they will end up using it as a bargaining tool. They will say, we don't know what the probability, what the outcome is going to be. We are certainly not going to price it into our court. So that's where it goes. The second problem is, even if you say that, yes, whatever are the proceeds from such thing, they should go back to creditors, who is going to handle it? We don't know how many of the creditors would remain. Right? I mean, if it is somebody, fresh SRA has come in, he will obviously bring in a circle of things. And this extends to other people also. I mean, thankfully, we have seen, as Sir pointed out very correctly, it's a new law. We are seeing changes over the year. I remember my very first case, filing GST during CIRP period was a problem. Because the system would automatically take in a first in, first out approach, right? And I said, look, you're breaking the law. They said, we don't know what law you are talking about. Okay? I do wish it goes to the enforcement authorities also, because I can share with you that I have spent some very uncomfortable days. Raghav was with me, one of those. And being offered a cup of tea is, I think, about the most that you will get. So certainly, I think this amount of training, knowledge, appreciation, awareness, all of these amongst governments needs to come. I'm not getting into the attachment and other issues that you've already covered, but there are several such things. The short answer is
the short answer is the integration needs to happen.
Absolutely.
Integration is the key.
Absolutely.
So, Mr. Nair, I mean, when we are talking about the avoidance application, since you are a counsel, you have been appearing on this side. You have, you must have argued, various avoidance applications as well. What is the reason that today there is a poor turnout of deciding the avoidance applications? So despite having such a huge potential, because it can give the maximum value to financial creditors, by the time we actually reach the stage of resolution, till that stage also we have witnessed the avoidance applications are kept pending. And then eventually when the resolution is about to happen, then of course there is a sword hanging on your head. So what is the reason? I mean, what is the reason for this poor turnout?
Parag, on the ground, what we have seen, as I pointed out, most of the matters that are listed before the adjudicating authorities have multiple applications. And notwithstanding the fact that there is summary jurisdiction, there are several objectors. Now, I think the primary reason for avoidance applications is that they are featuring very low down in the priority. In every Section 7 or Section 9, the focus of the bench, of the adjudicating authority or of the appellate tribunal is the approval of the plan. Because that sort of ties in with the objective and the preamble of the Act, which is the resolution process. So everybody is looking at the plan. The plan approval process is getting derailed by the sheer number of objections. Now there are several objections coming from the landowning agencies in the NCR, whether it's Noida, whether it's landowning agencies in fact, I believe Noida has had a few rounds of litigation going right up till the Supreme Court, finally decided that they were operational creditors. So they've been filing multiple applications. Now, when a bench is grappling with the approval of the plan within a certain timeline, the avoidance applications are really low down in the priority list. And the attempt is that let's get the approval of the plan out of the way so that a lot of other objections and a lot of other applications are rendered infructuous. They are also trying, from what we see on the ground, there is also an attempt to try and reduce the numbers of people in the court. We are now seeing in most of the cases, there are 20, 30, 40 counsels speaking at the same time. It's practically not feasible to take up an avoidance application because there is a whole list. I think all our colleagues who practice on a regular basis before the NCLT and NCLAT will know, there is a list where application by application is called out. So there are 6 months being taken, a year being taken, a year and more than a year being taken. I think that's the reason that avoidance applications are not getting the importance they deserve.
No, but now practically as a lawyer, what is your suggestion? I mean, in terms of, because avoidance applications do have some value.
No, I agree. I think what has to be done is, and this has to be probably done by the legislature or the IBBI, or with a coordination of between the ministry and the adjudicating authority. I think there has to be fixing of a right of audience. There has to be a priority that X, Y, Z will be heard by the adjudicating authority and the others will not be heard. And this has to be probably taken care of at the filing stage, that this application will be heard, this application will not be heard. I think one possible example is, for instance, the Honorable Supreme Court. There is a provision for chamber matters. So there is a whole category of cases that are heard by chamber judges. In fact, quite a few years ago, and I'm sure we've got Justice Bansal here, we've got Justice Singh in the audience, and I'm sure they can tell us, a few years ago, the Delhi High Court came up with a whole list of applications that could be heard by the joint registrars. Yes. So everything is not going before the judge and burdening the judge. I think something similar perhaps, we'll have to, this is one way of looking at it, that let's try and fix a right of audience, what is to be heard by the bench and what is to be heard possibly by the registrar or maybe by a member sitting single on a designated day. I think...
so the point that you're making is that there should be a streamlining done.
Streamlining.
Streamlining has to be done. That's a key. That's a key.
Absolutely.
Yeah. Thank you so much. Thank you.
Would like to jump in here. See, High Court, of course, there's a lot of delegation to joint registrars, Supreme Court also, but they're all judicially trained officers.
That's correct.
Now, I don't know if the registrars and joint registrars or the equivalents which exist in NCLT, are they judicially trained to handle these kind of applications?
No, sir, they are not. I was only giving an example to say that perhaps there has to be some discussion as to what is to be placed before the bench and what is not to be placed before the bench. You're absolutely right. The officers there are
not placed before the bench, where else would they be placed?
Perhaps on a given day, one of the members can sit singly and only hear these kind of applications. We can't be exactly sure as to how this has to play out, but the numbers are sort of making it difficult.
I mean, on a practical side, if on a one given day you pick up the cause list of NCLT, there are around about more than 60 to 65 matters which are listed. And on a practical side, I mean, 15 to 20 matters gets, taken up, and ultimately there are dates which are being given. So I'm saying that, because of the overall issue.
I think that might be true of various judicial forums.
Yes, the High Court also, there are 40, 50, 60 matters.
No, I think there sometimes more than 80.
Yes. I believe there are a few rosters at the moment where the supplementary lists are running from 50 to 120. I think that's a weight of numbers problem in India.
I think, Deepak, when it comes to you, we need to change the gears. Now it's been 8 years, insolvency is into the picture. I mean, you are with a bank, that is, globally placed. How do you see the banks, funds, investors, outside India? How do they see IBC? What is their reaction when it comes to IBC?
Interesting question, actually. So simply, when the outside guys see India, so what they really need when they're trying to invest in any country, forget about India, they need transparency, right? And they need to see value. I think we all agree now the value is there, the way India is growing. What we need to see is the transparency. And I think the IBC has given some transparency to the system at least, Because earlier they used to see the legal system is pretty long dated. If you want to recover, there is promoter sitting. You can't really go and try to do something. Because in the IBC, the promoter is out straight away. The RP, a professional guy, is running the company. So then you know, okay, where is my money? How can I get the money back? I can speak to him directly. So that kind of a thing is already there. I think that is already coming into the system the way people are investing from outside. I didn't need to keep giving the details and examples. I think they are looking at it positively. But my only thing is the way we are discussing, if it keeps going under the burden of longevity, I think people will start again questioning this entire system.
So you're saying the perception has changed for sure?
Yes, it has.
Thank you. Thank you. Now, Abhilash, coming back to you again. Now, we all have witnessed the concept of COC, commercial wisdom is being given the paramount importance. Have you ever seen in your tenure, or handling the multiple, issues at the RP level, that while of course COC is of paramount importance, there are members in COC who may be holding more than, let's say, 34% of the voting share. So, is there a presumption that a person who is holding more than 34% would tend to vote for its own plan? Because under the IBC, you have a provision that a COC member can vote for its own plan as well. What is your reaction on it, bro?
Yes, we have come across several such cases. The first point is that the commercial wisdom, the way the IBC looks at it, is I think, independent of the creditor's decision to put in a resolution plan. In most of the cases, I have found that creditors end up putting a resolution plan only to set a baseline value. They think, call it through their background experience to the valuation studies, they think this corporate asset is worth X, and therefore they put in a resolution plan for X. They say we will not go below X, because going below X, you get into plans below liquidation value, you open another Pandora's box. So yes, you are right. IBC does not really stop or dissuade such things. But yes, it could lead to a potential conflict of interest. We resolved it in 2 cases by, the applicant saying that we will recuse ourselves from the voting. That was the informal understanding amongst the creditors themselves. I don't really know if it will, pass the test of law, because all said and done, everyone hasn't voted. And the last part that you were saying, that, sorry, what was the last part again you said?
The last point that I was making is that when you talk about the veto, there's a presumption that, he may vote for in his own plan.
Yeah, so thank you. It slipped my mind. I think over here, I will give credit to our benches. Our NCLTs have been amazing in this respect, that they're taking their duty of ensuring that everyone's interest is protected. I tell all the COs I handle that the fastest way to get your resolution plan approved is to have 100% of the members approving it. The moment you take a resolution plan to the COs, to the bench, which has been approved by 80%, 85%, 90%, the antennae go up. And the first thing they say is, why are people not voting for it? So I think there is that safeguard that is available to us. What we will perhaps need to do is see if we can do something about a creditor voting for his own plan. That is something we have to set it right. I said informally recusing themselves worked, but I don't know whether it can be done as per law.
Deepak, I can see the smile on your face.
No,
you must have something to say.
It's already decided in one of the cases, the initial 12 cases, where one of the RAs was also a COC member. I think Supreme Court had decided that he can actually vote on their own case. So it's already decided. But yes, we did face a couple of cases where the veto power was with certain creditors and they wanted to put their own plan. So it really destroys the entire thing that a resolution can be brought in, because having a veto means that you are going to in-house fighting with the lenders between themselves. That's another issue.
I think just for everybody's consumption, The constitutional vires of that provision has already been challenged before Delhi High Court. The matter is sub judice on this issue. That, if let's say somebody is having a 34% veto, then they may not vote in favor of the plan submitted by the other RA. And that can lead to a situation where the company is forced to go into a liquidation, which is against the ethos of the objective of IBC. So that's there. And, I'm sure, Deepak, we would have dealt with this in the past.
I am biased on that because I handled the case myself. So,
Bijoy, do you think that the threshold limit of 1 crore, especially in, the operational creditor, needs to be increased?
Absolutely. A company whose worth is, net worth is about 300 crores. Just imagine that company being dragged to NCLT for a outstanding of 1 crore. In my personal view, being an in-house counsel, I think it's not justified. But however, there should be, I think lawmakers should think about, consider all these aspects before working on the threshold limit. I definitely feel it needs some changing. Yeah.
So somebody in the audience was mentioning that it needs to be reduced.
Frankly speaking.
No.
No, if a company with 300 crores net worth.
Yeah.
No, and that's what I'm saying. If a company with 300 crores net worth can't pay 1 crore, then definitely.
Sir, in fact, we want to get your views as well on this. So, in fact, we want to get your views as well on this. That as far as the threshold limit is concerned.
I think in today's times, 1 crore is too less. Yes. So I think to reduce the numbers and to have a more efficient administration of the code, I think the number needs to certainly be much higher.
Absolutely. Thank you so much. Now, Mr.
Nair,
Nair,
take care of the weight of numbers also.
Weight of numbers, yes, absolutely.
Parag, time's up.
Well, I think the time's up, and we have exceeded the time limit as well. No, but thank you so much. So, Mr. Nair, we would like to have the concluding remarks.
I'll just very quickly repeat what I said in the beginning and what Justice Bansal said and Abhilash said. I think it's all said and done. It's a watershed legislation. The benefits far outweigh the roadblocks. I'd not call them the negatives. They are merely the roadblocks. It's in the overall context of things, the overall context of various stakeholders, the weight of numbers, the affected parties. It's still a very, very new legislation, and I think we should give it a little bit more time for all the roadblocks and speed bumps to be ironed out. I think another 5 years and a lot of issues on which there are conflicting views and opinions will be settled one way or the other by our constitutional courts.
Absolutely. Sir, we would like to have your concluding remark on this.
It's good to conclude on the note which Mr. Nair has put in. I think we have to be satisfied that some great results have been achieved, and it's a watershed legislation. For the first time, some procedure has been put in place. It's only been in place for 7-8 years. So in fairness, we must give some more time for it to iron out its various deficiencies. So I would like to conclude on an optimistic note, and hopefully when we meet here a couple of years later, we'll have more positive things to say.
Absolutely, sir. Absolutely. Thank you so much. Thank you so much, all the panelists. Thank you, Justice Bansal, for being here. Thank you so much. Thank you.
Thank you, panelists. And can I request Mr. Parag to present a token of appreciation to our esteemed panelists? Thank you very much, everyone. Ladies and gentlemen, we'll take a short break for 15 minutes for high tea, and please be back here exactly in 15 minutes as we are expecting the Honorable Chief Justice of India for for his valedictory session. So please go for the break and come back very soon. Thank you. Ladies and gentlemen, it's time we transition into the grand finale of our summit. This session is not just a culmination of our two-day journey, but a beacon lighting the way forward for the legal community. With that, we are honored to introduce the valedictory session for the Global Lawyers Summit, organized by the South Asia Committee of the American Bar Association. Ladies and gentlemen, please put your hands together for Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Supreme Court of India. Sir, can we please have you on stage? Sir, could you join us on stage, please, sir? I also take immense pleasure in inviting our other speakers for the evening. Please welcome Ms. Neelam Tripathi, Senior Advocate, Supreme Court of India. Please welcome Ms. Vinita Sinha, Assistant General Counsel, Asia, IFC. Now please welcome Ms. Pallavi Shroff, Managing Partner, Shardul Amarchand Mangaldas and Company. And of course, please welcome back on stage Ms. Pratibha Jain, Chair, India Committee, ABA, and Head of Strategy and Group General Counsel, Everstone Group. We shall now begin the proceedings of this session with the customary lighting of the lamp. Thank you, everyone. May I now invite Ms. Nilima Tripathi for her welcome address, please. Ma'am, do you want to?
Honorable the Chief Justice, the distinguished guests, and dear friends. Yeah. This is okay now?
Yes.
Okay. This Global Lawyers Summit, organized by the South Asian Committee of the International Law Section of the American Bar Association, which is the second event. There was one event last year also. So talking about the ABA to begin with, this was founded in the year 1878 by the American Bar Association, or the ABA, which has been committed to advancing the rule of law across the globe by providing practical resources for legal professions, professionals, law school accreditation, model code of ethics, and more. ABA has been organizing conferences across the globe, catering to diverse interests and needs of legal professionals. In August last year, ABA had undertaken an unconventional decision to elect Mary Smith, who is the first Native American woman, as president of ABA. In addition to carrying the torchlight for indigenous women, her leadership serves as an inspiration to people all across the world, particularly those who have traditionally been marginalized. Now, the ABA conferences foster a sense of community and comradeship among legal professionals, providing a supportive environment. ABA conferences include sessions and initiatives focused on advancing diversity and inclusion, fostering a more inclusive legal community, and addressing issues related to bias, discrimination, and access to justice. The conferences provide a forum for exploring emerging trends, challenges, and opportunities shaping the legal profession. Under the able guidance of Ms. Pratibha Jain, the ABA has hosted a very successful international conference in India last year and this year as well, thereby providing the opportunity to connect with legal professional and knowledge gaining. The sessions were informative and thought-provoking. I could attend only a few. I wish I had attended more. While providing insights and updates, the stimulating and inspiring presentations and panel discussions by leading experts have provided useful perspectives and innovative ideas and will therefore go a long way in enhancing the skill sets. The two-day conference has brought delightful insights from around 130 plus speakers, 24 panels, 2 managing partner panels, many sitting and former Supreme Court and High Court judges, various CEOs, CFOs, GCs, and senior partners of law firms have graced this event with their presence. To conclude by saying about ABA that I am fairly confident that the participants will go back feeling enriched with insights into the current and new areas of law, as well as inspired and challenged for even more ingenious and out-of-the-box thinking approach of finding real-time practical solutions for the legal problems. A word also about our chief guest, Honorable the Chief Justice. I just happened to be scrolling through the Supreme Court website and I found a list of the various initiatives, a huge number of them on the technical front, which have been taken by the Supreme Court. I'm also aware of his recent statement while inaugurating one of the new law schools, where he said that Hindi should be promoted as a language of teaching, especially for law, because that will lead to a more inclusive education system. So borrowing from the same, I would say when I look at this long list of the initiatives which have been taken, and it's not possible for me to even try and put them even into a few words. So as they say, and borrowing from Bollywood, हमारे चीफ जस्टिस साहब के जो अचीवमेंट्स हैं उनको कुछ शब्दों में व्यक्त कर पाना मुश्किल ही नहीं नामुमकिन है. So I would only like to highlight some of the main heads under which the achievements can be categorized, which is the introduction of the hybrid hearing system, an MOU signed with IIT Madras to facilitate digital transformation of Indian judiciary, upgrading of Supreme Court's indigenous core tech ICIMS, translation of judgments in regional languages, upgradation of process of e-filing, establishment of e-Seva Kendra to avail variety of e-services relating to court, use of artificial intelligence to transcribe arguments, adoption of office module to reduce paper usage and enhance efficiency and transparency. Facilitation of free Wi-Fi in the premises. Embraced a state-of-art digital video conferencing system that transcends geographical barrier, launching a neutral citation system for identifying and citing judgments in a phased manner, and many, many more. I would really urge everybody here to visit the Supreme Court website because there is a whole detailed brochure on how all this has been achieved. With this, I welcome the chief guest. Though this is the closing ceremony, I've been asked to make a welcome address. Thank you very much for being here, and thank you all very much.
Thank you, Ms. Tripathi, and I would like to call here Ms. Jain to say a few words.
With the Chief's permission, I'm just breaking protocol here slightly to recognize the top premier firms in the country. Some of the managing partners are here, and they have come together to create a club of pro bono law firms, which is going to focus on creating a common platform where the law firms can come together and create a structure. All these firms today do a lot of pro bono work already. But the idea was to come together and highlight the importance of the work that they do and look at partnering with various organizations to further this cause. So it just provides them a platform for exchanging ideas on the best way to develop premium pro bono programs that have a greater outreach. So just to recognize them, Sir has agreed to have the managing partners who are here, and I know all of them have to take a flight to Bombay. So if I may call on stage Nishit Bhai, Naina from K-Law, Amit Kapoor from JSA, and Pallavi is already on stage. Is there anybody here from Sarafin Partners?
Thank you, Ms. Jain. I would now like to invite on stage, on the podium actually, Ms. Vinita Sinha to share her thoughts on the ABA India conference.
So, thank you, esteemed members of the audience. As we draw this fantastic conference to a close, it is my privilege to address this gathering of legal stalwarts and other professionals and students to summarize my reflections of the last 2 days. At the very outset, I express my profound appreciation for this opportunity to be present here to participate in the various sessions which I found extremely enriching. The American Bar Association's Harmonizing Horizons, Uniting Law, Governance, and Philanthropy in India and the West has undoubtedly set a new benchmark for sharing knowledge and fostering collaborations within our global community. This conference has set the bar extremely high, and I look forward to attending future conferences by the ABA. As the General Counsel for the region for a multilateral development organization, I recognize the immense value this conference brings to in-house counsels like myself, legal practitioners, and students of law. The conference provided a unique platform for legal professionals to engage with experts from diverse fields, gain insights into cutting-edge technologies and issues, explore innovative strategies for addressing contemporary and legal challenges for the future. The diverse range of sessions covering topics from law, governance, dispute resolutions, and sustainability has provided invaluable insights into the challenges and opportunities that lie ahead for our countries and for our future generations. These topics are extremely relevant to the legal community and investors in areas, again, I'm repeating, exits, dispute resolutions, and I was watching the bankruptcy session as well, extremely helpful. For law students, the conference has been a remarkable opportunity to gain exposure to the real-world challenges and engage with industry experts. It has inspired them to think beyond the confines of traditional legal education and explore the interdisciplinary nature of law in the context of technology and philanthropy. By encouraging students to participate in such events, we are nurturing the next generation of professionals who will be better equipped to navigate the ever-evolving landscape of the global legal community. The panelists for each session were very thoughtfully selected to provide a wide variety of perspectives. By bringing together legal professionals, technologists, financiers, investors, this conference has created a unique platform for the exchange of ideas and perspectives, ultimately paving the way for innovative solutions and strategic partnerships. The organizing committee's vision to unite law, technology, governance, philanthropy has definitely enriched the learning experience for the attendees. It is through such collaborative efforts that we can collectively address the complex issues and work towards a more sustainable, equitable, just and prosperous future. The conference's emphasis on fostering growth and development in both nations has underscored the importance of transparency, integrity, and adaptability in legal systems. In conclusion, I extend my heartfelt gratitude to the American Bar Association and the conference organizers, the sponsors, for the relentless efforts in bringing together such an esteemed and diverse group of professionals. I do sincerely hope that this conference will catalyze positive change, inspiring professionals and students alike to work together in pursuit of sustainable progress, innovation, and collaboration. As we look forward to future events, let us continue to build together upon the foundation laid by this conference, fostering an even greater global community dedicated to the advancement of law, technology, governance, and philanthropy. With that, a huge thank you.
Thank you very much, Ms. Sinha, for those insightful thoughts. May I now request Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Supreme Court of India, to deliver his valedictory remarks. Sir.
Neelam Tripathi, Senior Advocate, Vinita Sinha, Assistant General Counsel, Asia IFC, Pallavi Shroff, Managing Partner of Shardul Amarchand Mangaldas, Pratibha Jain, Chair of the India Committee of the ABA, distinguished managing partners and all the invitees here. Truly, it's an honor for me to be invited by Pratibha for the valedictory session of this two-day conference. Let me begin by telling you that post-COVID, there was an upsurge in the sense of optimism of what was left behind of humanity after the near Holocaust that took place across the world. So we who were left behind felt a sense of optimism in the future, because if humanity could transcend and survive what was a life-threatening pandemic, surely there were better times ahead for us. So this was reflected in a large measure in the corporate world, in the upsurge in environmental social governance concerns, the ESG concerns, so to speak. But as I was reading The Economist a short while ago, there's a reference to an anonymous memo by ex-partners of McKinsey, who spoke about the unchecked and unmanaged growth and the lack of strategic focus. Strong words by firms which really specialize in doling out advice and rendering advice to others. But this is also a world which is undergoing very rapid change. Coldplay and Taylor Swift, both of them are personal favorites of mine, have undertaken on concert tours and raked in $810 million and $1 billion. Beyonce's new album, called Cowboy Carter, released on 29th March 2024, is full of country tracks. And I thought I'd refer to all this by telling you of another quote which I came across, a quote by Eugene McCarthy, who says that being in politics is like being a football coach. You have to be smart enough to understand the game and dumb enough to think it is important. But as we all know, politics is important. And if you substitute politics with legal procedure, the very same thing that McCarthy said about politics can well apply to legal procedures as well. You have to be smart enough to understand the game and dumb enough to think that it is important. So behind all this legal wrangling over procedure and the forms of our profession lies something far more fundamental. And that fundamental aspiration is really our quest for a better vision for the future of our societies, committed to the rule of law and governance within the fold of constitutional democracies. I must congratulate Pratibha and her whole team for their industry in organizing this event, which brings together a diverse array of minds. I'm sure it was not easy to organize conversations around almost 25 different sessions, which were just as diverse and relevant. I believe that passion-driven conversations are melting pots of ideas. They provide a direction to meaningful policy initiatives and actual change at the grassroots. Interdisciplinary conversations transcending the realms of law, policy, regulation, business and governance are tremendous learning resources for the change makers of today and, more importantly, for the future. Let me begin by speaking for a brief while on philanthropy and justice, how law institutionalizes legal services. But before that, I had this little experience when we approached a very leading musician years ago when I was a young lawyer of the Bombay High Court to invite her for a performance. And she quoted a hefty fee. So we went up to her, uninitiated young lawyers that we were then, and we said that we are doing this for charity. So would you mind scaling down your fees for the performance? And she turned around to me in Marathi and said, "What's charity to you is livelihood to me." And that's something which has really never left my mind, that even philanthropy and charity in that sense requires organized structures for both of them to genuinely flourish. Philanthropy is considered contrary to distributive justice. Why? It's contrary to distributive justice, or considered to be contrary to distributive justice, as it creates a certain social hierarchy and does so in an arbitrary manner. It is an unreliable medium of change because it is subject to individual motivations and charitable impulses because of its non-institutional, uncoordinated character. So much as we speak about the importance of philanthropy within our own profession, it's important for us to understand the flip side and to overcome the flip side by seeking to institutionalize what otherwise becomes really ad hoc individual initiatives. John Stuart Mill years ago argued that lasting relief should be the responsibility of the state, and that charity almost always does too much or too little. And he said it lavishes its bounty in one place and leaves people to starve in another. This critique, I believe, subsides when we speak of philanthropy in the form of agency-enabling services, such as legal assistance, or what Justice Sikri said yesterday as legal social responsibility. The law can foster the coordination of philanthropic endeavor. We see an example of this in the regulation of corporate social responsibility, as well as in the legal aid mechanisms in our country. The legal service institutions across the country, you would be surprised to note, now have over 31,128 experienced panel lawyers, 42,446 paralegal volunteers, and 7,968 pro bono lawyers across the country. Having a dedicated team of lawyers ensures a steady and consistent availability of legal aid, rather than a case-to-case basis search for legal assistance. But the real problem which we face is not in terms of numbers, but in terms of quality. And how do we bridge this gap between numbers, between the demand and supply, between volume and quality legal services? And I believe the answer lies in creating a platform for opportunity, particularly platforms for opportunity for those who have not been mainstreamed in the past. For instance, you will find that there have been now initiatives by marginalized citizens, people belonging to marginalized groups in society, who are willing to give back to society, whether in terms of queer legal advice for people belonging to the queer community, people providing legal advice coming from the Dalit or the Bahujan Samaj backgrounds, or going to the most important segment of our population, women themselves. The Supreme Court had designated about 13 women lawyers as senior counsel between the establishment of the court in 1950 down to February 2024, out of which 2 were designated as a matter of right because they were former judges of the High Court. So if you're a former judge of the High Court, you get designated as a matter of right as a senior counsel in the Supreme Court. At the end of February 2024, in one lot, we decided to designate and designated 12 women lawyers as senior counsel in one go. Now, sitting in the Chief Justice's court, as I do, I've seen the transformation in personalities. Young women lawyers, or not so young women lawyers, who've been designated as seniors, who are appearing as advocates on record before us until the previous week, have suddenly outshone themselves and emerged from the roles which they had carved for themselves. So this opportunity which was created to them by an institutionalized structure has provided a platform for them to prosper not just in terms of monetary benefits, which is of course important in itself. It would be hypocritical not to accept that, but in terms of offering quality legal services to others. Now, majority of legal aid beneficiaries constitute women, persons in custody. The Under Trial Review Committee processed and filed 35,505 bail applications before trial courts and secured bails in 5,614 cases against the bail orders passed by trial courts. Just a week ago, we considered a case where a person was granted bail for a not very serious offense in July of 2023. The offense involved an allegation that the person had, as a superintendent of an educational institution, employed people using illegal means, employed people in the institution. So the person was incarcerated. He was granted bail, but he was before the Supreme Court in the month of March 2024, saying that though I've been granted bail in July of last year, I'm still not released from custody. And why was that? For the simple reason that the trial court fixed the amount of bail at 10 lakhs of rupees. Now, this person belonged to a rural background. The High Court, while granting bail, said you must grant bail subject to stringent conditions. So the condition was 10 lakhs of rupees. And 8 months down the line, this person comes back to the Supreme Court and says, I'm still not released from custody. So that reflects perhaps both the sides of legal aid assistance to the truly indigent. But what we have to do, and we can do, I believe, is to ensure more institutionalized structures, and we have tried to do that in the Supreme Court by introducing a new mechanism, which is a blockchain technology-aided mechanism called FASTER, so that when we pass bail orders in the Supreme Court, we are ensuring that we keep a tab on whether those bail orders are communicated, because it's not enough that I pass an order for bail in the Supreme Court or the High Court passes an order, that order is communicated to the superintendent of the district or the central jail, that order is received by the convict or the under trial, that the order is acted upon by the district or sessions judge who has to grant a warrant of release for that person, and the fact that the person is in fact released. Now, all this can be achieved through use of technology, which we are trying to do using blockchain technology. Now, blockchain also ensures that these orders cannot be fabricated, because you have enough people who are willing to play the Indian jugaad by, sort of placing on the online platforms in a fabricated order. But what we are therefore trying to do is to ensure that we merge technology with our own endeavors to provide for the liberty of subjects. Now, the National Legal Services Authority organized a first-of-its-kind regional conference on access to legal aid that witnessed participation from chief justices, judges, and lawyers from 15 countries in the global south. Our Constitution, particularly in its preambular values, promises justice, social, economic, and political. This was given substantive focus in Articles 14 and 21 and directive principles such as Article 39A, of which all of you know. Therefore, our Constitution elevates the status of legal aid from being a charitable impulse to the paradigm of rights and matters of state policy. And therefore, the Legal Services Authorities Act of 1987 institutionalized pro bono services in the country for those in the margins. The legal community, lawyers, law firms, law school clinics, and policy think tanks have further fortified this guarantee. So where there is a law, there is a remedy, which is a cliche we often hear as lawyers. The legal aid framework in the country affords substance to this guarantee of legal remedy. We must work towards a future where there is a remedy, there is accessible legal assistance. You might have some downstream benefits as well. I've been speaking to friends who have been managing partners and are managing partners in law firms, and I keep on telling them over coffee table conversations, everyone in your law firm does not aspire to being the rainmaker of the law firm, or everyone in your law firm may not rise to become the managing partner. Several of them, maybe for personal reasons, family reasons, or just temperamental reasons, realize, well, it's been good for me, the journey has been wonderful, but I want to do something different. An ideal example is Justice Somashekar Sundaresan, who worked with J. Sagar, became a managing partner, switched sides and became a lawyer, practicing lawyer, and then has been elevated to the bench. Now, how do we institutionalize this and not ensure that this is only a one-off lawyer who has moved from transactional lawyering into the mainstream of the court? Because there's no point in saying that we are not getting judges of quality. We have to ensure that we get judges of quality, because they will define the quality of legal services in the courts by getting good people and giving them the opportunity to aspire for judicial office. And not everyone, therefore, would want to continue with transactional lawyering. And I think initiatives like this, the Pro Bono Club, which has been set up as a part of this conference, I think would provide a wonderful launching pad for lawyers from the transactional side who have years of accumulated experience, particularly in commercial law. And there is a dearth of commercial law knowing expert judges across the country as new fields of law come into being. I never learned electricity law as we find it today when I was a young law student. I didn't have it on my agenda when I was a lawyer as well. The act came into force, the new act and legislation came into force much after I was appointed as a judge of the High Court. So also the Insolvency and Bankruptcy Code. But you have professionals today amidst you who are experts in this area. Some of them, even if 1% or a fraction of a percent contribute to what we believe is the mainstream of the court-oriented practice, I think we would have achieved a great deal in terms of providing governance, in terms of their expertise. Now, how has pro bono lawyering shaped legal service delivery? Why is philanthropy and legal services important? There are two broad areas of assistance that legal service providers could be dealing with. One is the substantive legal advice itself, and the other is helping a litigant meaningfully access our courts and their processes. Because of the sheer volume of work and lack of legal education for the masses, our courts do not exactly make for a smooth and easy experience. Navigating through our court premises literally and the complex set of procedures metaphorically can be challenging for a majority of unaided citizens. The actual and opportunity costs of even attending a court hearing are sometimes higher than what our litigants can afford. A 2016 study revealed that a litigant incurs a cost of rupees 1,039 per case per day and rupees 1,746 as the average cost incurred due to loss of pay or business. If we add to this the cost of legal advice and representation, the costs could be dizzying for a majority of the country, whose only option is to appear without any legal counsel. Pressed against the wall for the time they can dedicate per case, frequently the presiding officer is left scrambling for a willing lawyer to assign the case. And I'm not talking of the tip of the iceberg, whom you generally brief. I'm talking about the base of the pyramid, which represents, the population at large. The Bar Council of India's Standards of Professional Conduct and Etiquette state in Rule 46 that every advocate shall place in the practice of the profession of law, bear in mind that anyone genuinely in need of a lawyer is entitled to legal assistance, even though he cannot pay for it. That he has to be now, of course, substituted with he or she or their. Free legal assistance to the indigent and oppressed is one of the highest obligations an advocate owes to society. Our court, the Supreme Court, held in Indira Jaisingh versus the Supreme Court of India, on the need for advocates to contribute pro bono, which is now a major consideration for their designation as senior counsel. And I think that is a welcome change, because when we designate members of the bar as senior counsel, we are now looking at the extent of pro bono work which is being rendered by them. The bar has often championed pro bono causes and crystallized innovative legal argument into our jurisprudence. This applies to technical legal questions as much as it does apply to social action litigation, as amicus curiae, and as pro bono legal counsel. However, this side of the profession is not widely seen by the society at large. Popular culture often denigrates lawyers as people who would offer confusing legal advice that begins with, it depends. Well, it depends on what the judge will say. It depends on what the contract says. It depends on how well the other side is versed, in a bid to ensure steady business from a perplexed client. Our legal fraternity has generously thrown its weight behind some of the defining moments in our jurisprudential history, and they continue to do so. Landmark cases on judicial independence, human rights, environmental law were helmed by doyens of the bar acting pro bono. It was their passionate yet objective defense of certain principles which found favor with the judges eventually in shaping the law. Chief among them, let's remember for a moment and spend a moment of reflection on Fali Nariman, the doyen of the bar, or Mr. Soli Sorabji. Fali rendered pro bono services in judicial appointment cases. Famously, he remarked, "My client," he said, "is the independence of the judiciary." Dr. Y.S. Chitle and Justice Mukul Mudgal, as he then was, argued for the petitioner in the Sunil Batra versus Delhi administration case in 1979, which led to landmark prisoner rights judgments authored by the eloquent Justice Krishna Iyer. Or more recently, Dr. Justice S. Muralidhar, who is now a senior counsel, has appeared for the victims of the Bhopal gas tragedy. So you have examples like this, and we need to only replicate these examples by putting them forth and encouraging lawyers to come to court and contribute to the process of the law. Changing face of legal services, legal startups and technology. Let me spend a few moments on this theme. The chairperson of the Commission of India, Ms. Ravneet Kaur, mentioned yesterday that we are the third largest startup ecosystem in the world, with over 117,000 startups, 117,000 startups, and 55,000 of which have women directors. It's an amazing statement about the social transformation which is taking place across India. And to complement what Ms. Ravneet Kaur said, I can only give you one more statistic, which is very close to my heart. Forgive me for being repetitive if some of you have heard this from me before, but it's so close to my heart that I think it's worth repeating. In the recent recruitment to the district judiciary across India, you will find in state after state that over 50% of the new recruits are women, over 60% in some states, approaching 70% on certain occasions. So what does this tell us? This tells us that when you create an even and equal platform for women, they do the rest for you and use their entrepreneurial or skills of personality to come forth. And I think transactional lawyering taught our society just that. Because until the transactional law firms came into existence, especially after the 1980s with liberalization and India taking its place gradually in the global economy, I think the chief social transformation which transactional lawyering brought about was that when you create a merit-based platform for women in particular, they will avail of it. If you have a system which is premised on the old boy network, as barristers' chambers or counsel chambers were always in the practice of law, that poses a problem for women. On the other hand, when you create an organized platform which is merit-based, women are willing there to be equal partners in the workplace. Tying out-of-court dispute resolution, accessible legal advice, paperless legal processes into a syncretic whole, the legal startup ecosystem in the country is similarly thriving. We have over 20 online dispute resolution platforms offering online mediation, conciliation, and resolution services. How courts are employing technology to improve governance as well as access to courts is a very important question. Complementing these efforts, technology-enabled courts could be the key to better governance and faster-moving court processes. As on the 1st of March 2024, over 100,000 e-filings have been made before the Supreme Court, and approximately 839,000 filings have been made before the High Courts. Week on week, I get a graph, a bar chart actually, depicting to me as Chief Justice in one color the number of paper filings and in another color the number of e-filings. For the first few months, the e-filings were a fraction of the paper filings. Now you find that the e-filings are way ahead of paper filings. To facilitate better governance, a digital war room is in the pipeline in the Supreme Court, which would enable monitoring of the district judiciary's data in real time by using the National Judicial Data Grid, or NJDG. If all of you have not, or some of you have not used or surfed the net for the NJDG, the National Judicial Data Grid, I'd really earnestly request you to do so. It would be a 5-minute real-time exposure to what is new in the Indian judiciary. Or iJuris, which is an information sharing platform for the district judiciary. iJuris monitors statistics of vacancies and infrastructure relating to the district judiciary. So we even have questions like, do you have washrooms? Next question, do you have toilets for women? Next question, are your toilets for women equipped with sanitary hygiene equipment? Next question, do you have toilets which are gender neutral? So we have a whole drop-down facility which gives us a very up-to-date statement of the Indian judiciary in terms of infrastructure. The NJDG monitors the total pending and disposed of cases. Virtual courts, which have been implemented in 20 states, are being used for traffic challan cases on a pilot basis. E-courts had surpassed even the Indian Railway platform in terms of total electronic transactions. So this is really fascinating that in terms of even the total transactions, the e-Tal website or the e-courts website is far ahead, had surpassed even the Indian Railways. The National Service and Tracking of Electronic Processes, what we call NSTEP, it's a mobile application, GPS enabled, which enables the electronic service of processes, curbing delays and costs. We have already served over 3.4 million processes so far. We have today, as of now, translated 36,366 judgments of the Supreme Court in around 17 Indian languages. All judgments of the Supreme Court from independence until date have been translated into Hindi using a machine learning software, namely Bhashini. Now, what is the purpose of this emphasis on regional languages? We, of course, speak in English in the Supreme Court, in the High Courts to a greater or lesser extent. But in the district court, which is the first point of interface of the common citizens with the legal system, the language is the local language of the state. And if we have language of judgments which is not conversant to the common citizens, it just means that we are putting out all that we do beyond the reach of common citizens. So that's where, again, technology can be a huge enabler, and which is being used progressively. We have been using artificial intelligence, speech-to-text in the transcription of the arguments in Constitution Bench cases. I'm sure you've been seeing it on the screen, where we have simultaneous transcription of everything which is said by the counsel into text immediately. We have been experimenting with the use of artificial intelligence in the personal accident cases, what we call the MACT, Motor Accident Claims Tribunals cases, in the Section 138 cases involving check dishonor, case categorization, the removal of defects within our registries, a whole lot of areas where we are applying AI. Last few thoughts on the way forward, which are the areas of improvement. There is a growing apprehension regarding the condition of the judiciary in our nation, particularly concerning the backlog of cases and the sluggish pace of legal proceedings. As discussed yesterday by the managing partners panel in session 1, it is evident that at times delays inadvertently encourage frivolous litigation. Parties that stand to gain from such delays clog courts with frivolous cases to financially drain the opposite parties. But more significantly, and this I find is a matter of serious concern, that frivolous litigation really is rendering courts dysfunctional. The amount of time that a judge of the Supreme Court has to spend on what are very often frivolous cases, cases brought only to delay proceedings, is incredible. Section 62 of the Insolvency and Bankruptcy Code lays down strict parameters of the time within which you must file an appeal, 30 plus 15 days. You can't condone the delay beyond 15 days. Yet you find appeals filed in the Supreme Court with delays of 395 days or 75 days. Obviously, people know that the appeal is by time. But the strategy then is file the appeal, keep it in defect in the registry, don't allow it to come on board, and then tell the committee of creditors or whoever has to implement the decision for the resolution plan, I've moved the Supreme Court. You dare not finalize the issue. So that is an indicator of how judicial processes can be misused by sheer frivolity of filings. This is a self-perpetuating cycle where a legal system struggling to keep up is delayed, and delays further clog the system with callous, meritless litigation. This is not only a governance issue, but a deeper issue of access to justice. It is unfortunate that while legitimate litigation awaits its turn, time and resources of courts are blocked elsewhere. A 2018 study by the Commonwealth Human Rights Initiative found that we have 5 legal aid lawyers per 100,000 population. The lawyers' remuneration is capped at abysmal figures, and they often foot the bills for litigation expenses due to delayed reimbursements. We have in India a pool of young lawyers who want to be the voice of the voiceless. They struggle to find the balance between this call of conscience and the need for financial independence. There is resultantly a massive demand and a supply gap. The 25 sessions of this conference traversed a wide range of subjects touching upon the role of AI, climate change, investments, strategic partnerships, Viksit Bharat, data protection, and private equity. Speaking about the environment, the conflict is not always between environment and development, as very often it's portrayed to be. The conflict is sometimes between environment and environment. Just last week, we had to deal with a case where we have delivered a short order in the court, and therefore I can speak about it today, about the need to set up solar power transmission lines, particularly in the desert areas of Rajasthan. Now, there you have an endangered species called the Great Indian Bustard and the lesser florican. Now, the problem here is, how do you preserve the balance between the two? You have an endangered species on the one hand, and you have India's commitment at an international level to further the climate change protocols. Now, how do you balance between the two? Because here, this is a concern not between environment and development. It's between the environment and environment. If you don't have solar power, if you do not have renewable sources of power, the focus of the country is going to be on non-renewable sources, particularly like coal or the thermal power stations. So how do you draw this balance between the two? And I'm just mentioning this case because it's something which is present in my mind. It was argued before us just last week. But significantly, therefore, I think it's important that all of you representing the thinking and the intellectual side of the legal profession, with your wide experience in how commercial law works itself out, pans out into creating a more equitable, just, and accessible society. As my fellow panelists, Ms. Vinita Sinha, highlighted yesterday in a session on investor-friendly regulation, India is the largest portfolio for the IFC. Even if we have the eyes of the world on ourselves, we have not lost sight of some of the domestic exigencies that invite far less attention. In an attention-starved world, this attention is crucial between legal services in the country. The Indian Law Firms Pro Bono Club, announced yesterday, democratizes the institutional expertise of the law and of law firms and their experience, and offers a platform to young lawyers. So for much that I have told you which constitute the deficiencies of the system, I have learned over the last 4 decades and more in this profession that we survive on hope. I was in Bangalore and Hyderabad recently, and talking to a few good old friends, I was told that it is becoming very difficult for a 50-year-old to actually work in a business environment where the billings are all done by 20-somethings. So at 50, you feel yourself completely outdated. What to talk about somebody like me who has crossed 60 as well. So when you cross 60 and you still are battling with the need not to be outdated, you realize that optimism is our source of eternal hope. And in that hope, I leave you this evening. Thank you very much for inviting me.
Thank you very much, sir, for such an insightful session. And now I invite here on the podium Ms. Pallavi Shroff to give her concluding remarks. Ma'am, over to you.
Good evening, everyone. Honorable Chief Justice of India, my co-panelists, esteemed judges of the High Court, friends, ladies and gentlemen. It is indeed a daunting task to speak after the Honorable Chief Justice, but I would keep it short and sweet. I am indeed honored to deliver the concluding remarks of this amazing 2-day conference. It's been engaging experience, engaging with the various experts over different subjects, each of which are most relevant, most important, and cover the theme of the conference, which are harmonizing horizons, uniting law, technology, and philanthropy in India. It's a remarkable platform for exchange of ideas, discussions, fostering collaborations, and celebrating the achievements of the legal fraternity. As we conclude this insightful event, I would like to highlight some of the takeaways of this 2-day conference. First and foremost is the integration of artificial intelligence, blockchain, and technologies. In the morning and the day before, we discussed about the potential to revolutionize the legal fraternity. What the Chief Justice has spoken is how he has actually used artificial intelligence, blockchain, and has revolutionized the functioning of the courts in India. I think that is itself an amazing achievement for all of us. If the judiciary can lead the way or pave the way for using of this technology, the lawyers and law firms cannot be far behind. We've seen a complete evolution of technology, starting from a time when probably there was manual typewriters, to fax machines, to stencilographers, to having iPads in court, Wi-Fi, and using liquid text.
So there has been complete revolution. AI is but a natural extension of the use of technology. And I know several of us firms are already dabbling and using that in the way we deliver legal services. Importantly, the role of philanthropy in legal profession sounds new, but is not new. When we talk of philanthropy, of course, it's a more long-term solution to a problem. Charity could be a shorter term, but even if we use the word or understand the word interchangeably, I think there is a lot of pro bono work in courts for litigants who want to come to court. That is happening today by the lawyers and the law firms. Each of us law firms present here and those that are even not present, I can speak on their behalf. We are all committed to doing pro bono work. On the transactional side, equally, there is a lot of pro bono work that gets done. When NGOs want to receive investments or grants, there is pro bono work to be done. There is a lot of associations that want to do impact investing, where one level of investment can impact thousands of people. And a lot of us do that impact investment, which is on a pro bono basis. We are associated with national and international bodies, pro bono foundations that refer work to each of us, which we very happily do. We take pride in doing that, in fact. And that is, I think, a way that we give back to society. There are other ways of giving back to society, and probably COVID was one such example where we heard this morning how the law firms and the lawyers rose to the occasion, bought the oxygen generators, oxygen cylinders for their firms, 5, 6, 7, 8, 10, and were willing to share it with their partners, with their associates, and their families, whoever needed them. And all of us have done that. Getting people into hospitals, which was impossible at a point of time, using the relationships that we all had with the owners of the hospital, we've got people admitted. I know I have got about 20 people admitted to different hospitals when they really needed. I think this is all a commitment that we have to charity, to CSR in different ways. Lawyers and law firms have other ways of making their or showing their commitment to charity or to pro bono work. We as a firm have adopted a football team from a slum area in Bombay. We educate slum children in New Delhi on a regular basis. We've done that for the last 10 years. We believe in environment of planting trees. Some of our other law firm partners also said that earlier this morning. Shifting from plastic to glass. All these are small contributions, but they go a long way to actually show our commitment to the environment, to governance. As part of governance, what we discussed this morning was also a topic which is a favorite of our Honorable Chief Justice, which is diversity, equity, and inclusion. And I think what he spoke about is giving the opportunity is equity. It is not just having a number of women in the organization or in a firm, but giving them equal opportunity to that of another man in the firm. And I think that is important. Dealing with unconscious biases, subconscious biases, which are so important. You have a new piece of work. Do you want to give it to a lady who's as competent as a guy, or will the first thought in your mind be, oh, how will she manage? She has a child. These are the biases that are inherent in all of us. And we need to consciously deal with this and give equal opportunity. If equal opportunity is given, I assure you women rise. I have seen that, I think, in my own life. As we move further, we saw that there is the transformative power of collaboration. How do we collaborate with academia, with each other, with other lawyers, and with other institutions to bring about the transformative change? There is adaptability and flexibility in the legal industries. We've just heard about the ability to adapt and change in the legal industry. As the global landscape continues to evolve in the digital era, it is crucial for us to remain agile, responsive, and proactive in addressing the challenges and opportunities that may potentially arise. In coming years, we have to focus and invest on professional growth of our people. I know most of us as law firms have programs for continuous legal education, which is mandatory, which people need to go on, and these are fairly evolved programs. As we talk of adaptability, we have seen that clients' businesses have become more global. Their need for legal services has evolved from only seeking litigation advice to thinking of their law firms and lawyers as their partners in the growth, helping them to build and grow their businesses from local to global. Legal services have also evolved with the need of their clients, lawyers, and law firms have studied the new ways of doing business, the new challenges these businesses pose, and provide solutions to these problems. Collaboration with businesses, collaborations with academics, and with global law firms in different jurisdictions is inevitable. Embracing of technology is equally inevitable. Let us not shy when acknowledging that while it is essential to remain critical and discerning, we must recognize the value of open dialogue. This conference provides a platform for such open dialogue. As professionals in the legal domain, we must be committed to upholding the highest standards of ethics and professionalism. There is always the easy way out. And I think one thing that all the law firm managing partners did say this morning to the young and the very young students here, that the one thing you can never compromise in your life is your ethics. Because if you compromise there, you don't even begin being in the profession. While we do work for our clients and do make money, I think we do need to think of the greater role that we all play in serving people, in serving the country, and the well-being of society. Just as businesses have grown and changed, civil society has changed, and we need to recognize that. We need to recognize the aspirations of the young lawyers that come into the legal profession, offer them the opportunities, and empower them so that they too become leaders in their own time. I think this conference and the debate and the discussions on some of these issues that we've had, including on investments, which Vinita had mentioned, the exits. How do you exit? What can you do? How do you get stuck? Sometimes there are challenges. But these discussions actually help us to think ahead, to think for the future, and move forward. Thank you.
Thank you, Ms. Shroff. And finally, as we draw near to the close of this remarkable summit, it is time for a vote of thanks and the way forward. Please join me in welcoming Ms. Pratibha Jain, Chair, India Committee ABA and Head of Strategy and Group General Counsel, Everstone Group, to share her reflections on the theme.
Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Ms. Nilima Tripathi, Senior Advocate, Supreme Court of India, Ms. Pallavi Shroff, Managing Partner, Shardul Amarchand Mangaldas, and Ms. Vinita Sinha, Assistant General Counsel, Asia IFC, Justice Jasmeet Singh, Justice Amit Bansal. Ladies and gentlemen, it is with immense gratitude and admiration that I thank Dr. Justice Chandrachud for accepting our invitation today. And more than him, I need to thank Kalpana for ensuring that we can actually get him in our August gathering today. When he was speaking today on women empowerment and improving the lives of women in the country, I could tell where that power comes from. It's his wonderful wife and two lovely girls who are constant reminders at home, and I can tell you a powerful force that I think pushes him even further to work on this important cause. We all know of the important projects and the judgments he's given on women empowerment and initiatives, and we are very grateful for that, sir. It's almost when you were speaking, I was thinking, we are all converging towards what I think from the legal profession's perspective is the need of the hour. One of the other initiatives other than the Pro Bono Club of Lawyers we've promoted in this conference is the We for Her Foundation, sir, which is a website that is being created and, talking about e-initiatives, provide an institutionalized platform where lawyers who are willing to provide pro bono services and women who need that help, whether access to justice or even empowerment through creating new ventures, can be directly linked through that platform without any middleman needed. And I'm happy to inform you, almost all of the law firms that have supported this conference have also agreed to support this initiative, and some have already signed up on the website. I think these kind of initiatives with the Supreme Court's support are really going to help us transform the need of, he mentioned rightly, somehow it's the women who don't have as much of an access to justice as the rest of the country has, and we need to fill that void. And so I was just mentioning about getting together these managing partners who've signed up to this pro bono club with the Supreme Court and putting an institutionalized structure around it. So I look forward to being able to help do that, sir. We have reached the end of this conference. It's been a mammoth task, and it would not have been possible without the help of many. But foremost amongst them are the partners for this organization. I'll quickly name them because this was absolutely not possible without their support. AZBN partners, Cyril Amarchand Mangaldas, JSA Advocates, Khedar & Co, K-Law, Nishid Desai Associates, Seraphin Partners, Shardul Amarchand Mangaldas, Trilegal, SNR, APN Partners, Goodwin, KNL Gates, Osborne Partners, Sidley, Singhania & Partners, Cadden, Veritas Legal. Some of these foreign law firms are not even here. They weren't able to send anybody to the conference but supported the conference. I also want to thank our knowledge partner, OP Jindal Global University, CSR partner, We for Her, Federation of Corporate Lawyers, iPro Bono, IVCA, the Indian Venture Capital Association, SIAC, Singapore International Arbitration Center, and US-India Strategic Partnership Forum. I also want to thank Mr. Karan Kalia and the LegiQuest team and Network 18 for all the organizational support for the conference. A big shout out to my EA, Megha Gupta, who has been my backbone for the last few months in putting this conference together. She adopted the Durga avatar with multiple hands to manage the conference coordination. As they say, behind every successful woman is another successful woman. On a more personal note, yesterday was my mother's birthday. It's been 25 years since she died, but she died only after helping me fulfill my dream of becoming a lawyer. I'm a first-generation lawyer. I'm a first-generation lawyer and from a very traditional family. And it was my mother's quiet, steely support for me that enabled me to achieve my success today. So last but not the least at all, a big thank you to all the mothers who very quietly and in all forms of sacrifice inspire their children to achieve their fullest potential. Thank you, ladies and gentlemen.
Thank you, Ms. Jain. Ladies and gentlemen, as we draw the curtains on this magnificent summit, I wish to extend our deepest gratitude to Ms. Jain for her insightful closing remarks and heartfelt vote of thanks. Her words have not only summed up our enriching two-day journey, but also set the stage for the impactful strides we are poised to take in the legal fraternity. May I request Ms. Jain to please present a token of appreciation to Justice D.Y. Chandrachud. Can we have the token of appreciation, please? Thank you, everyone. May I request you all to please stand up for the national anthem. As we conclude the Global Lawyers Summit organized by the South Asia Committee of the American Bar Association, I urge you all to continue the conversation, share your thoughts, insights, and inspirations using our event hashtag ABA India Conference 2024. Let the dialogue that started here resonate across forums, boardrooms, and courtrooms, inspiring action and fostering change. Thank you to every speaker, delegate, and viewer joining us online. Your presence and participation have been instrumental in the success of the summit. Here is to the many ways we will carry forward the torch of progress, justice, and philanthropy. Until we meet again, keep the spirit of Global Lawyers Summit alive in your endeavors. Thank you, everyone, and have a great evening.